My lords, serial number 75. My lords,
Just any memos?
Yes. My lords, it's a cooperative society matter. It was supposed to be listed today, my lords.
Huh?
There's an urgency in the matter. They have illegally.
Today you had moved a memo?
No, my lords. Last week it was supposed to be. Date was given as today, my lords. It has not been listed.
ನಮ್ಮ ಡೇಟ್ ಇರೋದು ಯಾಕೆ ಬರ್ತಾ ಇಲ್ಲ ನಿನ್ನೆನೂ ಹಂಗೆ ಆಯ್ತು ಪ್ರೀವಿಯಸ್ ಬೆಂಚ್ ಕೊಟ್ಟಿರೋ ಡೇಟ್ ಬರಲೇಬೇಕು ಆ ಡೇಟ್ ಕೊಟ್ಟಿರೋ ಮ್ಯಾಟ್ರ್ ಯಾವ್ದನ್ನು ಡೇಟ್ ಕೊಟ್ಟರೆ ಲೇಟ್ ಆಗಿ ಹೆಂಗ್ ಹೋಗಿರೋದು ನಿನ್ನೆದು ಇವತ್ತಿಗೆ ಅಂದ್ರೆ ಲೇಟ್ ಆಗಿದೆ What is that?
There's a grave urgency because the cooperative society is filing frivolous complaints against the apartment owners and they have wrongfully registered under the Cooperative Societies Act. It was fully heard, my lord.
Monday.
As the respondent has dropped the petition.
Move a memo, another memo.
The respondent has
Total
dropped,
one.
the respondent has dropped the petition from Anganwadi work post matters and selected the other respondent matters.
Fresh matter?
Yes, matters. Service.
Service ಅಲ್ಲಪ್ಪ. Service is not before this court.
Sorry.
Check ಮಾಡಿ last time.
Apologies.
Your Lordship, these are connected matters pending from 21 onwards. This is regarding the execution of award, which is stayed in the trial court. Hence, the urgency of the matter.
EFA.
Pardon,
What is that?
GMRES,
GMRES.
Which year?
21. And the 22, they're connected matters. These are all.
Arbitration.
No, Your Lordship, this is the award has been is in the in the trial court. The execution of it is in the trial court. However, the matter here, which we have filed, we are the petitioners, is being affected because of the stay here. If this can
No,
kindly be
yes.
heard on Monday, Your Lordship.
Adjournments. List number 1, page number 10, serial number 40. Page number 11, serial number 41 and 42. Page number 12, serial number 43 to 45.
Page serial number 40.
44 that you have.
Hmm.
No, either 22nd or 28.
Inform ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದೀನಿ ಅವ್ರಿಲ್ಲ is not.
Mr. Prakash is also not there. Amendment ಮಾಡಿಲ್ಲ. That's right. Counsel for the petitioner seeks for and is granted a week's time to carry out necessary amendment. Amendment to be carried out on or before 15th March. If not carried out, will be liable to be dismissed for non-prosecution. Released on 20th March.
Serial number 43 minutes.
Yes.
Pray for a week's time. I appear for the petitioner.
Have you informed everybody?
My lords, respondent is the state, my lords. Bank, bank counsel is also there.
The Registrar Cooperative Societies doesn't want to be represented, Mr. Naik.
Take note.
Please take note.
Madam, lot of matters. We are asking them to file affidavits as to why they are not appearing. You acknowledge 43.2 Torsi. Please.
We'll take notice, my lords. State,
We will direct you to take notice. That's different. But why haven't they not appeared?
we will instruct them.
Your Register of Cooperative Society, CCMS alidiya?
Please. There.
They're away, they're there. So register.
Everybody will get
Yes.
to know.
Please.
So even this matter.
Please.
ಆದ್ಮೇಲೂ ನಿಮ್ಗೆ ಏನ್ ಹೇಳಿಲ್ಲ. 43. Learned AGA is directed to accept notice for respond number 2 in 43.2.
Please.
An affidavit of respond number 2 to be filed as to why despite service of notice, no appearance has been made. Learned AGA also is directed to secure instruction, make his submission as to whether the Principal Secretary, Cooperatives Department and the registrars coming under him have been onboarded onto CCMS. And if all the information is being shared to the concerned officers by tagging the relevant officers as regards each matter. At the request of counsel for the petitioner, relist on
Next Friday.
14th,
Please.
but our affidavit target, relist on 21st.
Grateful.
Page number 13, serial number 46 to 50. Page number 14, serial number 51 to 53.
Serial number 52. Serial number 52.
Yes, Mr. Acharya.
2 weeks, week after next I will get ready.
Have you informed everybody?
Yes, Sachin.
Clearing inform ಮಾಡಿದೀರಾ?
Clearing ಮಾಡ್ತೇನೆ, madam ಸಿಗ್ಲಿಲ್ಲ.
ಎಲ್ಲರಿಗೂ ಮಾಡ್ಬೇಕು. 52 at the request of counsel for respond number 1, relist on 21st March.
Serial number 53,
Hmm.
engaged with the serial counsel. The petitioner has also been informed and 1 week's time was made.
Have you informed everybody?
Yes, sir.
There are a lot of councils.
Yeah, informed everyone.
ಯಾರು ಬಂದು ಹೇಳ್ಕೊಡುದು ಆಮೇಲೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿಲ್ಲ ಅಂತ.
ಇಲ್ಲ inform ಮಾಡಿದೀವಿ.
ನೀವಿಲ್ಲ ಅಂದ್ರೇನು ತಗೊಂತೀವಿ ಆಮೇಲೆ.
ಇಲ್ಲ inform ಮಾಡಿದೀವಿ.
53 at the request of counsel for the petitioner, relist on petitioner in which matter? ಮತ್ತೆ petitioner ಅಂತ ಇದ್ದಾರೆ 53
Exponent 3.
respondent. 53.1 Ms. B.V. Vidyalata has entered up. Kashinath JD ಅಂತಿದೆ. Two different wakalatnamas.
Last time also.
PVR get respondent number
3.
at the request of counsel for respondent number 3, relist on 21st.
Page number 15, serial number 54 and 55.
54, my lord.
Hmm.
For the respond, petition is also present, my lord. Board has to be constituted, my lord. The election date is fixed. Compromise move ಮಾಡಿದೀವಿ. Till then, judgment agreement.
Compromise petition ಆಗ್ತಾ ಇದ್ದೀರಾ?
Move ಮಾಡಿದೀವಿ, ಪ್ರಪೋಸಲ್ ಹೋಗಿದೆ, because there is now a board. Election fix ಆಗಿದೆ, ಅದಾಗೋವರೆಗೂ decision ತಗೊಳ್ಳಿ.
54 learned counsel for
First
respondent
week ಅಲ್ಲಿ
number
election.
one submits that a compromise proposal is required to be considered by the board after being elected. The election being scheduled in the first week of June. In that view of the matter, relist on 26th June.
Page number 16, serial number 56 to 59. Page number 17, serial number 60 to 62.
My lord, 60, serial number 62, my lord,
Hmm.
2 weeks adjournment, senior registration.
2 ವಾರದವರೆಗೂ ಬರ್ಕೊಡು 2 ವಾರ ಇಲ್ಲಿ. ನೀವ್ ಯಾರಿಗೆ?
Petitioner,
Petitioner. Respond inform ಮಾಡಿದೀರಾ?
ಮಾಡಿದ್ದು.
At the request of counsel for the petitioner, relist on 28th March.
Page number 18, serial number 63 to 66.
Serial number 66, my lord. I am for the petitioner,
Hmm.
informed opposite side, my lord. Requesting for a week's time, my lord.
Request of counsel for the petitioner, relist
66 and
21st.
66.1, my lord.
21st.
Much, my lord.
Page number 19, serial number 67 to 73.
My lord, 68, my lord, for the petitioner. I have informed respondent number 5 in this case.
Respondent number 5.
I have informed, my lord.
68 at the request of counsel for the petitioner, 21st March.
Please, my lord.
Well, and no more adjournment.
And serial number 71, my lord. Try
71.
to connect that opposite council, my lord. It's difficult to connect, my lord. Short accommodation.
You
Personal.
have not contacted andre illa. When it reaches.
Please, my lord.
Page number 20, serial number 74 to 76. Page number 21, serial number 77 to 80. Page number 22, serial number 81 to 84. Page number 23, serial number 85. Page number 24, serial number 86 to 88. Page number 25, serial number 89 to 93. Page number 26, serial number 94 and 95.
93.1, please.
Hmm.
I appear for the petitioner. Lord, I have informed the other side.
Society, my lord.
Appear for the petitioner in the connected
my lord.
matters.
My lord, kindly have it next
Hold up.
week, my lord.
Board of term has been expired, my lord, shortly, my lord. They have not conducting the elections.
Are you opposing adjournment?
Opposing.
No
My
adjournment.
lord, for a moment, please, my lord.
Opposed
ಅಲ್ಲ,
andre
post
not
one,
at
post,
mentioning
my lord,
state Puneet.
ನೆನ್ನೆ ಡೇಟ್ ಮ್ಯಾಟ್ರು ಇವತ್ತು my lord, it is my lord,
If it is opposed, no adjournment.
my lord, Monday if I may request, not Monday, my lord, I'll not
Sorry,
be.
next.
Page number 26, serial number 94 and 95. Page number 27, serial number 96 to 99. Page number 28, serial number 100 to 102. Page number 29, serial number 103 and 104.
My lords, serial number 75, it's listed from yesterday to today.
Yeah.
Some urgency, my lords, may I request it may be taken up at 2:30.
It will be taken up. These are all the election matters, huh?
Please, it's a separate matter, my lords. Of course, it relates to election. There is a bylaw which is questioned. The urgency is in the writ appeal, my lords, we have been directed to issue calendar of events. It should include these two constituencies also. That is what is under consideration.
We'll take it up.
It's grateful.
ಇವಾಗ election matters full list ಮಾಡಿದ್ರಾ?
Please, ಮಾಡಿದ್ವಿ.
ಇಲ್ಲಿ ಲಿಸ್ಟ್
ಕೊಡ್ತೀನಿ sir. ಗೊತ್ತಿರೋದು ಎಷ್ಟೇ ಇದೆ ಆಮೇಲೆ ಮಾಡಿ.
ಇದಾದ್ರೆ ಸಾಕು ಅಂತೀರ.
ಅಲ್ಲಲ್ಲ ಇದಾದ್ರೆ my lord, lordship pass an order my lord, it be left to all other.
But full list ಕೊಡಿ.
Please.
That it can also, if somebody else wants to make any submission,
Please.
ನಮ್ಮನ್ ಕೇಳಿದ್ರೆ ಅದು ಆರ್ಡರ್ ಆಗೋಯ್ತು ಅಂತ. They should also be,
Please.
whatever submission will be here. We'll start today.
Please.
ನೀವು ಮುಗಿಯಲ್ಲ ಇವತ್ತು. We'll have it on next Thursday, next Friday.
Please.
ಲಿಸ್ಟ್
Meanwhile-
ಕೊಟ್ರೆ ಅದನ್ನೆಲ್ಲ we'll list it on that.
Please.
ಇರ್ಬೇಕಲ್ಲ ಬಾಳ.
ತುಂಬಾ ಇದೆ.
But petitioners ಎಲ್ಲ ಕಾಮನ್.
Please.
Petitioner lawyers are all common.
Common.
So.
Lawyers are. No, the
Only
society.
one issue that.
7-8 ಜನ ಲಾಯರ್ಗಳು ಅಡ್ರೆಸ್ ಮಾಡ್ಬೇಕಷ್ಟೇ.
ಅಲ್ಲೇ ತುಂಬಾದ್ರಲ್ಲಿ ಸೊಸೈಟಿಗೆ ಸರ್ವ್ ಆಗಿಲ್ಲ. ತುಂಬಾದ್ರಲ್ಲಿ ಸೊಸೈಟಿಗೆ ಸರ್ವ್ ಆಗಿಲ್ಲ. ಇನ್ ರೆಸ್ಪೆಕ್ಟ್ ಆಫ್ ಇವತ್ತು ತುಂಬಾ ಮ್ಯಾಟರ್ ಬಂದ್ರೆ ಸೊಸೈಟಿಗೆ ಸರ್ವ್ ಆಗಿದೆ, ಪೆಟಿಷನ್ ರೆಸ್ಪಾಂಡೆಂಟ್ಸ್ ಇದ್ದಾರೆ. ತಾವು ಅದನ್ನ ತಗೊಂಡ್ಬಿಟ್ರೆ
ಒಂದು disposal.
ಇವತ್ತು ತಗೊಳೋದೇ ಎಲ್ಲ.
ಪ್ಲೀಸ್.
We'll start today.
This election matters could be taken up on Monday also, Thursday, Friday,
ಇಲ್ಲ
Your fresh matters will take up. Fresh matters, there's no problem. Election ಇದೆ, voting rights ಬೇಕು, voting rights ಸಿಗತ್ತೆ. ಆಮೇಲೆ ವೋಟ್ ಏನಾಗತ್ತೋ ಆಮೇಲೆ ನೋಡೋಣ.
We can't declare.
ಅದು ಇವಾಗ ಅದೆಲ್ಲ ಇಲ್ಲಿದಾವಲ್ಲ, we'll take it up today for final hearing. Because they can't declare what's election results ಅಂತ ಇವ್ರ ಪ್ರಾಬ್ಲಮ್. ಈ ಕಡೆನೂ ನಾವು ಗೊತ್ತಿಲ್ಲ ಏನಾಗಿದೆ ಅಂತ ಅವ್ರ ಪ್ರಾಬ್ಲಮ್. So we'll have to pass orders. That we'll take it up on Thursday, Friday only. ಒಂದ್ 2-3 ದಿನ ಆಗತ್ತೆ ಅನ್ಸುತ್ತೆ ಆರ್ಗ್ಯುಮೆಂಟ್. As regards interim orders, every day it will be taken.
Great.
Serial number 24, my lord. I'm filing the memo for withdrawal now. Serial number 24.
24.
Filing the memo for withdrawal.
Election.
Yes, my lord.
ಏನಾಯ್ತು?
Nomination rejected, my lord. Nomination has been rejected.
And elections are already over, man.
They sent back to Shumoga, my lord.
So, nomination rejected.
ಹೌದು ಇಂಟ್ರಿಮ್ ಆರ್ಡರ್ ಕೊಟ್ಟಿದ್ರು my lord. Regard
To contest.
ಇಲ್ಲ, ಅದರಲ್ಲಿ ಏನಾಗಿದೆ, on 24/12/2024, this honorable court has permitted him to file a nomination. But that is the last date for scrutinizing of the nomination papers, and the election has been already over, my lord. Therefore, doesn't survive for consideration.
please.
ಪಾಪ ಕೈಗೆ ಬಂದಿದ್ದು you're taken away.
ಲಾಸ್ಟ್ ಡೇಟ್ ಆದ್ಮೇಲೆ ಬಂದಿದ್ದಾರೆ ಅವ್ರು.
24. Petitioner is before this court seeking for the following leaves. A memo dated 7/3/2025 has been filed, signed by the counsel for the petitioner, which reads as in accepting the said memo, accepting said memo and also the submission of all the counsels that the nomination submitted by the petitioner had been rejected and there is no adverse effect caused to the election. The petition is dismissed as withdrawn.
List number 1, order serial number 1. Shastri.
My lords, kindly permit me to read the order dated 3/12/24 that your lordships had passed in a very detailed fashion. A short grievance of the petitioners in this matter is that they are not allowed to become members of the respondent number 20 society, even though they are willing to make payment of the share capital and comply with all the other requirements. The submission of the learned counsel for the respondent number 4, who is the chief promoter of respondent number 20, is that the necessary applications be filed, accompanied by documents establishing that they are residents of the Bennehalli village. These applications would be favorably considered and they will be inducted as members of respondent number 20 within 2 weeks thereafter. Hence, the petitioners are permitted to file necessary applications accompanied by all the necessary documents, which shall be filed on or before 13/12/2024. It is made clear that no application filed beyond 13/12/24 shall be entertained by respondent number 20. On the applications being received by 13/12/24, respondent number 20 shall process the same within a period of 2 weeks thereafter by 27/12/24. Now, in compliance of this order.
Yes, for respondent number 4.
Chandrasekhar.
Chandrasekharaya. Paso.
Yes, my lord.
Serial number 2. Timothy KP.
Lordship, can you permit me to take out the hand summons to the Society Advocate Standing Council, please? Yes, Shaman is appearing on behalf of the society.
ಎಲ್ಲ ಸರ್ವ್ ಆಗಿದಾರಲ್ಲ.
Society.
ಸೊಸೈಟಿನೂ 6-9 ಸರ್ವ್ ಆಗಿದ್ದಾರೆ. Please.
Finally,
ನಿಮ್ದು ಇನ್ನ ಕಂಪ್ಲೈನ್ಸ್ ಮಾಡಿಲ್ಲ ನೀವು.
1 week time, you grant. I will call Mark.
Counsel for the petition seeks for and is granted 1 week's time to comply with the office objection. If not complied with by
challenging the proceedings, my lord, pending before the next schedule.
That is.
What are these proceedings?
Regarding, my lord, 29C proceedings.
29C proceedings pending ಇದೆ ಸ್ವಾಮಿ, ಎಲೆಕ್ಷನ್ ಆಗಿದೆ, ಅವ್ರು ಕನಿಷ್ಠ
How is
ಎಲೆಕ್ಷನ್
this-
ಆಗಿದೆ ಸ್ವಾಮಿ, ಅದಾದ್ಮೇಲೆ
ಮತ್ತೆ ಇನ್ನೇನು ಉಳಿತು?
ಅದನ್ನ ಡಿಸ್ಪೋಸ್ ಮಾಡಿಸ್ಕೋಬೇಕು ಸ್ವಾಮಿ, ಅದಕ್ಕೆ ನೆಕ್ಸ್ಟ್ ವೀಕ್ ಅಲ್ಲಿ
29C ಡಿಸ್ಕ್ವಾಲಿಫೈ ಆಯ್ತು ಆಮೇಲೆ
ಇಲ್ಲ ಸ್ವಾಮಿ,
proceedings?
ಪೆಂಡಿಂಗ್ ಇದೆ.
Before the appellate,
JRCS ಮುಂದೆ ಸರ್, ARCS ಮುಂದೆ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅಡಿಷನಲ್ ರಿಜಿಸ್ಟರ್.
Next week. Released on 14th. Will not seeks for compliance. If not complied by 15th, will be liable to released on 21st.
Serial number 3, Jay Kumar K.
The matter
Election
pertains to
petition.
election, my lord. Elections are completed. Now, results has not announced, my lord.
Pass over. We'll be taking up all of these matters.
Yes.
Serial number 4, Sudhindra BS.
Petition.
Hmm.
Filing withdraw memo.
Interim order ಏನಿಲ್ವಾ?
ಇಲ್ಲ.
Petitioner is before this court seeking for the following leaves. A memo dated 6/3/25 has been filed, signed by the petitioner and the counsel for the petition which reads as and accepting the said memo and submission dismissed as withdrawn.
Serial number 4, serial number 5, Krishna Gowda.
Elections.
13D.
Pass over,
Please.
pass over.
Serial number 6, Devi Prasad Shetty.
Same, my lord.
Elections are over, Manot.
Hmm.
Second, the elections are
We'll have to
over,
hear you.
particular.
Pass over.
92 connect.
ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿ ಇವತ್ತು.
ಹಾ.
ಏಳೆಂಟು ಜನ ಇದ್ದೀರಾ, ಈ ಕಡೆ ಇವ್ರಿಬ್ರು ಪ್ಲಸ್ ಒಂದ್ 4-5 ಜನ have appeared. This for the cooperative society, all of you can argue.
7, Jay Prakash Reddy.
Very good.
Pass over.
ಇಲ್ಲ, ಇದು
ಇದು ಬೇರೆ
Please, my lord.
sought for a mandamus melod to conduct the elections.
ಕಂಡಕ್ಟ್ ಎಲೆಕ್ಷನ್ಸ್.
ಅದು after issuing of the calendar of events, the day of filing nominations melod, the returning officer has urgent
But in this
postponed the.
In this case, my
elec-
lord, special officer is appointed, my lord,
Hmm.
and also say that, my lord, within 3 months, my lord, election should be conducted where it's.
Within 3 months ಅನ್ನೋದಕ್ಕಿಂತ 13D notice ಎಲ್ಲ issue ಮಾಡಿದ್ದಾರೆ ಸ್ವಾಮಿ. ಒಂದೇ
ಅದನ್ನೇ.
ಅದು ಯಾಕಂದ್ರೆ 2 months ಅಲ್ಲಿ ಇದಾಗೋದಿದೆ ಯೂನಿಯನ್ಗೆ ಎಲೆಕ್ಷನ್ಸ್.
My lord, regarding,
In 2 months you'll have.
within, my lord, from where it is halt, my lord, from there, my lord, with 3 months of the.
Statutorily ಆ period fix ಆಗ್ಬಿಟ್ಟಿದೆ. So ಅದು violate ಮಾಡೋದು.
ಅದು violate ಮಾಡಿ.
ಹಂಗಾಗಿ-
Special officer can be
Okay,
appointed
actually,
only for a period
petition.
of 3 months. And I'm not
ಒಂದ್
disputing.
ತಿಂಗಳಿಂದ ಏನ್ ಮಾಡ್ತಾ ಇದ್ದೀರಾ?
ಅಲ್ಲ, ನಾನು ಅವತ್ತು immediately I filed.
ಅಲ್ಲ, ಒಂದ್ ತಿಂಗಳಿಂದ ಮೂವ್ ಮಾಡಿ ಅದು ಆರ್ಡರ್ ತಗೊಂಡಿದ್ರೆ ಆಗೋಗಿರೋದು.
ಇಲ್ಲ, ಅದು ಮೂವ್ ಮಾಡಿದೀವಿ ಸ್ವಾಮಿ, ಅದು.
ಒಂದ್ ತಿಂಗ್ 30 days you would have got extra time.
ಅಲ್ಲ,
ಇವಾಗ ಗೊತ್ತಿಲ್ಲ ಎಷ್ಟು, where was it stopped?
My lord,
at
regarding
the stage of
nomin-
filing nomination.
nominations,
ಆಗತ್ತೆ ಹಾಗಾದ್ರೆ 2 months.
ಅಲ್ಲಿಂದ ನಾವು, please, my lord.
ಹಾಗಾದ್ರೆ 2 months ಅಲ್ಲಿ ಆಗತ್ತೆ.
ಹೌದು ಸ್ವಾಮಿ. And
Is before this court seeking for the following release. The grievance of the petitioner is that the elections have not been conducted post the notification issued for filing of nomination. Therein, the AG has submitted that a special officer having been appointed, the special officer is taking necessary steps
Please, my lord.
to
Madam,
conduct the election in accordance with law as per the time frame
please.
fixed in terms of the applicable law and rules. His submission answers the grievance of the petitioner, placing the said submission on record,
On his.
directing the special officer to conduct the election as expeditiously as possible. The petition stands disposed.
Specific direction is given, my lord, and the order itself say that. my lord. Then,
Submits that special officer has been appointed
next page, my lord.
and government order dated, and in terms of government order 12/2/2025, the special officer has already been instructed to to conduct the elections at the earliest.
Please.
ಆಮೇಲೆ
my lord, not to disqualify the petitioners, my lord, managing committee, because we have not.
that is not subject matter. right?
ಅಲ್ಲ,
Not to disqualify, how do we say that?
No,
If
because
they-
my lord,
the notice,
no, if the election is not held within, before expiry of the term, my lord, automatically as per section 28B2, the members of the
Listen,
managing committee will incur.
needless to
disqualification.
say, the elections, the conduct of the elections having been delayed on account of the appointment of the special officer, no director of the society can be disqualified under section 29B,
28B2.
28B2.
Please, my lord, because any other reason, my lord, it cannot be.
29B2 one.
Please, please.
Serial number
Sorry, my
8.
lord, I have.
R5, Your Honor. No objections, Your Honor. Please kindly pass any order, Your Honor.
Any order.
Voting, Your Honor.
Voting ಮಾಡಿದಿರೇನಪ್ಪ?
Result announce ಮಾಡ್ಬೇಕು ಸುಮ್ಮನೆ ಅಷ್ಟೇನೆ. Election ಎಲ್ಲ
Announce.
13D, my lord.
Pass over.
Pass over.
Cost payment ಮಾಡಿದಿರಾ?
Last ಆರ್ಡರ್ ಆಗಿರ್ಲಿಲ್ಲ ಬಟ್ ಮೇ ಬಿ ಇದು ಬಂದಿದೆ 18th ಅಲ್ಲಿ
Cost
ಆರ್ಡರ್
ಆಗಿದೆ ಸರ್.
ಆರ್ಡರ್ ಶೀಟ್ ಅಲ್ಲಿ ಆಗಿರ್ಲಿಲ್ಲ.
Serial number 98 also.
ಡೈಲಿ ಆರ್ಡರ್ಸ್ ಅಲ್ಲಿ
1,000 ರೂಪಾಯಿ ಕೊಟ್ಟು ಬನ್ನಿ.
ಯಾರು ಕಟ್ಬೇಕು?
Clerks
ಆಯ್ತು.
Serial number 98 also same, Your Honor.
98 ಬಂದವಾಗ ಹೇಳಿ.
Serial number 9.
My lord, election over, my lord, you announce the result, my lord, regarding, my lord.
Who is R2 and R3?
The R2 is a formal party, my lord, filing memo for this notice to the R2, my lord, is
Yeah,
a formal party, my lord. The R3 is served, my lord, is.
Lord AG accepts notice for respond number 2.
Please,
4 ಯಾರು?
For the returning office, my lord, returning officer.
please, 4 also state.
4 also state.
AGA.
Secretary Daivagnya Credit Cooperative Society.
Served, my lord, is.
Society, my lord.
And summons served, my lord. is.
ಯಾರಿಲ್ವಾ?
ಬಂದಿಲ್ಲ sir, my lord.
ಎಲ್ಲಿ and summons?
Memo filed, my lord, sir, to that effect. Acknowledgement of the
ಇದೆಯಾ?
service of notice filed, my lord.
A memo dated 3/3/25 has been filed, enclosing the acknowledgement of service on respond number 4. When service on respond number 4 is held sufficient, registry direct print the name of respond number 4 with the endorsement served by and summons. Pass over.
Summons, my lord, regarding, my lord, some observation,
Appearance.
appearance is concerned.
Because my lord knows you, they won't bother, even they have served, my lord,
Because
they won't come.
ಎಲ್ಲ ಸೊಸೈಟಿಗೆ
let there
advocates
be a-
ಇಲ್ಲ ಸ್ವಾಮಿ.
ಯಾರು CO ಬರಲ್ವಾ?
ಬರಲ್ಲ,
ಬರಲ್ಲ.
ಕೆಲವ್ರು ಬರಲ್ಲ,
ಬರಲ್ಲ.
ಎಲ್ಲಾರು ಅಲ್ಲ, ಕೆಲವ್ರು ಬರಲ್ಲ ಅಂತ ಇದ್ರಲ್ಲಿ.
COನು CCMS ಅಲ್ಲಿ ಇದಾರಾ?
ಇಲ್ಲ,
Regarding societies, my lord, it is, I think,
ಸೊಸೈಟಿ ಬೋರ್ಡ್ ಅದ್ ಬೇರೆ.
board ಬೇರೆ ಇರುತ್ತೆ. Private societies.
ಅದೇನು ಹೇಳಕ್ ಬರಲ್ಲ, ಅವ್ರು ಏನು ಹ್ಯಾಂಡ್ ಇನ್ ಲೋನ್ ಅಥವಾ ಏನು
ಇವಾಗ ಹೆಂಗ ಅದು ಸಾಲ್ವ್ ಹೆಂಗ್ ಮಾಡೋದು?
ಅದಕ್ಕೆ ಅವರು CEO ಅನ್ನ ಪ್ರೆಸೆಂಟ್ ಇರೋದ್ ಕೇಳಿದ್ರೆ, ಸೊ ಇಟ್ ವಿಲ್ ಬಿ
ಅಲ್ಲ, ಇದು ಇವತ್ತು we are taking it.
ಇವತ್ತಲ್ಲ, ನೆಕ್ಸ್ಟ್
Next,
We are taking it.
please,
So ಬೇರೆ ಯಾವ್ದಾದ್ರು ಇದ್ರೆ ಅದು ನಿನ್ನೆ ಒಂದ್ರಲ್ಲಿ ಹೇಳಿದೀವಿ.
please.
ಇದಕ್ಕೇನ್ ಬೇಕಾಗಿಲ್ಲ.
ಈಗ ಅವ್ರ ಹೆಸರು ತೋರಿಸಿ.
CO has nothing to say in this matter.
To regarding, my lord,
13D to-
preparations, my lord, to regarding 13D ಅವರೇ, there is a, my lord,
D2A, 2C, 2A.
2A. Preparation made by the, list made by the society only, my lord, that has been approved by the returning officer.
The ಯಾರು fourth respondent?
Please.
Returning
Third.
officer.
Fourth.
Third respondent.
Third,
The secretary.
ಬಟ್ ಅವ್ರ ಸರ್ವಿಸ್ ಆಗಿ ಬಂದಿಲ್ವಲ್ಲ?
please.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್.
And summons ಕೊಟ್ಟಿದ್ದಾರೆ.
ಬಂದಿಲ್ಲ ಅವ್ರು.
Please.
Handsome memo ಹಾಕಿಸಿ. R3.
ಬೇಲೆಬಲ್ ವಾರೆಂಟ್.
ಹೌದು, ಒಬ್ರು ಹೋಗಿ ಈಗ ನೋಡಿದ್ರೆ.
ನಿಮ್ಮವ್ರೇನಾ?
ಅವ್ರೆ.
Also, memo filed.
ಅದೇ ನಿಮ್ಮವ್ರೇನಾ ಅಂತ.
Please.
ಬೇಲೆಬಲ್ ವಾರೆಂಟಾ ನಾನ್ ಬೇಲೆಬಲ್ ವಾರೆಂಟ್?
Available summons.
ಮಾಡೋಣ. Issue bailable warrant to respond number 3 for a sum of rupees 10,000 returnable by 20th March. ಯಾರು ಬರ್ತಾ ಇಲ್ವಾ?
ಅಲ್ಲ, ಕೆಲವ್ರು
ಕೆಲವ್ರು ಬರ್ತಾ ಇದ್ದಾರೆ,
ಕೆಲವ್ರು ಬರಲ್ಲ.
My lord, the third respondent. my lord.
ಇನ್ನೊಂದ್ಸತಿ ಚಾನ್ಸ್ ಕೊಟ್ಟು ನೋಡೋಣ ಬೇಡ.
One chance.
My lord,
ಸರ್ವಿಸ್ ಆದ್ಮೇಲೆ ಅಪಿಯರೆನ್ಸ್ ಬರಲ್ಲ ಅಂದ್ರೆ
Please, it's bound to, my lord, they will apply.
ಅದಕ್ಕೆ 3 ತಿಂಗಳು ಡಿಲೇ ಆಗ್ತದೆ.
Please.
my lord, submission. The third respondent has sent a WhatsApp message to me, my lord, to announce the result, my lord. Seeking
nice.
permission.
ಅದೇ ನಿಮ್ಮವರು ಅಂತ ಗೊತ್ತಾಯ್ತು. ಅದೇ ಹೇಳ್ತಾ ಇರೋದವ್ರು ಹ್ಯಾಂಡ್ ಇನ್ ಗ್ಲೋವ್ ಏನು ಅಂತ ಗೊತ್ತಾಗಲ್ಲ, ಬಂದ್ ಹೇಳಲ್ಲ. 13 how do we examine 13(2A)(2) whether that list has been prepared properly or not is your grievance. ಅವ್ರು ಸರಿಯಾಗಿ ಮಾಡಿದಾರೋ ಇಲ್ವೋ ಅಂತ ಹೆಂಗೆ ಎಕ್ಸಾಮಿನ್ ಮಾಡೋದು ಅವ್ರು ಬರ್ಲಿಲ್ಲ ಅಂದ್ರೆ?
Only right to vote, my lord, starting. Right,
ಅಷ್ಟೇ
please.
contest ಇಲ್ಲ.
No, no contest, my lord. Only right to vote, my lord.
Whether the list has been prepared properly or not.
Please, please.
Available warrant written by. ಬರಕ್ ಹೇಳಿ ಅವ್ರಿಗೆ ಅವತ್ತು.
Please, my lord.
Next to NBW.
Number 10. Dada Khalandar.
I bring the petitioner in this matter, my lord. Seeking permission.
ಏನಪ್ಪ ಇದು? ಇನ್ನ ಎಂಟ್ರಿ ಮಾಡ್ರ ಆಗಿಲ್ವಾ?
No, my lord.
ಯಾವತ್ತು ಎಲೆಕ್ಷನ್?
Election is on 18/3. Nomination is commenced on 19/3, 9/3, my lord.
Second round of litigation, my lord, this is my lord.
Here, in this matter, the petitioner names are not shown in the ineligible voters list or in the eligible voters list.
Not shown.
They are not shown, no,
ಯಾಕಪ್ಪ?
in both the list. Therefore, their status is also in the ambiguity.
Society ನ ಪಾರ್ಟಿ ಮಾಡಿಲ್ಲ ನೀವು?
Society, I made an application for making your society also. I filed an application.
So ಅದ್ರ ಮೇಲೆ ನೋಟಿಸ್ ಹೋಗಿದ್ಯಾ?
ಅಯ್ಯ
Yeah.
put up
Kumar Rajgopal is,
1/25.
they filed a caveat for the society is concerned. And
R5.
yesterday they have appeared before this court.
R4.
And their request only. the
Chin
matter is
Basuraju.
taken.
Please.
Please, my lords.
Mr. Basuraju?
Yesterday also they have taken a passover, my lord.
Paso.
Serial number 11. Kavita M. Court fees.
Court fees.
My lord paid, my lords.
Hmm?
It's-
You know how to file. Why are so many objections coming?
No, my
These are
lord,
silly
only-
objections.
Only recovery officer is mentioned instead of assistant registrar. Now I will clear, my lord.
ದಿನಕ್ಕೆ ಒಂದ್
I will
ಎರಡ್ ನಾಲ್ಕು ಫೈಲ್
permit-
ಮಾಡ್ತೀರಾ ನೀವು? ಇದು ಹೆಂಗಮ್ಮ?
I may be permitted to carry out now, my lord. Only two
For the petitioner submits
corrections, my lord.
that court fee has
My lord,
been
in
paid, she
this-
seeks for 2 days' time to comply with the office objection. Learned AGA accepts notice for respond number 1, issue notice to respond number 2 to 4,
My lord,
returnable by
my lord, I pray for hand summons, my lord, in this.
9th April.
My lord,
ಏನ್ ಆಕ್ಷನ್ ಆಗಿದೆಯಾ ಆಗ್ಬೇಕಾ?
no, my lord, auction is scheduled on 26/3, my lord. But it is, this
26/3.
is a vehicle loan. We have taken in the year 2015. We have paid 2 years.
Returnable
Later-
by 21st March. Counsel for the petitioner is also permitted to take out hand summons on respond number 2 to 4, 24th.
Two is the assistant registrar, my lord. I will
Two assistant
carry out the, carry out the,
Recovery officer ಅಂತ ಹಾಕಿ.
that's the objection, my lord. This assistant registrar. Now I may be permitted to carry out, my lord.
AGA accepts notice for respond number 1 and 2, 3 and 4.
Now I may be permitted,
ಮಾಡಿ.
my lord.
ಅಲ್ಲ ಹಂಗ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, amendment application ಹಾಕ್ಬೇಕು. Once it is entered, you can't do it.
Yes.
Serial number 12. Kogerle.
For the
You not take out now hand summons.
lords, that has been served upon them. I have the.
Not even taken out.
Lords,
How can you serve it?
no, lords, yesterday, lords, we waited for lords obtaining the hand summons. But later on, lords, we have also sent a letter along with. lords.
Letter ಅಲ್ಲ and summons ಅಲ್ಲಿ. You took the order on 6/3 and you don't serve it.
Yesterday evening, my lords, we took the order and later on, my lords, we have also served along with the memo, my lords, I am. Original copy. Original copy.
Vikas Gramina Sahakari Bank. And counsel for the petitioner has filed a memo enclosing a letter addressed to respond number
Lords, three.
3, which bears the acknowledgement of receipt by respond number 3. And service in respect of respond number 3 is held sufficient. Registry is directed to print the name of respond number 3 in the cause list with the endorsement, service held sufficient. Yes.
Lords, this is a case where, my lords, election is on 9th, that is on Sunday.
Hmm.
Lords, what had happened, my lords, is that two persons, my lords, that is the petitioner herein, files two nomination. So that is one claiming, my lords, under the general category and another one, my lords, under the category A. So another person, my lords, has also filed under category A. Now, my lords, what they do is that they reject, my lords, my nomination. I withdraw, my lords, one nomination that is under the general category within the time stipulated. So far as, my lords, claiming category A, my lords, is concerned, they say that one person has, my lords, proposed for two persons. That is impermissible in law. My lord, the same person, my lords, has proposed me only, my lords, for two nominations. The endorsement, my lords, kindly see annexure A, typed copy at page number 15. What he says, my lords, that one person cannot propose for two persons. My lords, that is under the, my lord, the person who has proposed, my lords, is only for me, my lords, that is the petitioner herein, for two nominations. They, my lords, interpret.
Who asked you to file two nominations and get the same person to sign for you?
No, my lords, that is, my lords,
It's a shortcut kodya kodre.
Allah. My lords, I have claimed, my lords, under category A and as well as, my lords, under the general.
Why did you file two nominations?
My lord, two nominations, my lords, I filed it and I withdrew, my lords. I withdrew within the time stipulated. What remains, my lords, is only one nomination. The person who proposed me, my lords, has not proposed any other person. Not as per the rule, my lord, 14A, my lord.
It's the same person,
No, regarding
the
that,
same candidate.
so regarding, my lord, kindly see, my lord, because first, my lord, they say that in the general category is concerned, my lord, there's a nomination accepted. But my lord, 2A is concerned, my lord, we are not accepted because of, my lord, there's a rule is very clearly say that, which, my lord, application
Did you reject it before withdrawal or after withdrawal?
after withdrawal.
After withdrawal, ಹೆಂಗ್ ಮಾಡ್ತೀರಾ?
Regarding, my lord, may I read, my lord, 14A, my rule. Now the position, my lords, is that if I am, my lords, moved out, only one person remains and no election is to be conducted. 14A, my lord, preparation of the nomination paper. I read, my lord. Or on before date of appointment or making the nomination, comma, each candidate shall in person deliver the returning officer or assistant returning officer at the place of specified in this behalf. The nomination paper duly completed completed in the form number 13 and signed by the candidates and another member with right to vote proposer. Such nomination shall also contain the declaration signed by the candidate expressing his willingness to stand the candidate for the election to the board or society from the general constituency or constituency reserved SC or ST or women or backward class, provided, my lord. The provided no one member delegate shall be the candidate for more than one constituency and no member delegate shall be processed more than one candidate from the same constituency.
It's like he has filed two nominations, right or wrong, that is one aspect of it. Before the date of withdrawal, one nomination has been withdrawn. It is after that you carried out the scrutiny. So when the scrutiny was carried out, the nomination for general category was not available. So for you to raise an objection that there are two applications for nominations with two proposers, the same person proposing,
Please.
would not arise because it's not available for scrutiny for you to compare it. It's been withdrawn.
Please. Regarding, my lord, my instructions is, my lord, regarding which one my application is first, my lord, they will accept. Others application is cannot be accepted because
ಇವಾಗ ವಿಡ್ರಾ ಮಾಡಿದ್ಮೇಲೆ accept ಹೆಂಗ್ ಮಾಡ್ತೀರಪ್ಪ? ಇಲ್ಲ ಬನ್ನಿ ನಿಮ್ದು accept ಮಾಡ್ತೀರಿ contest ಮಾಡಿ ಅಂತ ಹೇಳ್ತೀರಾ?
allow. Page 22, my lords, annexure D, he permits withdrawal. I have placed it on record.
Scrutiny is after the last date of withdrawal.
Please.
Not before.
Please, ma'am.
Acceptance and withdrawal, then scrutiny, withdrawal ಆದ್ಮೇಲೆ scrutiny ನಾ?
Withdrawal, scrutiny ಆದ್ಮೇಲೆ.
ಅದಕ್ಕೆ ಕೇಳ್ತಾ ಇರೋದು.
Please.
If scrutiny is before,
please,
then you are right.
Please.
If scrutiny is after withdrawal, then we can't accept it.
Scrutiny is concerned.
What is the sequence?
Please, Lord, as per the page 19, my lord, is the sequence. My lord, page 19, my lords. Scrutiny is, my lord, 2-3-25, my lord. Lords, they scrutinize, my lords. Kindly say, my lords, serial number 2. Serial number 1, my lords, that is on 25.
ನಾಮಪತ್ರ ಸಲ್ಲಿಸಿದ ಪ್ರಾರಂಭದ ದಿನಾಂಕ is 25/2.
Yes, my lords. Then, my lords, for submission, my lords, is on 1/3.
ಕೊನೆಯ ದಿನಾಂಕ 1/3.
Yes, my lords.
ನಾಮಪತ್ರಗಳ
Lords,
ಪರೀಕ್ಷೆಯಲ್ಲೇ 2-3.
2-3. Then
The
thereafter,
scrutiny happened on 2-3.
2-3, Lords. On the same day, I withdraw, Lords, one nomination on 2-3. That is also signed by him.
Is the scrutiny was complete before withdrawal or
Before
not?
that, before that I withdrew it, my lords, that is also signed. Kindly see, my lords,
Page?
it also says that is on 2-3-2025 at 11:09, my lords. 11:09 AM.
Because impadiya, the last dinanka is 3-3.
3-3, yes, my lords.
2-3 is the scrutiny.
2-3, my lords, I
Then
withdrew.
the notification of the approved candidate is on 2-3. 3-3 is withdrawal.
2-3, my lords. 2-3 is withdrawal. 3-3 is the final, my lords, list will have to be published. Sindhutva
Impadiya
Bandida Abhyarthi-
ಕೊನೆಯ ದಿನಾಂಕ is 3-3, Mr. Subramania.
Please, my lords, 3-3 is the last date. On 2-3, my lords, I withdrew.
So scrutiny first ಆಗತ್ತೆ ಆಮೇಲೆ withdrawal.
Withdrawal ಆಗುತ್ತೆ.
So ನೀವು withdrawal ಯಾವತ್ತಾಗಿದ್ದು?
2-3,
Before-
my lords. At page number 22.
Respect of scrutiny ಮಾಡ್ಬೇಕಾದ್ರೆ head application ಇತ್ತು ಅಂತ reject ಆಗಿದೆ.
No, that is not the ground on which they have rejected, my lords.
That has not been stated in
No,
the,
that
in
is,
the endorsement, my lord.
now,
but-
my lords, they cannot take excuses.
Where is the rejection?
My lords, rejection order, my lords, is at annexure A, page 15, typed copy.
What time was this issued?
Lords, this was, lords,
This is 1-3.
ಇಲ್ಲಿ, yeah, my lords, page 12, ಕೈಯಲ್ಲಿ ಬರ್ದಿದ್ದಾರೆ ಅವರು. ನಾಮಿನೇಷನ್ ಪೇಪರ್ ಹಿಂದೆನೆ ಒಂದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ಅಂತ. ಹಿಂಬರಹ ಅಂತ, page 12, my lords. What he says, my lords, that person who proposed has proposed for 2 persons.
That we understood.
Yes.
What is the sequence of event ಅಂತ ಆಗ್ಲಿಂದ ಕೇಳ್ತಾರೆ ನಿಮ್ಮನ್ನ. Was it rejected after scrutiny or before scrutiny?
No, no, this is, my lords,
Did you withdraw before scrutiny or after
my
scrutiny?
lords, that is before scrutiny, my lords.
How
Before
do we say that? How do you say that?
My lords, because kindly see, my lords, page, my lords, 22. On the left-hand side, my lords, there is a signature of the returning officer stating that, my lords, on 2-3-2025 at 11:09 AM.
What time was the scrutiny carried out, Mr. Yogesh?
Lord, ನಾಮಪತ್ರ, my lord, the typed copy ಕೆಳಗಡೆ ಇದೆ. Page number 14. ಮಧ್ಯಾಹ್ನ 12:53 ಅಂತ. The page number 14, my lord, bottom ಅಲ್ಲಿ.
Yes.
ಟೈಮ್ ಹೇಳಿದ್ದಾರೆ. ನಾಮಪತ್ರದ ಕ್ರಮ ಸಂಖ್ಯೆ ಸೊನ್ಸು ಆಗಿ ನಾಮಪತ್ರ ನನಗೆ ಕಚೇರಿಯಲ್ಲಿ 1-3-25
ನಾಮಪತ್ರ submission 1-3.
ಗಂಟೆಗೆ
ಇಬ್ರಿಗೂ ಒಂದೇ question ಕೇಳ್ತಾ ಇಬ್ರು ಹೇಳ್ತಾ ಇಲ್ಲ. What
So I
time was
withdrew,
the
lords.
scrutiny carried out? Withdrawal ಅಂತ ಇವಾಗ ಸುಬ್ರಹ್ಮಣ್ಯ ಅವರು ಹೇಳಿದ್ದಾರೆ.
Please.
Withdrawal happened at 11:09 AM. Scrutiny ಎಷ್ಟೊತ್ತಿಗಾಯ್ತು?
My lord, in respect of
Till 3 o'clock it is.
in respect of my lord, 3-3 is my lord, date is my lord, in respect of a notification kindly say, my lord, 3 ಗಂಟೆ ಅಂತ.
ಬೆಳಿಗ್ಗೆ 10 ಗಂಟೆಗೂ ಮಾಡ್ಬೋದು, ಸಾಯಂಕಾಲ 5 ಗಂಟೆನೂ ಮಾಡ್ಬೋದು. ಎಷ್ಟೊತ್ತಿಗೆ ಆಯ್ತು
Up
ಅಂತ?
to 3 PM, my lord. That regard, my lord. Pass or minus.
If the scrutiny had happened prior to 11:09,
My,
then Mr. Subramania has no case. If you have done a scrutiny after he withdrew at 11:09,
please.
11:10 ಮಾಡಿದ್ರೆ ನೀವು,
My instruction is, my lord, at the time of scrutiny, my lord, 2 applications is there. That is the reason we have not considered.
so that means you should have done the scrutiny before 11:09.
Please, I think so.
So you have to place some record
Please,
to say
please.
what time.
Please. That,
Because after he is withdrawn, you can't take that contention.
please, my lord. So my instructions, my lord, that say that, I say that, my lord, at the time of scrutiny, there is a 2 applications is there. That is the reason we have considered.
ಅವ್ರು ಹೇಳ್ತಾ ಇರೋದು
ಗೊತ್ತಾಯ್ತು ಸ್ವಾಮಿ.
withdrawal ಆದ್ಮೇಲೆ ನೀವು ಈ ಸ್ಟೋರಿ
Please,
ಕಟ್ಟಿದೀರ ಅಂತ ಅವ್ರು ಹೇಳ್ತಾ ಇದ್ದಾರೆ.
That is why, my lords, it is not forthcoming.
Lord,
In the endorsement
ಅಲ್ಲ,
also.
endorsement ಅಲ್ಲ, ಅದನ್ನ
Lords,
ಹೇಳಿಲ್ಲ.
they concentrated, my lords, that one proposer has, my lords, proposed for 2 persons. But now having known, my lords, that it is not.
That has not been stated in the endorsement, my lord.
Whether one proposer, two application, all of it is immaterial if the scrutiny has happened after 11/9.
Now, my lords, my only respectful submission, my lords, is that now they are coming forward, my lords, with all these objections. Otherwise, my lords,
ಯಾವಾಗ ಟೈಮ್ ಆಯ್ತು ಅಂತ
Please,
scrutiny.
please, I will, my lord. Take
Pass
it.
over.
Please.
Shastri, you are appearing for whom?
For the, they have served an office copy, a copy of the writ petition yesterday at 8:30.
ನಾವು ಸರ್ವ್
So-
ಹೇಳ್ ಸಫಿಶಿಯಂಟ್ ಮಾಡಿದೀವಿ.
Please, my lord.
ನೀವು ಬಂದಿಲ್ಲ ಅಂತ. ಸೊ ಅದು ಹೊಡೆದಕ್ಕೆ ಶ್ವೇತ. ಶ್ರೀ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ, memo has been filed ಎಲ್ಲ ಬೇಡ. ಶ್ರೀ ಬಾಲಕೃಷ್ಣ ಶಾಸ್ತ್ರಿ has entered appearance for respond number.
Society, my lord.
The
respond-
registry is direct, print his name as such. Pass over.
Serial number 13. Mr. N.
Auction is scheduled on 13/3, my lord.
13/3 court fee.
Court fee paid, my lord.
ಫೈಲಿಂಗ್ ಮಾಡೋ ಕೊಟ್ಟಲ್ವಾ ಎಲ್ಲದ್ರಲ್ಲೂ ಯಾಕೆ ಅಬ್ಜೆಕ್ಷನ್?
Only these two, my lord.
13/3.
Outstanding balance is 21,87,000, my lord.
ಎಷ್ಟು ಕೊಡ್ತೀರಾ?
25%.
And AG accepts notice for respond number 1 and 2, issue notice to respond number 3, returnable by 9th April, emergent notice. Counsel for the petitioner submit that the total due as on date is 21,87,741. Due to financial stringency could not be paid, 4 weeks 25%, 4 weeks thereafter 25%, so and so, and state so.
Serial number 14.
Auction shall go on, but shall not be confirmed.
Appear for the petitioner, my lord.
In the meanwhile, office objections to be complied, if not complied by next date, dismissal.
Lord, there are but 8 office objections and complied during the course of the day, my lord.
Yes.
My lord, the case is this, that the petitioner happens to be a developer for the respondent one society, my lord. The contention is that I have not developed the land, but the case has been filed under section 70 before the respondent registrar, man. My contention is that I'm not a member of the society and this whole proceedings is not maintainable
It's maintainable.
under section 70, man.
It's maintainable. We have held it.
That is my contention. That's one, my lord. And second thing is the second ground that I'm alleging, my lord, that the project has been handed over to another person, that is Sadhguru Developers.
That's between both of you.
No, but there is already an agreement that has been signed between the society and the developer, man.
That you bring it to notice.
It's already
It will be considered on merits.
It's already.
Now you
brought
are
on-
here before this court on maintainability.
On maintainability.
That maintainability will reject. You place everything before that.
That document's on record, man. Notice me.
Learned AG accepts notice for respond number 2. Notice to respond number 1 is dispensed with in view of the order proposed to be passed. Petitioner is before this court seeking for the following leaves. The respondent had raised a dispute under section 70 of the Karnataka Cooperative Societies Act 1959 as regards the formation of the layout, as regards which the petitioner had been appointed as a contractor stroke developer. The contention of the petitioner is that the petitioner is not a member of the cooperative society, but only a developer. Therefore, a dispute could not be raised under section 70 of the Cooperative Societies Act. It is in that background that the aforesaid reliefs have been sought for. Section 70 reads as under. It is not in dispute that it is the property of the society which is being directed, which was agreed to be developed by the petitioner and an agreement entered into with the society. It is also not in dispute that upon such development, the sites which are to be formed were to be allotted to the members of the first respondent society. Thus, in effect, it is the property of the society which is the subject matter of the agreement, and any dispute relating to that property which was to be allotted to the members of the society, in my considered opinion, would come within the meaning of subsection 1 of section 70 of the Karnataka Cooperative Societies Act 1959. In that view of the matter, the above petition contending that a dispute could not be raised against a developer would not be sustainable. The petition stands dismissed at the stage of admission, reserving liberty to the petitioner to agitate all defenses before the second respondent.
Hearing on IS serial number 15. Mithun GA.
For the petitioner. 15. Lordship, in the last date of hearing, the Lordship had requested us to deposit a sum of 25 lakhs. We have placed it on record and we are ready to pay another 25 lakhs, Your Lordship. However, there is a merger that has occurred. The National Cooperative Bank Limited is merged with Cosmos. We have given a proposal to the management of the bank.
Who is for the respondent?
Shobha KR.
Shobha KR. So you sent a proposal for 25 lakhs.
Please.
Madam.
Since the new management has taken over, once the approval is given, we will continue to pay the same back.
None appears for the respondent. Learned counsel for the petition submit that a proposal has been submitted for closure of the loan. The payment as per the interim orders passed have already been paid.
Please.
To provide an opportunity for the respondent to be represented, released on 20th March.
Interim order to pay.
Interim order earlier granted is extended till next day.
Please, sir.
Serial number 16. KS Venkatramana.
Here for first respondent.
Lordship, this is a matter wherein the entire amount by auction purchase they have recovered. The excess amount the bank is refusing to return. Your Lordship, this honorable court had in fact appointed a.
Just one.
ಇದರಲ್ಲಿ
IA 1 of 24, IA 20, ಎಲ್ಲ dismiss ಆಗಿದೆಯಾ?
We're not pressing on any of
ಸ್ವಾಮಿ
those.
ಒಂದು
ಒಂದು ನಿಮಿಷ. IA 1 of 24 and
1 of 23.
1 of 24, 1 of 23. 4 of 19?
Pending ಇದೆ sir.
And
ಇಲ್ಲ.
3 of 24?
Not pressing on any of those. Your
Any of the items?
Please, Your Lordship. Your
ಈಗ
Lordship, what has transpired is
One minute.
subsequent to the auction,
Lakshmi Iyengar and senior counsel submit that she would not be pressing IA 1 of 24, IA 2 of 23, which has been recorded wide order date 15/1/25. Today she submitted that she would not be pressing IA 3 of, IA 4 of, IA 4 ಯಾರು ಹಾಕಿರೋದು? Mr. Vardhaman Gunjal has filed it, including, so you can't say that. IA 3?
Direction.
IA 3 has been filed by whom?
Direction.
ಯಾರಮ್ಮ ಹಾಕಿರೋದು IA 3?
Three of 24.
3 of 24 has been filed by you, that you won't press.
please.
Today she submitted that she would not press IA 3 of 24. Hence IA 3 of 24 stands dismissed. What about Mr. Gunjal? Is impleading application still pending?
Pending.
Lordship, none of that survives at this point of time.
ಅಲ್ಲ
Reason
ಅಲ್ಲ
being the-
ಈಗ
Might I complete?
ಹೇಳ್ಬಿಡಿ.
Your Lordship, at this point of time, the property that was auctioned,
Hmm.
we have subsequently, after the auction, purchased it back from the auction purchaser.
Hmm.
Your Lordship, meanwhile, the petitioner had passed away.
Hmm.
So the wife waited for his retirement benefits and the daughter took a loan, combined all of that and repaid the borrower, repaid the auction purchaser.
Hmm.
Now, Your Lordship, the bank has
Sale deed executed by the auction purchaser
Please.
in your favor.
in our favor.
Hmm.
Now, what has happened is the bank has collected in excess of the due amount. All we are seeking is the refund. They said it was about 11 lakhs. This honorable court had appointed a court commissioner. Court commissioner has presented a report that it is 13.5 lakhs that is due.
Hmm.
Now, all we are seeking is,
You will file or you have filed? You filed. Hmm.
now all we are seeking is the bank returns us that excess amount of 13.5 lakhs. After they have deducted their cost that they had incurred everything, 13.5 lakhs is due to us, Your Lordship.
Yes,
That is
Mr.
all we are seeking now.
From the very beginning, my contention on behalf of respondent one is that writ petition is not maintainable. Writ petition is not maintainable. They have obtained the interim order of stay by suppressing material facts and also misleading the court. That is substantiated by the order of the division bench in contempt proceedings. Now, what will happen to this joint memo and the transaction occurred between the petitioner and the fourth respondent, that is the auction purchaser, if the writ petition is dismissed? So I submitted this when your lordship
Writ
was sitting
petition
in December 24. Your lordship cautioned the other parties also about this. So therefore, I am ready for arguments on the main.
Argument, Matt.
Yes.
Your Lordship, all that survives for consideration
ಇಲ್ಲ
right now.
whether ನಾನು ಇನ್ನೊಂದು whether
He wants to argue
ಇದು
on the main.
ಸ್ವಾಮಿ
Hear both of you on the main, then we'll pass orders.
ಎಲ್ಲ ಈಗ ಇದೆಲ್ಲಾನು ವೈಟ್ ವಾಶ್ ಆಗೋಗುತ್ತೆ. ಇದೇನು ಈ IAS ಇದ್ರಲ್ಲಿ ಹಾಕಿರೋ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಎಲ್ಲಾನು ಈ ಜಾಯಿಂಟ್ ಮೆಮೊ ವೆದರ್ ಇಟ್ ಓವರ್ ರೈಡ್ಸ್ ಆಲ್ ದೀಸ್ ಥಿಂಗ್ಸ್ ವಿತೌಟ್ ದಿ ಕನ್ಸೆಂಟ್ ಆಫ್ ದಿ ಫೈನಾನ್ಸಿಯರ್ ಬ್ಯಾಂಕ್.
ನೀವು ಸ್ವಲ್ಪ ಮೈಕ್ ಆಫ್ ಮಾಡಿ, ಎಲ್ಲರಿಗೂ ಮೈಕ್ ಆನ್ ಮಾಡ್ತೀವಿ ಅಂತೀವಿ, ನೀವು ಆಫ್ ಮಾಡಿ.
ಅದೇ ಗೊತ್ತಿಲ್ಲ,
ಅಲ್ಲಿ ಒಂದು ಬಟನ್ ಇದೆ, ಗೊತ್ತು ಮಾಡ್ಕೊಂಡು ಆಫ್ ಮಾಡಿ.
ಆಯ್ತು,
ಅದು ಗೊತ್ತಿಲ್ಲ ಅಂತ ಹೇಳೋದಲ್ಲ.
ಸಾರಿ ಮೇಡಮ್.
ಎಸ್.
ಸೊ ಹೀಗಿದೆ. So therefore, my contention is whether this joint memo overrides all these ideas.
So you address arguments on merits, we'll hear you. If we find favor in them, we'll pass orders. If we find in your favor, we'll pass orders.
I have filed my objections also. Not only
Yes, madam. Ready?
Please, Your Lordship.
Ready?
Please, Your Lordship.
Ready.
In fact, what I have sought for in my main prayer at
Hmm.
this point of time would not survive for consideration in view of the fact that all of this has been settled. Your Lordship sees that this honorable.
So what do you want? Do you want to withdraw the petition?
Your Lordship, all we seek right now is for return of that amount. Your Lordship may kindly see
For
the
that he
previous
wants
order.
to address argument. So please address argument,
Your
whatever
Lordship,
you want to.
Please, might I take Your Lordship to the previous order, Your Lordship? Dated. Sunil that you are appointing me. Your Lordship, on 1/4/2024. 1/4/2024.
4/2024. Yes.
They had filed a list of calculation. Therefore, there appears to be some dispute regarding memo of calculation filed by both the parties. Light of the same, Shri Mohammad Tahir, learned counsel, is appointed as amicus curiae to assist the court. Amicus is at liberty to engage services of chartered accountant to assist and find out error, if any, differences in the memo of calculation filed by both sides. Both sides to furnish such information as may be required for the amicus to enable him to make the submissions in court. The expenses to be borne by both petitioners as well as respondent number one relist the matter. Now, after this, Your Lordship, on 4/7/2024, Learned Counsel Shri R.S. Ravi, appearing on behalf of petitioners, submitted that during course of these proceedings, fourth respondent, auction purchaser, and the petitioner have tried to settle the dispute amicably. Learned Senior Counsel seeks a short accommodation to ensure the presence of the fourth respondent through the Learned Counsel. The matter may be heard. After this, Your Lordship, at the request, the time stipulated was extended, Your Lordship. Then Your Lordship's detailed order on 22/10/2024. This was pertaining to the e-khata. There was difficulty in registration because e-khata was required. Therefore, we had sought some time, and all of this was paid. And on 15/1/2025, Your Lordship, that we didn't press any of these IAs, vehemently submits it, present petition substantially been heard. This was done by the respondent to get this matter back, which we had no objection to. On 15-1, he refuses to argue in the roster court.
Refuses ಅಲ್ಲ, he is misleading the court. ನಾನು ಹೇಳಿದೆ, you are part of the bench which decided the contempt proceedings ಅಂತ ಹೇಳಿದ ತಕ್ಷಣ ಅವರು ಬೇರೆಯವ್ರ ಮುಂದೆ ಹೋಗ್ಲಿ ಅಂತ ಹೇಳಿದ್ರು.
Said nothing to do with the contempt. It was at a time where Mr. Tahir, no, Mr. Please.
He heard ಅನ್ನೋದು, I have not been heard. The day joint memo was filed, the learned judge who was sitting on that day, he said, you take instructions from your client, I will hear you. From then onwards, I have not been heard. From day one, I am saying the writ petition is not maintainable. Whether the joint memo sanctifies all these mistakes committed by the petitioner. ಈಗ ಪೊಲಿಟಿಕಲ್ ಸರ್ಕಲ್ಸ್ ಅಲ್ಲಿ ವಾಷಿಂಗ್ ಮಿಷಿನ್ ಅಂತಂತಾರೆ ಯಾವ್ದಕ್ಕೋ, ಆ ರೀತಿ ಆಗೋಯ್ತು.
Your Lordship, they are the ones who filed this. I'm not. This is the calculation produced by the other side. No.
Mr. Chandrasekhar, you have been making statements and statements and statements.
Yes.
Political and this is not a political forum for you to make statements.
Sanctify.
You want to address arguments, please address arguments. ಹೇಳಿ.
ಈಗ ತಾವು ಇವತ್ತು ಫ್ರೀ ಆಗಿದ್ರೆ
ನಾವು ಯಾವತ್ತೂ ಫ್ರೀನೇ, ಇಲ್ಲಿ ಕೂತಿರೋದೇ ಫ್ರೀ ಆಗೆ, ಬೇರೆ ಏನು ಕೆಲಸ ಇಲ್ಲ ಅಂತಾನೆ ಫ್ರೀ ಆಗ್ತದೆ.
ದಯವಿಟ್ಟು ಒಂದು ಡೇಟ್ ಕೊಡಿ, ಅವತ್ತಿನ ದಿವಸ ಐ ವಿಲ್ ಕಮ್ ವಿತ್ ಪ್ರಿಪರೇಷನ್.
ಇವತ್ತು
ರೆಡಿ
ಮತ್ತೆ ಹೇಳಿ ಮತ್ತೆ
ಆಯ್ತು.
ಯಾಕಿದು ಮತ್ತೆ ಪುಷ್ ಮಾಡ್ತಾ ಇರೋದು?
ಆಯ್ತು. My objections. As directed to the honorable court on 25/1/24.
25/1/24.
Producing 18 documents.
Yes.
Is my little submissions. Which were repeated because earlier I had filed this 4/1/2019. They have been repeated. Annexure R1. With regard to the little submissions. What's it?
Yes.
This petitioner had earlier filed one more writ petition. Before this article. That had been produced at 15/44.
Yes.
This honorable court said for 6 weeks, stay order was to deposit 25 lakhs.
Yes.
Thereafter, after nearly 1 year, they filed appeal before the game against the award passed by the state minister of home affairs. Delay was controlled. However, appeal was dismissed. Thereafter, all the copies are there. Copy of the KET order, that is serial number 16, pages 85 to 93. Serial number 17, annexure R16, copy of the award passed by the joint registrar of property societies dated 4/4/2007. 94 to 98. 18, Annexure R 70, copy of the lease deed dated 10/1/2019 between Sri Nanamurthy and the petitioner. So by taking advantage of this stay, even before the stay was given, they have leased it out to this Nanamurthy. My written submissions, number one, they have not referred, they have referred in the petition very casually. Para number 7. What you may wait is here, I will read it. The petitioner filed WP number 94/94 challenging the said option notice dated 3/2/2018 on 27/2/2018. A copy of the
ಯಾವ ಪ್ಯಾರ ಓದ್ತಾ ಇದ್ದೀರಾ ನೀವು?
para 7 of the writ petition, subsequent this writ petition, the current writ petition. Earlier.
Para 7, it's only saying is relevant to submitted petition. I approach this honorable court in WP 946162, showing the word in view of dismissing the appeal. ಅದೇ para 7 ಓದ್ತಾ ಇರೋದು. Yes.
The petitioners filed WP number 94/61/94.
ಇಲ್ಲ, that is not what is here in para 7. It is relevant to submit here ಅಂತಿದೆ. ನಿಮ್ಮ objection ಯಾವ್ದು ಓದ್ತಾ ಇದ್ದೀರಾ? Petition para 7 ಅಲ್ಲ ನೀವು ಓದ್ತಾ ಇರೋದು. ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿದ್ದು ಸ್ಟೇಟ್ಮೆಂಟ್ ಆಫ್ ಅಬ್ಜೆಕ್ಷನ್? 4119. Yes.
Page 11.
Yes.
The petitioners filed WP number 94/61/94 challenging the said option notice dated 15/2/2018 on 27/2/2018. A copy of the writ petition is produced herewith as annexure part 1. This honorable court by the order dated 7/3/2018 granted an interim stay for a period of 6 weeks, subject to the petitioner depositing a sum of rupees 20 lakhs with the first respondent. Further, it directed that if the amount is not deposited within the aforesaid time, the interim order shall stand vacated automatically. A copy of the said order of stay dated 7/3/2018 is produced herewith as annexure part 2. It is pertinent to point out at this stage that the petitioners accepted the award and they had no intention of challenging the said award. Therefore, they are precluded from challenging the award. It is only an afterthought. So, subsequent to this, they have not deposited 20 lakhs. Automatically, the stay order given this by this honorable court was vacated. So, after 10 months, they filed an
Appeal before the KAT, which came to be dismissed later thereafter.
case that
Written submissions.
number 15, page
85.
85,
And it came to be dismissed.
yes,
Yes.
against the order, there appears
Hmm.
case.
Hmm. Hmm. What fact has they suppressed?
This order of order of lately turned to the writ petition very casual in a perfunctory manner. They have said
Yes.
is relevant to submit here that the petitioners have also approved this order WP number 9461.
They suppressed the interim order and the direction to make payment.
Find the above of it. What was the order? What they did have been suppressed. In view of dismissing of the appeal number 59 for 2018 by the tribunal, the aforesaid writ petition is no more survived for consideration. Obviously. No prudent person will accept this contention. To that effect, a memo is being filed to withdraw the said writ. Only memo and in view of the dismissal of appeal, they have filed this earlier writ petition doesn't have.
Yes.
ಏನ್ ಮಾಡಿದ್ದಾರೆ ಕೋರ್ಟ್ನವ್ರು ಏನ್ ಮಾಡಿದ್ದಾರೆ ಇವರು ಅದನ್ನ ಫಾಲೋ ಮಾಡಿದ್ದಾರೆ ಕಂಪ್ಲೇಂಟ್ ಮಾಡಿದಾರ ಇಲ್ವಾ ಏನು ಬರ್ದಿಲ್ಲ.
ಆಯ್ತು, ಅದು ಹೇಳಿದ್ರಿ ಆಮೇಲೆ ಅಷ್ಟೇನಾ? ಹೇಳಿ
ರಿಕ್ವೆಸ್ಟ್ ಟೈಮ್ ಇದು ಮಾಡಿದ್ರೆ ಐ ಆಮ್ ರೆಡಿ.
ನೆಕ್ಸ್ಟ್ ಏನು?
ನೆಕ್ಸ್ಟ್ R3 ತೋರಿಸಿ. Copy of the letter given by the first petitioner in the to the first party dated 5/10/2018.
Page 27. ಹೇಳಿ.
ಇದು ಆಪತ್ತಿನಿಂದ ಇದು ಮಾಡಿ on the date of action, after the date of action, the petitioner appeared before the before the secretary of the society. She gave a nice representation.
That she will pay the amount of 78,71,000 and issued a check. ರೆಡಿ ಇದೀರಾ ಹುಡುಕ್ಬೇಕಾ? ನೀವು ರೆಡಿ ಆಗ್ಬೇಕು ಬರ್ತೀರಾ ಅಂದ್ರೆ ಇನ್ನೊಂದು ದಿನ ಕೊಡ್ತೀವಿ ಸರ್, ಬೇಗ ಹೇಳ್ಬೇಕು. ನೀವು ಎಲ್ಲ ಮುಂದೆ ಇರೋ ಜಡ್ಜಸ್ ಮೇಲೆ ಎಲ್ಲ ಅಲಿಗೇಷನ್ ಮಾಡಾಕ್ ಬಿಟ್ರಿ, ದೇ ವೆಂಟ್ ಹರ್ಡ್ ಮೀ ಅಂತ. ಇವಾಗ ಹಿಯರಿಂಗ್ ಮಾಡಿದಾಗ ಬೇಗ ಹೇಳ್ಬೇಕು ನೀವು. Yes.
Subject repayment of my mortgage loan in view of auction sales.
We have read the entire letter. We have read the letter. Really, what is your submission?
Submission is when she has given this letter and issued a check. That also, if it is not a check belonging to her, somebody or yaro family friend check.
Gurudatta.
Gurudatta. our check.
Hmm.
It is a case for cheating.
ಯಾರು ಅವ್ರು ಹಾಕ್ಬೇಕಾ ನೀವ್ ಚೀಟಿಂಗ್ ಅಂತ ಹಾಕಿ ಹಾಕ್ಬೇಕಾಗಿತ್ತಲ್ಲ ಇಷ್ಟರೊಳಗೆ ನೀವು 2018 ಇಂದ ಯಾಕೆ ಸುಮ್ನೆ ಇದ್ದೀರಾ?
ಕರೆಕ್ಟ್, ನೀವು ಹೇಳೋದು ಕರೆಕ್ಟ್. ನಾವು ಸುಮ್ಮನೆ ಇದ್ದೀರಾ ನಾವು ಕೋರ್ಟ್ ಕೇಸ್ಗಳು ಹಾಕಿದ್ದೀವಿ ಎಲ್ಲ ಸರಿ. ಈಗ 2019ರಿಂದ ಅವರು ಕಾಂಟ್ರವರ್ಟೆಡ್ ಅದನ್ನು ನೋಡಿ.
ಎಸ್. ಆಮೇಲೆ
misleading the court by suppressing material facts and obtaining the order.
that you have repeated 5 times. Next day, next
5 times of the ತಮಗೆ ಇದಾಗಬೇಕಲ್ಲ.
ನಮ್ ತಲೆಯಲ್ಲಿ ಹೋಗ್ಬೇಕು ಅಂತೀರಾ, ಹೋಗ್ತಾ ಇಲ್ಲ ಅಂತೀರಾ? ಆಯ್ತು, ಹೇಳಿ.
The other side.
ನೀವು ಮುಂದೆ ಹೋಗಿ ಮಿಸ್ ಚಂದ್ರಶೇಖರ್, there are other people also waiting. ಮುಂದೆ ಹೇಳಿ. You can argue. Don't repeat.
Page number 7.
ಆ ಕಂಟೆಂಪ್ಟ್ ಹಾಕಿರೋದೇ ನಿಮ್ಗೆ ಬೇಜಾರಾಗಿರೋದು.
Subjugate
Yes.
the financial institution to their right. This court asked 6 lines to this court granted an interim order of 5/11/2018 staying the award dated 4/4/2017, and by that time the award had already been implemented, and thereby the question of staying the award would not have arisen, and the said interim order be of no consequence. Therefore, the contempt petition is not maintainable as accused has not violated the order passed by this. Next to 61, they withdraw this.
Yes.
So they withdraw this. Amendment applications. One amendment application that they are right by this honorable. Page 63.
Yes. Sixty-three is the application.
69
Order.
Annexure R10. It has to be the both responded submit that IA number 1 of 2019 and IA number 4 of 2019 have been directed to be taken along with the remaining petition, and as such no orders are presently required. In so far as IA number 1 of 2013 which Learned Council for the both respondent applicant submitted that this application required notified, but the both respondent applicant could not press this application in view of IA number 1 of 2019. This submission is taken on record, and IA number 1 of 2021 stands disposed of accordingly. Further, the aforesaid Learned Council submit that IA number 2 of 21, which is filed by the petitioner because of certain alleged subsequent events, could be allowed to facilitate complete and effective adjudication, but with liberty to the respondents to complete their pleadings, not only as regards the original petition, but also the amendment now proposed. In the light of this submission, IA number 2 of 21 is allowed. The Learned Council for the petitioners is permitted to carry out the amendment, and the amendment petition is the petitioners have not complied with the order. Thereafter, another amendment application of mine is that I have filed my detailed objections to this, which is not maintainable as per the dictum of cross high court.
ಆರ್ಡರ್ ಆಗಿಲ್ಲ. ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿಲ್ವಾ? ಇದು IA ನಂಬರ್?
IA number
IA ನಂಬರ್ 1 of 23. ಮೊನ್ನೆ ವಿಡ್ರಾ ಮಾಡಿದ್ದು. IA 1 of 23 this is.
ಇದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿಲ್ಲ.
ಆಗಿಲ್ಲ, ಅವ್ರು ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಲಾಸ್ಟ್ ಟೈಮ್ ಅಪ್ಲಿಕೇಶನ್. ಅದ್ರ ಮೇಲೆ ಆರ್ಡರ್ ಆಗಿದೆ, ವಿಡ್ರಾವಲ್ ಆರ್ಡರ್ ಆಗಿದೆ.
ಅದ್ರ ಬಗ್ಗೆ taken up along with the
Yes.
So in the main learn orders are whether the order obtained, the stay order obtained by the petitioners from this honorable court, whether it survives or not.
ಈ ಪೆಟಿಷನ್ ಸ್ಟೇ ಇದೆಯಾ ಇದರಲ್ಲಿ?
Virtue of that stay, ಇದೆಲ್ಲರೂ ಇದು ಮಾಡ್ಕೊಂಡು ಬಂದ್ರು, and also they filed contempt proceedings to intimidate the first respondent.
ಏನಂತಿದೆ ಇದರಲ್ಲಿ ಸ್ಟೇ? When was the order of stay? 5/11/18.
That time my auction was already, done on 5/10. This order was given on 5/11. Okay, by the at that time there was no, chance for giving the stay order.
Yes.
ನಾನು ಅಲ್ಲಿ have deposited the amendment application ಅಲ್ಲಿ deposited with the first respondent ಅದನ್ನು ಮಾಡೇ ಇಲ್ಲ.
ಆಕ್ಷನ್ ಎಷ್ಟು ಅಮೌಂಟ್ ಮಾಡಿದ್ರಿ ನೀವು? ಆಕ್ಷನ್, ವಾಟ್ ಇಸ್ ದಿ ಅಮೌಂಟ್ ದಟ್ ಇಟ್ ವಾಸ್ ಸೋಲ್ಡ್ ಫಾರ್? ರೌಂಡ್ ಫಿಗರ್? ವಾಟ್ ಇಸ್ ಅವರಿಂದ ಎಷ್ಟು ಡ್ಯೂ ಇದೆ ನಿಮ್ಗೆ? ವಿ ಆರ್ ಆಸ್ಕಿಂಗ್ ಎಷ್ಟು ಡ್ಯೂ ಇದೆ ಅವರಿಂದ? ಅವರಿಂದ ನಿಮ್ಗೆ ಎಷ್ಟು ಡ್ಯೂ ಇದೆ? ಎಷ್ಟು ಬರ್ಬೇಕು ನಿಮ್ಗೆ ದುಡ್ಡು? ಎಲ್ಲಿ ಹಾಕಿದೀರಾ? Please wait. He has a complaint that 5 benches have not heard him. So we are giving him all the hearing. So that he should not have the impression that this court doesn't hear. ಹೇಳಿ, ಎಷ್ಟಿದೆ ಅಮೌಂಟ್ ಡ್ಯೂ? ಎಷ್ಟಿದೆ ಹೇಳಿ. ಯಾವ್ದು ಫೈಲ್ ಮಾಡಿದೀರಾ? ಟ್ವೆಂಟಿ 24 ಒಂದು ಫೈಲ್ ಮಾಡಿದೀರಾ? ಅದ್ರ ಪ್ರಕಾರ ಡ್ಯೂ ಇರೋದು ಬರ್ದಿಲ್ವಾ ಇದು ನೋಡಿ. ಕ್ರೆಡಿಟ್ ಬ್ಯಾಲೆನ್ಸ್ ಆಯ್ತಲ್ಲ, ಕ್ರೆಡಿಟ್ ಬ್ಯಾಲೆನ್ಸ್ ಆಯ್ತು, ಇಲ್ಲ ಡೆಬಿಟ್ ಬ್ಯಾಲೆನ್ಸ್ ಇದ್ದಿದ್ದು 80 lakhs ಬಂತು. Seventeen, 12, 24. Seventeen, 12. ಅಲ್ಲಿದೆಯಾ ನೋಡಿ. 17, 12 ಯಾವ್ದು ಇಲ್ವಲ್ಲ. ಇವಾಗ ಎಷ್ಟು ಅಮೌಂಟ್ ಡ್ಯೂ ಎಷ್ಟಿದೆ ಹೇಳಿ, ಅವರಿಂದ ಎಷ್ಟು ಡ್ಯೂ ಇದೆ? ಇಲ್ಲಿಲ್ಲ ಅದಕ್ಕೆ. ಎಷ್ಟು ಅಮೌಂಟ್ ಡ್ಯೂ ಇದೆ? ಇನ್ನ ಆಫ್ಟರ್ 80 lakhs. ಕೊಡಿ ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಕೊಡಿ. ಸ್ಟೇಟ್ಮೆಂಟ್ ಎಲ್ಲಿ? $7 lakhs ಡ್ಯೂ ಇದೆ ಅಂತ ಹೇಳಿದ್ರಲ್ಲ. ಕೊಡಿ. $7 lakhs ಡ್ಯೂ ಅಲ್ಲ, ಇದು ಎಕ್ಸೆಸ್ ಇಂಟ್ರೆಸ್ಟ್ ಕಲೆಕ್ಟೆಡ್. ನೀವು ಜಾಸ್ತಿ ಕಲೆಕ್ಟ್ ಮಾಡಿದೀರಾ ಅಂತ ಇದು ಹೇಳ್ತಾ ಇರೋದು. Now there is a chartered accountant certificate which has been filed by the amicus on 26/6/24. ನೋಡಿದೀರಾ? ಅದ್ರ ಪ್ರಕಾರ 13,55,000 ನೀವು ಕೊಡಬೇಕು ಅಂತಿದೆ.
ಎರಡನೇದು ರಿಟ್ ಪಿಟಿಷನ್ which is not maintainable, ಇವೆಲ್ಲಾನು ನಡೆಯುತ್ತಾ. ಎರಡನೇದು
ಅದು ವಿಲ್ ಡೀಲ್ ವಿತ್ ಇಟ್. ನಿಮ್ಮ ಸಬ್ಮಿಷನ್ ಆಯ್ತು ಅಷ್ಟೇನಾ? ಹಿಯರಿಂಗ್ ಆಯ್ತಾ? ಅಲ್ಲಿ ನೆಕ್ಸ್ಟ್ ಇನ್ನ ಕೇಳಲಿಲ್ಲ ನನ್ನ ಅಂತ ಹೇಳ್ಬೇಡಿ. ಇನ್ನೇನು ಡೇಟ್ ಇಲ್ಲ, ಎಲ್ಲ ಆರ್ಗ್ಯುಮೆಂಟ್ ಇನ್ನೇನಾದ್ರು ಹೇಳ್ಬೇಕಂದ್ರೆ ಹೇಳ್ಬೇಡಿ. ವಿ ಆರ್ ರಿಸರ್ವಿಂಗ್ ದ ಮ್ಯಾಟರ್ ಫಾರ್ ಜಡ್ಜ್ಮೆಂಟ್. ಇಲ್ಲಿ ಇನ್ನ ಟೈಮ್ ವೇಸ್ಟ್ ಮಾಡೋದು ಬೇಡ ಅಂತ. ಆಯ್ತಾ? Heard Sri Chandrasekhar HS for respondent number 1.
Summing up the entire thing.
ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಡೇಟ್ ಅಲ್ಲ, ಇವಾಗ್ಲೇ ಹೇಳಿ ಏನ್ ಸಮ್ ಮಾಡ್ತಿರೋ ಸಮ್ ಮಾಡಿ.
Whatever have done, they have suppressed material facts and misled the court. Subsequent time, giant memo happened, actually, all these, misdemeanors will not vanish. Will not vanish.
Shri H.S. Chandrasekhar for respondent number 1, Ms. Lakshmi Iyengar, learned senior counsel for the petitioner, reserved.
Your Lordship, at the Karnataka Sauharada Sahakara Rules and Act, Your Lordship, marked that and kept it, Your Lordship, under Rule 1813, where whatever amount is.
We are
in
not
excess-
disturbing the auction.
Please, no, just that we are entitled to, we have marked that and kept it in the end.
Not press.
That's
Yes.
obliged.
Next.
Okay. With regard to R3 and R4, they have suppressed it. Other budget now.
Yes.
The result of that suppression.
Yes. The effect of it.
Yes, effect of that suppression.
Next.
Correct. Correct.
Serial number 17.
Obliged.
K. Nataraj Baba.
Petitioner, my lords. Application for subsistence allowances, my lords.
Subsistence.
Please, my lord. But,
Suspension agidya.
Please, my lord. But report has been submitted, my lords. But third respondent not taken any decisions on the report.
Third respondent Chandrasekharaya. Yes, Ms. Chandrasekharaya. Copy of writ petition.
I'll serve.
Learned counsel for the petitioner has served IA 1 of 24 and the counsel for respondent number 3, who seeks for and is granted a week's time to obtain instruction and make a submission.
Sir,
Relist on 14th.
copy, sir. Please.
Serial number 1 ಅಲ್ಲೂ ಇದೆ ನೀವು ಆವಾಗಲೇ ಇರ್ಲಿಲ್ಲ ಪಾಸ್ ಓವರ್ ಮಾಡಿದೀವಿ. We'll have to make a submission.
Serial number 18. G.M. Ananda.
Petitioner. Affidavit has to be filed by the first respondent regarding CCMS entry and all.
ಅದಾಯ್ತು. ನಿಮ್ ಮ್ಯಾಟ್ರ್ ಹೇಳಿ ಅದು ನಮ್ದು ಅವ್ರದ್ದು. ಎಸ್ ಏನಪ್ಪ ಟ್ರೈನಿಂಗ್ ಆಯ್ತಾ? ಅದಾಗೋರ್ಗು ಅವ್ರು ಹೇಳಲ್ಲ. And AGS seeks for a week's time to make a submission on the order dated 17/12/2024. Yes.
On merit, date.
At the request of Nimdo ready na ನೀವು? The counsel for respondent number 2 is ready to address the arguments. Counsel for petitioner
He also
seeks for
said.
ನಿಮ್ಗೂ ಟೈಮ್ ಬೇಕಾ? Both the counsel for the petition and respondent number 2 seeks for and granted 2 weeks time to get ready and address the argument. Relist on 20th.
19.
Interim order idea?
Interim order.
Interim order earlier granted is extended till next date of hearing.
Please.
19.
19, I appeal for the petitioners in this case, my lord. In this case, petition number 3 had passed away. On the last occasion, I had filed an application to bring the legal aids on record, which came to be allowed. There is also an impleading application that has been filed, for which I have to file my objections, my lord. A week's time.
This filed impleading, Mr. Anand?
Well, I have filed impleading application.
ಯಾರ್ ನೀವು?
I'm the petitioner in writ petition. Sought for a direction to the additional registrar to act in accordance with section 1(7).
I have also
The
challenged
enrollment
constitutional
of dual
rights in
members on the roles of there are 3 number of societies functioning. BEML Employees Society in Bangalore, BML Employees Society Mysore, and KGF. But all persons have become enrolled as a members in all 3 societies, getting benefits, etc., casting the vote, etc. I submitted representation before the additional registrar to act in accordance with 17. There is a prohibition, disqualification in the section 1(7).
Can't be more than
He
2.
did not act, I filed writ petition. In a writ petition filed by me, the orders passed by this honorable court directing registrar to act in terms of section 17 after affording opportunity to the all concerned.
So you're virtually the complainant.
Yes, complainant, but they have not acted. I filed writ, obtained direction and
Antara complainant.
Your lordship may kindly see the impugned notice.
We won't allow the application. You can address your arguments as an intervener. You're not a proper
Last time ತಾವು ಹೇಳಿದ್ರಿ, but orders ಆಗಿಲ್ಲ. ಸೇರಿಸ್ತೀನಿ ಅಂತ ಹೇಳಿ.
IA 2 of 24 has been filed for being by a person to be impleaded in the proceedings. Shri P. Anand Laran, counsel for the impleading applicant, submits that it is the impleading applicant who had taken objection as regards the petitioners and certain others becoming members of the three cooperative societies in BML. And as such, he submits that the impleading applicant would also have to be heard in the matter. The impleading applicant virtually is in the position of a complainant and as such is not a proper necessary party to these proceedings. IA 1 or 2 of 24 is partly allowed by permitting the impleading applicant to come on record as an intervener only to assist this court and not as the adversarial litigant. Is what is the statement of objections, Elena?
That is for the
Non-filing of amended cost title.
I'll file amended cost in a week's
Counsel
time.
for the petitioner seeks bond is granted a week's time to file amended cost title. In statement of objection, Mr. Nanja Reddy.
ಅದು ಫೈಲ್ ಅಬ್ಜೆಕ್ಷನ್ ಫಾರ್ 3 and 4.
ನಿಮ್ಮ objections ಮೇಲೆ objections ಇದೆ ಅದೇನ್ ಮಾಡ್ತೀರಾ?
ಇಲ್ಲ ಅಬ್ಜೆಕ್ಷನ್ ಮೇಲೆ ಅಬ್ಜೆಕ್ಷನ್ ನಾಟ್ ಎ ಮೆಂಬರ್ ನಾಟ್ ಎ ಮೆಂಬರ್ ನಾವು
Office objection ಇದೆ.
Copy note. Copy notes.
Office
He'll
objection.
comply, he'll comply.
Counsel for respond number 3 and 4 seeks fund is granted a week's time to comply with the statement of objection. If the amended cost title is not filed by 14th, the petition will be liable to be dismissed for
Well, I'll file it, my
non-prosecution.
lord. I'll file it.
If the statement of objections on the statement of objections are not complied by 14th, the statement of objections would be liable to be rejected and eschewed from the file. Relist on 21st March. For ಅವತ್ತು ರೆಡಿ ಆಗಿ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಬಿಡಿ. ಅದು ಇನ್ನೂ ಒಂದು ನೀವು ಚಾಲೆಂಜ್ ಮಾಡಿದೀರಾ? ಅದ್ ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡ್ಮೇಲೆ ಇದ್ ಮಾಡ್ತೀರಾ?
ಇನ್ನ ಒಂದು ರಿಟ್ ಇದೆ.
May I make a submission?
23315.
Subsequent to filing the petition, I filed the amended application to challenge the
There is
constitutional.
another petition filed by Mr. Nanja
Very
Reddy
well,
as
very well.
regards these very two petitions have been filed.
23315 to 2020.
Connect with 233
15 2024.
24 14
21st, my lord.
21st, sorry.
Grateful.
Serial number 20, Mahesh Kiran Shetty.
For the petitioner, your lordship, respond.
Yes. Yes.
Your lordship, we are actually ready to settle the matter. We have given an OTS proposal for rupees 42 lakhs.
My lord, what has happened is they gave a proposal saying that they will pay 40 lakhs. Then we gave a proposal saying that we are okay if total amount due is 55 lakhs. We said we are willing to give 5 lakhs deduction. So they are already getting a benefit of 5 lakhs. So 50 lakhs kotre, we can close the matter, whole matter.
You are at 50 lakhs, you are at 40 lakhs.
Total amount due is
52.
55. Total amount is 55.
Up to 42 we can.
We are not,
That is what was instructed.
your instruction, you speak to Mr. Shailesh, not to us.
Yes, one more proposal if they give us, your lordship, which is a little more.
Can
lenient
you
to
2
us.
lakhs and ಹೇಳ್ಬಿಟ್ಟು ಆಮೇಲೆ ಮತ್ತೆ ಅವ್ರು 2 lakhs ಕಮ್ಮಿ ಮಾಡದ?
Something in the
Give a
middle.
proper offer for them to consider. They'll consider
The total due is 50 lakhs. in that
55
range.
lakhs,
54 lakhs or something. In that range.
54 lakhs.
In that range, a little.
ಎಷ್ಟಕ್ಕೆ settlement ಮಾಡಿ?
Allah, we may make a submission, my lord. If the payment, even we will give a further deduction of another 2 lakhs, 48 lakhs ಕೊಟ್ಬಿಡ್ತೀನಿ. Only thing is the payment has to be made in certain schedule. ಯಾಕಂದ್ರೆ ನಮ್ಗೆ NPA ಜಾಸ್ತಿ ಆಗ್ಬಿಡುತ್ತೆ. That's the issue.
31st March ಬರ್ತಾ ಇದೆ. Unless you make the first payment before that, they won't accept it.
One proposal, let them give your lordship.
If we
which is-
adjourn it, then they won't accept it. Please remember that.
The matter may be posted on Monday, your lordship. I'll just.
We'll have it on Monday. Please
Yes.
come up with a proper
Yes,
proposal.
your lordship.
Now, this concession will only happen till 31st March.
Yes.
1st April in the no concession and thermos.
Yes, sir.
To enable both the parties to speak to each other, to arrive at an amicable settlement, relist on 10th at 2:30 p.m.
Your lordship, the interim order. Yes.
Interim order earlier granted is extended till next.
Grateful, your lordship.
Serial number 21, Sandesh TB.
Your lordship, I request a pass over. I pay for respond number 6 to 10.
Pass over.
Please.
22. Prithvi Wadeyar.
That I appear for the impleading applicant
my lord, effectively, I'm the one, my lords, who is impacted by the writ petition. And my lords, the interim order effectively operates against who I have not been named as a party. So my lords, I filed a
Does
deputy.
that operate against, objections have been filed, Mr. Patil?
They are yet to serve a copy. I don't know. Maybe, maybe they were not knowing who was the advocate on record or something of this
Prithvi's
sort.
name is there, everybody knows Prithvi Ode.
No,
ನೀವು appear ಆಗ್ತಾ ಇಲ್ಲ ಅಂತ ಗೊತ್ತಿಲ್ಲದೆ ಇರ್ಬೋದು, ಪೃಥ್ವಿ ಗೊತ್ತು.
We've served, my lords. We've served them. Those are my instructions.
as the things stand, even yesterday, we were surprised that a mention was made. We have filed impleading application without intimation, adjournment is taken.
Been served by email is what I'm told. My lords, it's been served last evening at 7 p.m. on the council on record.
Serve one more copy.
Very well, my lords. My lords, could I just mention this, my lords?
Yes.
The product in question is milk.
Yesterday, yes, that is.
And therefore, my lords,
that is why we took it up.
It is a perishable commodity.
Perishable commodity.
As,
my lords,
as,
all that I'm
as it
saying
is, nothing has started for perishable commodity to come in.
No.
Nothing has started. No operation has started. Your Lordship may kindly grant me some, by Tuesday or Wednesday, we will file our objections.
Where is the milk? What is the urgency that?
20,000 liters of milk have already been supplied to me, and that, my lords, is supposed to continue. My lords, if I don't sell it, that entire quantity goes waste. I have no difficulty, my lords, if the interim order is any supplies that I make will be subject to the outcome of the writ petition. There's no difficulty at all.
Will not be the.
Now you have only 20,000 liters.
Yes, yes.
That is the only thing which is perishable. You can't be getting more milk to make it perishable.
Effectively, my lords,
The second submission we can't accept.
I understand. My lords,
The first submission of what is there in your possession.
yes.
What do you have to show that you have 20,000
My
liters?
lords, I filed it along with my application. 20,000 liters has been supplied. In fact, I'm told, my lords, it may already have got spoiled by now, because, my lords, there is an order that
If it's already got spoiled, then there's nothing to
or,
be done.
my lords, I don't know, it may have been spoiled. So, my lords, this is the urgency. My lords, I have a contract which is supposed to, my lords, I can supply milk for all of Telangana except Hyderabad. That is the contract that has been given to me. I am impacted by this interim order. My lords,
That
I
is-
will show from
That
the
is
writ
a-
petition.
That's a different point.
Yes.
We'll consider that one.
Yes,
Your urgency yesterday, which was expressed,
yes.
was there's milk which is going to get spoiled. That's why we listed it. Mr. Prithvi had sought for time. We had given him time.
Yes,
Somebody mentioned it. We listed it today to be informed.
yes.
Now, if your milk is already spoiled, then there is no urgency.
But my lord, this is a continuing contract.
That we'll see.
I market it.
That we'll hear. Now you give them the copy, then we'll hear you.
Yes, no. Could it be taken up, my lords?
Next Thursday, next Friday.
Could it be Thursday? Could it be Thursday, my lord? There is some urgency, my lord.
We want to go play holy on that day.
Oh, I'm so sorry. So Friday.
Learned counsel for the impleading applicant has served Madra. Has today served a copy of the impleading application in IA number 1 of 2025 and the counsel for the petitioner. Counsel for the petitioner seeks for and is granted 4 days time to file a statement of objection which shall be filed on or before 12th March after serving copy thereof on the counsel for the impleading applicant. Relist on 14th March.
We've also filed an IA for vacating stay. My lords, if they could file their objections to that also, my lord, then the matter can be disposed of. It's a short point of law. It can be disposed of on that day itself.
What is IA 2 of 25?
That is the IA for vacating stay. My lord, that is effectively my
You
statement
want to
of
file that
objections.
of counsel for the petitioner is at liberty to file objections to IA 2 of 25 and such other documents as the petitioner wishes to place on record. 14.
Interim order.
Interim order earlier granted is extended.
Deeply obliged.
Serial number 23.
Your Lordship may kindly excuse for this reason.
Respondent number 1.
ನಾವು ಕೊಟ್ಟಿದ್ದು ಡೇಟ್ ನಂತರ ಡೆಪಾಸಿಟ್ ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದಾರಾ?
ಮಾಡಿದ್ದಾರೆ.
ಮಾಡಿದ್ರೆ ಸಾಕು.
The interim order to be continued. I supplied the copy to the other side also. Office objection.
ಏನಪ್ಪ, what is the total amount due?
29 lakhs for 32,000. My lord,
Award, Swami, award challenge ಮಾಡಿಲ್ಲ.
29 lakhs 32,000 not bad.
ಎಷ್ಟಕ್ಕೆ ಸೆಟಲ್ ಮಾಡ್ತೀರಾ?
6 lakhs rupees ಡಿಡಕ್ಟ್ ಮಾಡಿ 26 lakhs 74,037 rupees ಇದೆ ಸ್ವಾಮಿ.
ಇವಾಗ ಎಷ್ಟಕ್ಕೆ ಸೆಟಲ್ ಮಾಡಿ?
ಅವ್ರು ಬಂದು ಮಾತಾಡಿದ್ರೆ ಆಲ್ವೇಸ್ ವೆಲ್ಕಮ್ ಸ್ವಾಮಿ. ಅವ್ರು ಮಾತಾಡೇ ಇಲ್ಲ.
Some because financial difficulties ಅಲ್ಲಿ ಇದ್ದಾರೆ.
ಯಾವಾಗ ಹೋಗಿ ಮಾತಾಡ್ತೀರಾ?
I will ask them to. ಒಂದು
Petitioner submit that the amounts directed to be The petitioner has complied with the order date 5/12/24. Counsel for respond number one. Counsel for the petitioner submit that the petitioner is ready and willing to amicably resolve the matter by making payment of a mutually accepted amount. Counsel for respond number one submit that if the petitioner were to approach, Yarna,
Respond number one, bank.
were to approach respond number one, the discussions could be had on amicable resolution of the matter. Petitioner is directed to call upon respond number one at the office of the respond number one at 10:30 AM on 18th March 2025. ಯಾವತ್ತು ಹೋಗ್ತೀರಾ?
ಶಿವಮೊಗ್ಗದಲ್ಲಿ ಸ್ವಲ್ಪ
ಯಾವತ್ತು
ಅಲ್ಲೇ
ಹೋಗ್ತೀರಾ?
ಇರೋದು ಸೊಸೈಟಿ ಅಲ್ಲೇ ಸ್ವಾಮಿ.
ನೆಕ್ಸ್ಟ್ 24th or 25th.
ಎಷ್ಟು ದೂರ ಹೋಗುತ್ತೋ ಅಷ್ಟು ದೂರ.
ಶಿವಮೊಗ್ಗನೇ.
24th March 2025. Released on 3rd April.
In the meantime,
Interim order earlier granted is extended.
interim order default ಅಲ್ಲಿ ಇದಾಗುತ್ತೆ.
ಮಾಡಿದೀವಿ, extend ಮಾಡಿದೀವಿ.
Please.
ನೀವು settlement ಮಾಡ್ಕೊಳ್ಳಿ.
Serial number 24 dismissed, 25 Mahesha Rupin and connected matters.
ಇಲ್ಲ pass over. Pass over. All the matters we are taking up. Once we finish this, everybody could address items.
Serial number 26,
Same, pass over.
27 Jaiprakash
In
Reddy.
impleading ಏನಿದು?
Completing application filed by the one of the member. Served the copy.
That's in all the cases they have filed. In some they have shown, some they have.
ಎಲ್ರು ಅರ್ಜೆಂಟ್ ಅಂತ ಇದಾರೆ, ಸೊ ಅದು ಅಲೌಡ್.
Already the election is conducted, Your Honor. Only in the result.
27, accepting the reasons stated in support of IA 1/25, the impleading of applications allowed.
ನಾನು ಕೊಟ್ಟಿದ್ದೀನಿ.
Yesterday in the 27, order has been passed on IA for repleading. Adu, your lordship has permitted them to come as an intervener, not as a. Yesterday, your lordship was pleased to pass that order.
I pass over.
Please, madam.
28 Sandesh TB.
Kindly pass over.
Pass over.
29 Jaiprakash Reddy.
Ready? Mr. Reddy, ನಿಮ್ದೇ ಮ್ಯಾಟ್ರು. Sure,
Sure.
29.
29. Yesterday, identical matter was. Remote.
And AGA accepts notice for respond number 1, 2, 3. TL Kiran Kumar for 4, issue notice to respond number 5, returnable by 9th April. The voting rights and delivery order.
30
Voting rights.
ಅಲ್ಲ voting rights ಅಲ್ಲ ಇದು. ಬೇರೆ voting
ಬೇರೆನಾ?
rights. Lord, election was held on 9/2/2025. Now results have not been declared still. 9/2
ಏನಕ್ಕಪ್ಪ ಆಗಿಲ್ಲ?
ಅಲ್ಲಲ್ಲ
Petition
ಅದಕ್ಕೆ
pending ಇದೆಯಾ?
ಅದು ಕೆಲವರು voting rights ಗೆ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕೊಂಡಿದ್ರು. 3 ರಿಟ್ petitions were filed. Stay because it was pending there, results were not declared. Now all those 3 rit petitions have been disposed of. Disposed of. Now the returning officer has fixed the date for tomorrow for declaration, for counting and declaration.
Disposed of in what terms?
Not on the ground that you raise section 70
election
petition. Anta dispose agide. And there is a direction to announce the results.
ಎಲ್ಲ ಹಂಗೆ dispose.
Andre society appeared and said they have not complied with 13D. Therefore, it
They have
was
not complied.
ಈಗ ಇದ್ರಲ್ಲಿ ಏನಾಗಿದೆ?
And AGA accepts notice for respond number 1, 3.
ಅಲ್ಲ ಇದು
4, TL Kiran Kumar for 2.
ಇದ್ರಲ್ಲಿ slightly different, my lord. ಈಗ ಇನ್ನೂ ಡಿಕ್ಲೇರ್ ಆಗಿಲ್ಲ, ನಾಳೆಗಿದೆ. Meanwhile, one of the candidate, my lord, he expired on 17/2. Before the declaration, he expired. Not the next highest vote ಅಲ್ಲಿ ನಾನಿದ್ದೀನಿ. So, my lord, I am asking for.
Counting ಆಗಿ ಎಲ್ಲರಿಗೂ
ಗೊತ್ತಾಗಿದೆ ಡಿಕ್ಲರೇಷನ್ ಅಫಿಷಿಯಲಿ ಡಿಕ್ಲೇರ್ ಆಗಬೇಕು. ನೆಕ್ಸ್ಟ್ ಹೈಯೆಸ್ಟ್ vote ಅಲ್ಲಿ ನಾನಿದ್ದೀನಿ. Therefore, I have sought for a direction to the returning officer for declaring me as the elected candidate.
Applicable law is there, they'll follow the applicable law. We can't directly.
representation ಕೊಟ್ಟಿದ್ದೀನಿ. That representation may be considered because
In accordance-
14 F ಅಲ್ಲಿ before, my lord, before polling death is occurred, my lord, they'll have to hold a fresh election for fresh nomination and rescheduling the
After polling
calendar.
ಇಲ್ಲ.
After polling ಇದರಲ್ಲಿ ಏನಿಲ್ಲ. Therefore, I have not.
Whatever the applicable law, they will pass an order.
I have given a representation to the returning officer, my lord, that.
So
may be-
respond number 5 ಯಾರು? Who is the standing counsel?
Standing counsel ಇದಕ್ಕೆ
Unless we serve them, we can't pass any order. ಇದಾರ ನೋಟಿಸ್ ಹೋಗ್ಬೇಕಾ?
ಗೊತ್ತಿಲ್ಲ ಇದಕ್ಕೆ ಯಾರು ಇದಾರೆ ಅಂತ. Housing.
Issue emergent notice to respond number 5, written over by 3rd April.
ನಾಳೆಗೆ ಡಿಕ್ಲರೇಷನ್ ಇದೆ. Subject to at least subject declaration.
ಏನ್ ಸಬ್ಜೆಕ್ಟ್?
ನಾಳೆಗಿದೆ ಡಿಕ್ಲರೇಷನ್. ನಾಳೆ ಅವರು ಅಕಸ್ಮಾತ್ ನನ್ನ ಡಿಕ್ಲೇರ್ ಮಾಡಿ ಅಂತ ನಾನು ಕೇಳಿದ್ದೀನಿ.
We have to issue a mandamus. There's not a certiorari subject to ಹೆಂಗಾಗತ್ತೆ?
ಅಲ್ಲ
mandamus ಅಲ್ಲಿ subject to ಹೆಂಗಾಗತ್ತೆ?
ಅಲ್ಲ ಐ ಹ್ಯಾವ್ ಪಾಸಿಟಿವ್ ಡೈರೆಕ್ಷನ್ ಕೇಳಿದ್ದೀನಿ ಅದರಲ್ಲಿ.
ಕೇಳಿದ್ದೀರಾ? But only if it is certiorari, we can make it subject to. Mandamus ಅಲ್ಲಿ subject to ಹೆಂಗ್ ಮಾಡಕ್ಕಾಗತ್ತೆ? Mandamus ಅಲ್ಲಿ ಅದೇ ಆಗತ್ತೆ. We can't make it subject to in a mandamus. Service ಮಾಡಂಗಿದ್ರೆ ಮಾಡಿ.
ಹ್ಯಾಂಡ್ ಸಮನ್ಸ್ ಮಾಡ್ತೀನಿ ಇವತ್ತು.
Counsel for the petitioner is also permitted to take out hand summons on the respondent. Emergent notice written over, but ನಾಳೆ ಒಳಗೆ ಆಗಲ್ವಲ್ಲ?
ಅದೇ ಆಗಲ್ಲ.
ನಾಳೆ ರಜಾ ಬೇರೆ. ಅದಕ್ಕೆ ಬರೋವಾಗ ಯಾರು ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಅಂತ ತಿಳ್ಕೊಂಡು ಬಂದ್ಬಿಡ್ಬೇಕು. ಅವ್ರು ಹೇಳ್ಕೊಂಡು ಬಂದ್ಬಿಡ್ಬೇಕು.
ತಿಳ್ಕೊಂಡು ನನ್ಗೆ ಗೊತ್ತಾಗಲಿ ಇದಕ್ಕೆ
ಹೇಳ್ಕೊಂಡು ಬರ್ಬೇಕು.
ಅಲ್ಲ ಇದ್ರ ಸೊಸೈಟಿಯಲ್ಲಿ ನಾರ್ಮಲ್ ಸ್ಟ್ಯಾಂಡಿಂಗ್ ಕೌನ್ಸಿಲ್ ಯಾರು ಇರಲ್ಲ, ಅವರೇ ಆಮೇಲೆ ಕೊಡೋದು.
ನೀವೇ ಎಷ್ಟೋ ಸೊಸೈಟಿಗೆ ಅಪಿಯರ್ ಆಗ್ತೀರಾ ಮಿಸ್ ಶೆಟ್ಟಿ, ಸೊ ಯು ನೋ ಇಟ್. Emergent notice written by 27th March.
31, Jayaprakash Reddy.
Same as 29, my lord.
And AGA for respond number 1, 2, 3. TL Kiran Kumar for 4, issue emergent notice to 5, returnable by 9th.
ಅಲ್ಲ 3-4ಗೆ ನೆನ್ನೆ ಇದು ಮ್ಯಾಟರ್ಸ್ ಎರಡು 3-4 ಕೊಟ್ಟಿದ್ರಿ ಸ್ವಾಮಿ.
3-4.
ಸೀರಿಯಲ್ ನಂಬರ್ 29 ಅಲ್ಲೂ 3-4.
29 3-4.
32, R Hemant Raj.
Yes, Hemant.
Kindly see annexure B, page number 28. Your lordship has rightly allowed the writ petition, the invoking by section 12(6) of proceedings. Kindly take page number 44. Page number 44. The third direction. The third response to administer is directed to call for special general body meeting by issuing necessary notices to the concerned primary members, giving the notice as recorded under the act. Now you have to kindly take special meaning of the special general body meeting under the Society Registration Act. General body means 2E6.
Yes.
2E6. In relation to primary cooperative society, all the members of the cooperative society. Then this is important. In relation to secondary cooperative society, or is a secondary cooperative society? Society, all the delegates of the member of cooperative society and the individual members, they are permitted to participate in the meeting and they are permitted to vote in the meeting. In relation to the secondary cooperative society, the meeting is taken by the secondary cooperative society. This is the fourth respondent herein. In relation to the secondary cooperative society, all the delegates of the members of cooperative society and the individual members, delegates. Now you should kindly see what is the meaning of the delegates under the Society Act. 2(1)(e)(1)(a), delegate. Delegatee means a director of cooperative society appointed by the board to represent that a cooperative society in order to cooperative society with power to participate and vote in the general meeting and consent or proposed or second in the election of the cooperative society, to which he is appointed as a delegatee. Delegatee means a member of the board of cooperative society appointed by the board to represent that a cooperative society in other cooperative society. Now you should kindly see meeting, you should annexure A. They have restricted only president of the society. primary societies, annexure A, page number 17, they issued this meeting notice. In this notice, Your Lordship, they restricted the page number 20. ಒಕ್ಕೂಟದ ಸದಸ್ಯ ಸಂಘಗಳ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಅಧ್ಯಕ್ಷಣೀಯ ಮಾತ್ರ ವಿಶೇಷ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಭಾಗವಹಿಸಲು ಅವಕಾಶವಿರುತ್ತದೆ.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
ಪೇಜ್ ನಂಬರ್ 20 ಸ್ವಾಮಿ. ಸೂಚನೆ.
ಸೂಚನೆ. ಎಸ್.
ಒಕ್ಕೂಟದ ಸದಸ್ಯ ಸಂಘಗಳ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಅಧ್ಯಕ್ಷಣೀಯರು ಮಾತ್ರ ವಿಶೇಷ ಸಾಮಾನ್ಯ ಸಭೆಯಲ್ಲಿ ಭಾಗವಹಿಸಲು ಅವಕಾಶವಿರುತ್ತದೆ. ಆದ್ದರಿಂದ ಸಂಘದ ದೃಢೀಕರಣ ಪತ್ರದೊಂದಿಗೆ ಹಾಜರಾಗಲು ಕೋರಿದೆ. This is not a direction of your Lordship order. The delegating, Your Lordship, this is not a restricted only for the president or vice presidents, lady president or gents president. They are restricted only, they are allowed to participate in the meeting only insofar as the president is concerned. That is not, Your Lordship, the meaning of the general body, special general body meeting. The delegating means, Your Lordship, the board as directed by the board of any persons. That is not, Your Lordship, confined to, Your Lordship, the president under the Society Registration Act. They are not allowed to, Your Lordship, the members of delegate of the society, primary society, in the meeting of secondary society.
Yes, Mr. Devi Prasad Shetty.
Lords, R5, my lords, I am appearing on behalf of R5. Lords, on the principle, my lords, as to who is required to represent the primary society.
You had appeared last time. Yes.
Lords, the first and foremost question, the person who is now before this honorable court is the president. He is not the delegate himself.
He has been anyway authorized.
Lords, he is not the delegate himself. He is entitled to participate. The delegate.
What about the delegates?
Lords, so far as delegate is concerned, my lords, whatever my learned friend said, Lords, delegate, your lords, may kindly see the definition of delegate. Lords, delegates are usually only for the purposes of voting in the polling process.
Yes.
This is not pertaining to any polling, my lords. This is in the general body for the purpose of passing a resolution in relation to the amendment of the bylaws.
No, there is no.
Delegate, E1A. Delegate means a board of director of a cooperative society appointed by the board to represent the cooperative society and other cooperative society with power to participate and vote in the general meeting and to contest or propose or second in the election of the cooperative society to which he is appointed as a delegate. Delegate, my lords, in the usual parlance. I'll also take your lordships to the other provisions, my lords. Lordships, may kindly have a look at the definition of representative in I2. Representative.
Section 2.
Section 2, I2.
Yes.
Representative means a person elected by a group of individual members of a primary cooperative society or a secondary cooperative society to represent them to participate in their behalf in the representative general body of the meeting of the society in accordance with the act, rules and the bylaws under this act. Now, so far as the general body is concerned, this stands further clarified under Rule 14AK. Lords, what happens so far as the delegates is concerned? Just a prelude to what I want to submit, Lords. The term of all the primary societies came to an end. So they have already conducted their elections. Now, after they conduct their elections, Lords, they will have to send their delegate list. That scenario will come under 13D6. 13D 2A6. If your lordships were to see 13D 2A6, then I'll take your lordships to Rule 14AK.
Yes.
Lords, the Cooperative Election Authority shall call upon the chief executive of the cooperative society to obtain from the member society the name of an authorized member of the board of such society. 13D 2A6. Rule.
2A6.
2A6
is the final list.
Lords, I'm sorry, Lords, it's 13D6 only. I'm sorry, my sincere apologies. 13D6.
The Cooperative Election
Authority shall call upon the chief executive of the cooperative society to obtain from the member society the name of an authorized member of the board of such society as a delegate, together with the resolution of the board of the said society and the specimen signature, along with the photographs of the delegate duly attested and bearing the seal of the society, and furnish all such information, so on and so forth. But this, the reason why I'm reading this is, once the term is over, Lords, of the previous societies, then the delegates also will vanish. When the fresh elections are required to be conducted for the federal society, then this is the procedure for calling upon the delegates. Now, participation of the member societies in the general body is covered under Rule 14AK. board meetings. Friends, may I straight away draw your lordship's attention to sub-rule 12 of Rule 14 AK. Where in a meeting of the general body or board of a cooperative society, another cooperative society is to be represented, and such cooperative society shall be represented in such meeting only through a chairperson or a president, or a member of the board duly authorized by the board of such cooperative society, as the case may be. And where there is no such board, then it is for whatever reason through the administrator or the special officer of such cooperative society.
Correct. Yeah.
Note the word delegate is conspicuously absent in 12. 14. Sub-rule 12 of Rule 14 AK. The reason, my lords, is the scheme of the statute is that at the time of polling, my lords, there is a requirement of a specified person or a director being sent as a delegate.
14 AK is relating to board meetings.
Or board meetings, my lords.
Now, the meeting which is convened is a general meeting.
It's a general meeting.
General body meeting.
So general meeting is different from a board meeting.
Lord, general meeting is different. Lords, even wherever, Lord, the reason why I am submitting is, if your lordships were to see sub-rule 12, where in a meeting of the general body, lordships may kindly note the words, my lords. Though the caption, it starts as board meetings, 14 AK 12 deals with where in a meeting of the general body or a board of a cooperative society, another cooperative society is to be represented.
That seems to be an error, because every other clause only speaks of the board meeting.
This is consciously inserted, my lords, because so far as, my lords, I don't think, my lords, that there is any difficulty with reference to, because the delegate is conspicuously absent in the general body. But what I would submit is this, my lords. At the instance of the present petitioner, he himself is the president.
That is the...
Now, he doesn't have a cause. Lords, it's not that he can hold a public interest litigation, my lords, because he's an individual member of the society.
I can't, Your Worship, for a moment, that is the answer.
He can.
Your Worship, straight away, I can't participate in the meeting. Your Worship, they have to give authorization. Though I am the president, Your Worship, the society has to authorize me as a delegate. Otherwise, I can't participate in the meeting.
So I'm making a statement.
Merely, Your Worship, I am the president. Straight away, I can't appear before the general body meeting.
And bylaws of the society, my lords, may just the fifth respondent society
That is the
bylaws.
meeting of the delegation. Merely, Your Worship, I am the president of the society. Straight away, I can't appear. Your Worship, they have to, board has taken resolution and give authorization to participate in the meeting. That is called the delegation.
May just pass on
They
the
may
bylaws.
send another person also, Your Worship. Instead of me, they may send another person also.
But the bylaws of the fifth respondent society, my lords. Lords, that
Yes, where are the
situation under 13D6 is yet to arrive. Because the elections are not.
bylaws?
My lords, I am just passing on the copy of the bylaws.
What is the meeting now called for? It's a
Lord,
general
Still
meeting.
general
Lord,
body
may I
meeting.
just, my lords, what happened?
Your
There
Lordship
was a
order is-
direction for amendment of the bylaws.
Our argument madak or mugili amel ni vedli.
Your Lordship order is correct, Your Lordship. Kindly see.
Thank you for the certification. Please sit. Let him finish his argument. We'll come back to you.
Lords, there was a direction to amend the bylaws.
Huh.
Lords, your lordships
No,
intervened.
what is this meeting which is
Lord, the
Vishesha
meeting is
Samanya
pursuant to,
Sabhe?
yes, pursuant
Special
to-
general
yes,
body
pursuant
meeting.
to your lordship's direction,
Hmm.
there is a requirement of placing the proposed amendment of the bylaws before the general body,
Yes,
for which a special general body meeting is required to be called.
yes.
Lord, then two people came before this honorable court and wanted to scuttle on certain grounds.
Hmm.
Writ petition was subsequently dismissed by imposing a cost of 50,000 rupees.
Hmm.
Even in the interim prayer, which is sought for in the instant writ petition, they wanted stay of the meeting. Ultimately, that is the whole object, my lords, with which this writ petition is filed. Because from the writ petition, I don't find a cause of action at all as to why he will be prevented from attending the meeting. Nonetheless, lords, now the bylaws of the fifth respondent society, lords, there are options given if your lords were to see, my lords. Bylaw of the society. My lords, it is
This is
here.
a meeting in person of subsection 6 of section 12.
Yes.
What is subsection 6 of 12?
But subsection 6, my lords, is placing it before the general body. Subsection 5, my lords, it will be, because that will be through 3. and then rule, my lords, if your lords were to see, because subsection 5, then your lords may kindly come to rule 6.
Yes.
Lords, rule 6, my lords, where a cooperative society proposes to amend its bylaws, where a cooperative society proposes to amend its bylaws, no such amendment shall be made, say by resolution passed by 2/3 majority of the members present and voting at a general
You
meeting.
are reading which rule?
Lords, rule 6.
6, yes. Yes.
Lords, no such resolution shall be valid unless notice of 15 clear days with the text of existing bylaws, so on. So, my lords, I'd skip 1, 2, 3, 4, and 5, my lords, because this is pertaining to the voluntary amendment of the bylaws.
Yes.
What is directed by the registrar is covered under sub-rule 6 of rule 6. Where the registrar proposes any amendment to the bylaws of the cooperative society under subsection 5 of section 12, the authority competent to convene the meeting shall place such proposal before the annual or special general meeting, as the case may be, and a decision on such proposal shall be taken at a meeting, and the cooperative society shall carry out the amendment of the bylaws as directed by the registrar as per section 12(5) of the Act.
Yes.
Lords, just before that, may I just request your lords may kindly take sub-rule 2 also, my lords. The resolution should not be passed. No such resolution shall be valid unless notice of 15 clear days with the text of the existing bylaw, the text of the proposed amendment, and the reasons therefore has been given to the members of the society in accordance with the bylaws. So members are the primary societies.
Yes.
So the notice is required to be given to the members, and thereafterwards, my lords, a meeting will be convened in terms of sub-rule 6, and the meeting will have to be conducted. Now, the president is the person who is before the court. The notice specifically says president is entitled to participate. My lords, if he came up with a case before this honorable court saying that I don't want to go and participate in the meetings, but the society has decided that somebody else is to go and participate in the meetings, he will have a cause.
Correct.
Even our bylaw, that's not the pleadings. So that's
That is my case.
That's not the pleadings, my lords. Kindly have a look at the bylaws, because bylaw is very flexible, my lords. Our bylaws, the society bylaws.
Flexible is, yes.
My lords, at page 45, my lords, general body, just before 13, my lords. Subject to the provisions of the Act, the rules and the bylaws, the final authority of the union shall vest in the general body of the members. The general body of the union shall consist of all the delegates of the member society at the rate of president. President by default, my lords, is the delegate of the society according to our bylaws, or one director chosen by the board of each society from amongst its directors. The board of every member of society shall choose its president or a director to be its delegate to participate and vote in the general meeting, or to participate, contest, vote, or withdraw the nomination paper in the election of the directors of the union. We recognize, my lords, the president is by default the head of the institution, which is the member society, and we permit the society.
It's automatic delegate unless authorized.
Unless they authorize somebody. My lords, I wanted to make a statement. If any other society comes up with a statement saying that we are sending a delegate instead of this, we have actually not prohibited. Strictly speaking, it's not prohibited, my lords. I should not say that no, you cannot send the delegate. But the difficulty here is the process of nominating or delegation comes after the term has ended and new body comes into existence. Then under 13D6, a letter will be sent, my lords, by the election authority to prepare the list of delegates and send it. So that situation has not yet arisen because elections are not yet conducted.
This is for amendment.
Only for amendment. Lords, and the interim prayer sought for is, I can understand, my lords, if they had sought for an interim prayer saying that let the delegate of our petitioner society be permitted to participate, I can understand. But this interim prayer is to stall the meeting.
No, interim order may be restricted like that. Sorry, your lords. Sorry.
New argument madavag you will interfere. Parvagilva? Sorry. Yes.
So therefore, my lords, my respectful submission is, President is entitled. If your lords were to see the pleadings, because I just went through the pleadings, my lords, conspicuously absent of what is now being sought for. Lords, grounds, if your lords were to see, my lords, at page number 11, para 11. This is the cause, my lords. This is the only statement which I find. The petitioner further submits that pursuant to the order dated 10/12, passed in WP number so and so, fifth respondent issued notice, whereas a special general body meeting was scheduled to be held on 13/3. Notice dated 27/2, only the presidents of the primary societies were allowed to participate. Delegates were not allowed to participate contrary to the provisions of the Act. Petitioner society is aggrieved by the notice, so on and so forth.
Yes.
And then, my lords, the next sentence, the petitioner is, I'm sorry, before this honorable court, copy of the authorization given to the petitioner to initiate the proceedings before this honorable court is produced as an surety. So the president himself is again authorized. And president is the person who is being permitted into the meeting.
Authorization to file a writ petition.
So therefore, my lords, there's no cause. In fact, the foundational facts to say that they wanted to send a delegate is conspicuously absent in the writ petition pleadings. Lordships.
Yes. 14 AK, sub-rule 12, your lordship.
14 AK.
Sub-rule 12. Where in any meeting of the general body or board of a cooperative society, another cooperative society is to be represented. Such cooperative society shall be represented in such a meeting only through the chairperson or president or a member of the board. You should kindly mark it, or member of the board duly authorized by the board of such cooperative, as case may be, and where there is no board of such cooperative society for whatever reason, through the administrator or the special officer of such cooperative society. It should be, no, your lordship, my learned senior counsel submitting that, I am the president, I can appear. No, your lordship, merely I become a president, your lordship, there is no authorization. Unless and until the board has given me authorization to participate in the special body meeting, then I can't appear, your lordship.
Has your board authorized anybody else?
Still, your lordship, they are not taking a decision.
So let them take a decision.
Reason is this, your lordship. Kindly clarify that effect, your lordship. That is enough.
Your general body definition under your bylaws says that general body would be
Adrlo or anta ide sum.
or irado andilla ade ಹೇಳ್ತಾರೆ ನಿಮಗೆ. It's only or andilla. President and delegate alla.
Delegates.
One of them. If ಯಾರು delegate ಮಾಡಿದ್ರೆ ನಿಮ್ಗೇನು ವ್ಯಾಲ್ಯೂ ಇಲ್ಲ.
ಅದೇ correct.
President ಆದ್ರೆ
in case tomorrow board has taken a decision, your lordship, they are authorized to delegate any other person, none other than the president, then your lordship, I can't participate. Merely I become the president of the society, straight away I can't appear before the meeting.
You can, as per this, by merely being a
But
president.
your lordship, the notice is restricted. Kindly for a moment, your lordship, kindly annexure page number 20. Notice is restricted. That is the reason, that is my grievance. Page number 20. ಸೂಚನೆ ಒಕ್ಕೂಟದ ಸಂಘ ಒಕ್ಕೂಟದ ಸದಸ್ಯ ಸಂಘಗಳ ಮಾನ್ಯ ಅಧ್ಯಕ್ಷರು ಮತ್ತು ಅಧ್ಯಕ್ಷರು ಮಾತ್ರ
Why won't you add a delegate?
Delegates ಅಷ್ಟೇ ನಂದು, that is my grievance.
If he makes his statement before the court, that he wants to send a delegate, I'll just get instructions if they wanted to permit delegates or otherwise.
Insofar as this society, but ನಾಳೆ ಇನ್ನೊಂದು 10 petition ಬರುತ್ತೆ. 13 ಜನ ಅಲ್ಲ.
That's the reason why I said, this is a notice which is sent on 27/2. Meeting is on 13/2, another 4 days. Nobody has come. The notices are served, and all of them have already sent this. Kindly have a look at page 27 for 1 second, These forms are already sent to us.
We'll make it applicable to all the other primary
Page
societies.
27, Lords, is my kindly say.
Page it correct, sir. I want to intend to show this document.
Lords, this is sent to us already.
ದೃಢೀಕರಣ ಪತ್ರ. ಸಹಕಾರ
Lords,
ಸಂಘ
other
By
societies
all
are-
of them.
Lords, they have already sent it.
And who has come, is a delegate or is the president in all of them?
President, Lords, in president.
In all of
the-
them, president.
Yes, all of them have already sent this
If there is
forms.
a delegate other than the president,
Lords, if
what
there is a
I-
delegate, we will permit, Lords. We'll permit. Our bylaws.
That clarify, that is a clarification is required. They should not restrict only president.
petitioner. So submission record ಮಾಡಿ ಅಷ್ಟೇ dispose, ಇದೆಲ್ಲ ಬೇಡಲ್ಲ ಹಾಗಾದ್ರೆ.
ಆಯ್ತು.
ಅದನ್ನೆಲ್ಲ ಡೀಲ್ ಮಾಡ್ಬೇಕು.
ಅದೇ ಬೇಡ.
ಇನ್ನೂ ಒಂದ್ಸತಿ ಮಾಡೋಣ ಅಂತಾರೆ. ಇಲ್ಲ ಇವಾಗ್ಲೇ ಮುಗಿಸ್ಬಿಡೋಣ. So that doesn't become an issue again.
ಅಲ್ಲ 15 days notice ಇರಬೇಕಾಗುತ್ತೆ.
ಕೋಲಾರು, ಚಿಂತಾಮಣಿ.
As per their bylaws, 15 days notice is required. ಅಲ್ಲಿಂದ ಮಾಡ್ಲಿ ಸ್ವಾಮಿ, ನಮ್ಗೇನಿಲ್ಲ. Delegates power ಕೊಡ್ಲಿ.
Petitioner is before this court seeking for the following reliefs. You have filed caveat for R4. R5 ಗೆ?
It should be filed for R5 only minutes.
They have noted it as for R4 because It was filed as Kolar District Cooperative Society by
Do you
by
accept-
managing director.
Do you
So,
accept notice for respond number five?
Five. Four, my lord,
And
the
AGA
government-
accepts notice for respond number 1 to 3. Shri Sarvana S, who has filed caveat for respond number 4, accepts notice for respond number 5 also. Registry is direct print his name. as
1 to
such.
4 will be government minutes.
1 to 4.
Yes, because 4 is the
1 to 4
administrator.
administrator.
Yes.
1 to 4 AGA. Shri Sarvana S submit that he has filed caveat for respond number 5. It has been wrongly shown as appearing for respond number 4. His registry is correct his appearance as that appearing for respond number 5. The petitioner is before this court seeking for the following reliefs. The petitioner is aggrieved by a notice for meeting issued by respond number 5 for a meeting proposed to be held on 13/3/2025 at 11:30 PM to consider amendments to the bylaws. The submission of Shri R. Hemant Raj, learned counsel for the petitioner, is that the meeting, being a special general meeting, is restricted, the participation is restricted only to the president of the various societies, being the members of respond number 5 society. In terms of section
2E1A.
subsection E1A of section 2 of the Karnataka Cooperative Societies Act 1959, and after brevity referred to as Act of 1959. A delegate would mean a director of a cooperative society appointed by the board to represent that cooperative society. And as such, he submits that it is not only the president, it is not the president who will be an automatic delegate, but would have to be nominated by the cooperative society. Subsection E1A of section 2 is reproduced hereunder for easy reference.
My apologies. Can I seek your lordship's excuse?
Yes, please.
Great.
His further submission is that in terms of Rule 14 AK, Sub-Rule 12 of Rule 14 AK of the Karnataka Cooperative Societies Rules 1960, and after for brevity referred to as Rules of 1960, it is the chairperson or president or a member of the board duly authorized by the board of such cooperative who could represent the cooperative in the meeting. Sub-Rule 12 of Rule 14 AK is reproduced hereunder for easy reference. His submission, therefore, is that the meeting could not have been restricted to be attended by the president of the primary cooperatives, but there should have been a notice issued to the cooperatives permitting a delegate to represent the primary cooperative in the meeting of the fifth respondent. Shri D.R. Ravi Shankar and Senior Counsel appearing for respondent number 5 would submit that though the notice has been issued indicating the president to attend the meeting, the same has been issued in pursuance of Rule 12 of the bylaws, bylaw 12 of the bylaws of respondent number 5, which defines a general body as under page 45. By referring to the above definition, he submits that the general body of the union would consist of delegates of all the member societies at the rate of president or one director chosen by the board of each society from among its directors. The board of every member society shall choose its president or a director to be its delegate to participate and vote in the general meeting or to participate, contest, vote or withdraw the nomination paper in the election of the directors of the union. Thus, he submits that unless there is a delegation made by the primary cooperative, the president would be the de facto, the president would be the president. the one who would be authorized to represent the primary cooperative in the meeting. If there is anyone else who is delegated among the board of directors, they could also attend the meeting of the fifth respondent. He therefore submits that there is no restriction on the primary cooperative appointing any delegate to the meeting. Again, by relying on sub-rule 12 of rule 14 AK, he submits that it is only one person who could represent the primary cooperative, who could either be the chairperson or president or a member of the board duly authorized by the board. By default, it has been considered that the president is the delegate of the primary cooperative. In the event of anyone else being nominated, such person could attend the meeting to be held on 13th March 2025 at 11:30 a.m. He therefore submits that the petition could be accordingly disposed, recording his submissions. Third, so-and-so peruse papers. The submission of Sri D.R. Ravishankar and Senior Counsel would answer the grievance of the petitioner inasmuch as the society itself having the respondent number 5 society itself having clarified that by default the president could represent the primary cooperative, and in the event of primary cooperative nominating any other director apart from the president, such director could be the delegate at the meeting, would answer the grievance of the petitioner. It's, however, required for this court to also answer the contentions which have been taken up by both the councils. Inasmuch as the general body definition having been extracted here and above, it is clear from the said definition itself that it is the president by default who would represent the primary cooperative, and if anyone else is nominated by the primary cooperative, that person would be the delegate at the meeting. Thus, as per the bylaws, it is clear that it could be the president who could attend the meeting as a delegate by default, or any other board member could be appointed as a delegate. Needless to say, if any other board member is appointed as a delegate, the president would not be a delegate of the primary cooperative, and it would be the delegate nominated by the primary cooperative who would represent the primary cooperative in the said meeting. Even a perusal of sub-rule 12 of rule 14 AK, which has been reproduced here and above, would also indicate that it is a disjunctive or which has been used, thereby permitting the chairperson or the president or a member of the board nominated by the primary cooperative. Thus, again, it would be one of the above who could represent the primary cooperative in the meeting. If there is no delegation stroke nomination made by the board, by the primary cooperative, it would be the president who would be by default represent the primary cooperative in the meeting. And if there is a delegation made by the primary cooperative of any other person other than any other board member other than the president, then such nominated delegate shall replace the president as a default nominee and would attend the meeting. Thus, it is clear that the president, though is a nominated member, president is nominated by default, it could be any other board member who also could be nominated by the board of the primary cooperative. Hence, though there is a technical defect in the notice which has been issued at Annexure A, which does not include the word delegate of the primary cooperative, the submission of Shri D.R. Ravishankar and Senior Counsel on behalf of the primary cooperative, on behalf of respondent number 5, on instruction that even a delegate of any primary cooperative supported by necessary documents would be permitted to participate in the meeting to be held on 13/3/2025 would not only inure to the benefit of the petitioner primary cooperative, but any other primary cooperative who is a member of respondent number 5, which would answer the grievance. As such, I pass the following order. Writ petition is disposed in terms of the submission made by Shri D.R. The writ petition is disposed in terms of submission made by learned senior counsel on behalf of respondent number 5, that even a delegate supported by necessary documents would be permitted to participate in the election proposed to be held on 13/3.
Only small indulgence, sir. Small clarification. Rule 6, your lordship, there should be 15 days clear notice, your lordship.
No. You cannot be asking for all those things.
At least.
Your whole purpose is to delay the meeting, which we won't tell.
My friend has not yet clarified whether president is participating or his delegate is.
ನಿಮ್ ಪೆಟಿಷನ್ ಅಲ್ಲೇ ಹೊಡೆದಾಕ್ಬಿಡ್ಬೋದಾಗಿತ್ತು.
ಈಗಲೂ ಇನ್ನೂ ಅವ್ರು ಹೇಳಿಲ್ಲ.
ಇನ್ನೊಬ್ರು ಯಾರು ಬರೋದು ಬೇಡ ಅಂತ ಇದಷ್ಟೇ. ಏನು ಈ ಮಿಲ್ಕ್ ನಿನ್ನೆ ಅದೇ ಜಯಕುಮಾರ್ ಪಾಟೀಲ್ ಅವ್ರಿಗೆ ಹೇಳ್ತಾ ಇದೆ, ಮಿಲ್ಕ್ ಪ್ರೈಸಸ್ ಹ್ಯಾವ್ ಗಾನ್ ಅಪ್ ಬಿಕಾಸ್ ಆಫ್ ಯುವರ್ ಫೈಟಿಂಗ್. If your fighting reduces, the milk price will come down. ಎಷ್ಟು litigation ಇದು? We are not speaking of lawyers' fees. Minimum ಒಂದು 4 ರೂಪಾಯಿ ಕಮ್ಮಿ ಆಗತ್ತೆ.
Serial number 33, Jayaprakash Reddy.
Yes, Mr. Reddy.
Lord, in this petition, my lord, the term of the managing committee has come to an end on 1/2/2025, my lord. No elections have been held even till today. No steps has been taken.
Special officer appoint ಆಗಿದಾರಾ ಇಲ್ವಾ?
ಇಲ್ಲ ಆಗಿಲ್ಲ.
ಅದು ಆಗಿಲ್ಲ.
ಅದು ಆಗಿಲ್ಲ.
And AG accepts notice for respond number
1 to 3.
1 to 3, 4 ಗ್ಯಾರು.
No, notice ಹೋಗುತ್ತೆ.
Issue emergent notice to respond number 4. Returnable by 14th. Counsel for the petitioner is also permitted to take out and summons on respond number 4. Released on 14th.
Serial number 4, 31 ಅಲ್ಲಿ and delivery, man.
31 and delivery.
34, Sandesh TB.
Here for the petitioner's counsel. The
Mr. Patel.
term is due to expire on 23/3/25.
ಏನೇನಾಗಿದೆ
We have taken every one of the steps, including 13D2A by registered post. Repeatedly, we wrote to them. In spite of it, returning officer or scrutiny officer for voter list are not being done. It is deliberately not being done because we are an intending contesting candidate. Our society would propose a candidate for the Mysore DCC Bank election. They don't want us to contest, therefore they can appoint an administrator. This is happening only in Mysore district. And for that, recently about 10 days, 15 days back, this court was pleased to point out it's being done for no reason, and inference of legal malice could be properly done, and it was directed till the holding of election, the present committee shall continue.
This is as regards primary credit cooperative society.
Yes, the Agricultural Credit Cooperative Society, same DCC Bank.
Same.
This and 35 both are same.
ಮತ್ತೆ ಇನ್ನೇನಕ್ಕೆ ಬೇಕು ನಿಮ್ಗೆ ಇನ್ನೊಂದು ಆರ್ಡರ್?
ಅಲ್ಲಲ್ಲ, ಅದು ಅಂದ್ರೆ ಬೇರೆ ಸೊಸೈಟಿ.
ಬೇರೆ ಸೊಸೈಟಿ.
ಬೇರೆ ಸೊಸೈಟಿಗೆ. ಅಂದ್ರೆ ಮೈಸೂರಿನಲ್ಲಿ ಆಗ್ತಾರೆ.
ಮೈಸೂರಲ್ಲಿ ಆಗ್ತಾರೆ. ಯಾಕ್ರಿ?
ಮೈಸೂರು ಡಿಸ್ಟ್ರಿಕ್ಟ್.
This case is concerned, my lord, whether.
Why can't we automate this process? Your 13D26, D2, 2A, all of it data is already available. Every time ಇದೇನಕ್ಕೆ ಮಾಡಬೇಕು? ಎಲ್ಲ ಮೆಂಬರ್ಸ್ ಏನಿದಾರೋ it can be uploaded. ಅವ್ರ 2A4 ಏನೇನು ಯೂಸ್ ಮಾಡಿದ್ದಾರೆ ಅಲ್ಲಿ ಬರ್ಬೋದು. ಅದಕ್ಕೆ why don't we instruct the society that they should web host all these details and put it up?
training to the all societies concerned.
ಅವ್ರಿಗೆ ಆಫ್ ಮಾಡಿ ಅಂತ ಹೇಳಿ ನೀವು ಆನ್ ಮಾಡ್ಕೊಳ್ಳಿ.
That regard, my lord, we have given all training to the, my lord, all societies concerned, my lord, whether they are properly, ಇದು ಮಾಡ್ತಾ ಇದಾರೆ ಅಂತ ಗೊತ್ತಾಗ್ತಾ ಇಲ್ಲ. But regarding this,
What is the solution, Mr. Patil?
ಅಲ್ಲ ಈ ಕೇಸ್ ಅಂತ ಹೇಳ್ತಾ ಇಲ್ಲ.
ಅವ್ರು ಇದ್ರೆ ಆಗಲ್ಲ. At least if you suggest what are the things to be done, we can direct them to do all those.
This 13D procedure, the procedure is too elaborate and it's like no.
As per the direction issued by the courts.
What could have been done was that disability could have been only for contesting, not for voting.
That we cannot change.
No.
What we are looking at is,
If it were to be for contesting, and then the notice could have been in a different manner instead of this RPAD. In the sugar factory society, there are more than 17 or 18,000 members. 90% of them, unless it is an election, they don't attend general body or anything. They supply sugar, they take the price of.
understand, nenne one matter bandittu adene. RPD agila anta we have to reject because the rules provide for it to be so. It's a waste of money spending 30 rupees on 10,000 people into 30 and 3 lakh rupai waste adu. But because of so much of infighting, it cannot be avoided.
Now, make some suggestion of amending the rules, a paper publication or something of the sort to be,
Division bench also.
And now nodilla ant bartare.
Division bench itself say that, my lord,
See, insofar as preparation of the list,
my lord.
that can be automated with all the list being web hosted. ಯಾರು ಏನ್ ಸರ್ವಿಸ್ ಪ್ರೊವೈಡ್ ಮಾಡಿದಾರೋ, ಅವೈಲ್ ಮಾಡಿದಾರೋ ಇಲ್ವೋ, ಪ್ರೊವೈಡ್ ಮಾಡಿದಾರೋ ಇಲ್ವೋ.
On that regard, my lord, society should be, my lord, upgraded on regarding that is concerned.
They can, we'll direct the societies on here, we'll instruct you to direct them.
ಇದರಲ್ಲಿ ಬೇಕಾದವ್ರು ಮಾತ್ರ ಮೆಂಬರ್ಸ್ ನ ಲಿಸ್ಟ್ ಮಾಡ್ತಾರೆ. ಅದರಲ್ಲೂ ತುಂಬಾ ರಾಜಕೀಯ ಇದೆ. ಸಿಇಒ ಯಾಕೆಂದ್ರೆ ಫುಲ್ ಅಲ್ಲೇ ಇರ್ತಾನೆ ಅವ್ನು ಸಿಇಒ.
ಇದು ಕಂಟಿನ್ಯೂಸ್ ಪ್ರೋಸೆಸ್ ಇದ್ರೆ ಯಾವಾಗ್ಲೂ ಒಂದಿನ ಆಗೋದ್ರಿಂದ ಇದು ಪ್ರಾಬ್ಲಮ್ ಆಗತ್ತೆ.
ಅಲ್ಲ ಇದು 5 years ಮಾತ್ರ ಅದಿರೋದು.
ಸೊ ಎವ್ರಿ ಇಯರ್ ಆಗ್ತಾ ಇದ್ರೆ ಇದು
ರಿಗಾರ್ಡಿಂಗ್, my lord, some of the correct.
ಇವಾಗ ಎಲೆಕ್ಷನ್ 5 years, ಇವಾಗ ಎಲೆಕ್ಷನ್ ಬಂದು ಅಂದಾಗ ಮಾಡಿದಾಗ ಎಲ್ಲ 5 ವರ್ಷ ಚೇಂಜ್ ಆಗೋಗತ್ತೆ. ಆ ವರ್ಷದ್ದು ಹಂಗೆ ಆಗ್ತಾ ಇದ್ರೆ ಆನ್ ಎ ಮಂತ್ಲಿ ಬೇಸಿಸ್ ಇಷ್ಟು ಹಾಲು ಸಪ್ಲೈ ಮಾಡಿದ್ರು, ಇಷ್ಟು ಕ್ರೆಡಿಟ್ ತಗೊಂಡ್ರು, ಇಷ್ಟು ಲೋನ್ ತಗೊಂಡ್ರು, ಇಷ್ಟು ಲೋನ್ ಇದು ಬಂತು, ಅದು ಅಲ್ಲಿ ಬಂದ್ರೆ then there won't be any hanky-panky or fudging of records at the last moment.
Correct.
Which is what is the allegation coming in almost all matters. That some transparency will come about.
13D notice is concerned, my lord, division bench taken a view that, my lord, is necessary.
First ನೀವು ನೋಟಿಸ್ ಕೊಡಕ್ಕೆ ಏನ್ ನಿಮ್ದು ಫೌಂಡೇಶನ್ ಏನೋ
Regarding, my
that
lord,
they have not availed the services
please,
Section
to
20.
hold them to be ineligible.
please.
So if that is web hosted on a monthly basis and updated with a time and date stamp.
Regarding, my lord.
ಈ ಮಂತ್ ಇಷ್ಟು ಸಪ್ಲೈ ಮಾಡಿದ್ರು ಬಂದ್ಬಿಡ್ತು, ಈ ಮಂತ್ 10,000 ರೂಪಾಯಿ ಲೋನ್ ತಗೊಂಡ್ರು ಅಂತ ಬಂತು, ಮುಗೀತು. ದೇ ಅವೈಲ್ಡ್ ಸರ್ವಿಸ್.
CEO.
ತಗೊಂಡಿಲ್ಲ ಅಂದ್ರೆ ಇಲ್ಲ.
Regarding that, my lord,
societies, agriculture credit societies, all these information is available in this system. Only thing to be done is an application of for web hosting, all that in in public domain.
See, please think about it. May not be today, maybe next week in another matter or somewhere. Or in the same matter, probably next week.
The loans which are issued, all are available in the system in every one of the society.
If we direct the registrar of cooperative society to set up a web portal for all the societies to enter these details, ಅವರು ಎಲ್ಲ ಒಂದೊಂದು ಸೊಸೈಟಿ ಮಾಡಕ್ಕಾಗದೆ ಇರ್ಬೋದು. Registrar of cooperative society will set up the portal. Each of the cooperative societies, primary, secondary, ಏನೇನಿದೆಯೋ, or whatever data is there, they can upload, which will be taken as a date and time stamp.
Infrastructure ಎಲ್ಲ
Infrastructure, registrar of cooperative societies ಅಲ್ಲಿ ದುಡ್ಡಿದೆ. ಅವ್ರು ಮಾಡ್ತಾರೆ.
ಅವ್ರವ್ರ
ಸೊಸೈಟಿ ಬೇಡ ಪಾಪ.
ಅಲ್ಲ, ಏನಾದ್ರೆ ಗೌರ್ಮೆಂಟ್ ಇಂಟರ್ಫಿಯನ್ಸ್ ಇಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಅಸಿಸ್ಟೆಡ್ ಸೊಸೈಟಿ ಇಲ್ಲ ಅಂತ ಅಂದ್ಬಿಟ್ಟು ಇದ್ ಮಾಡ್ತಾ ಇರ್ತಾರೆ. So government cannot do that. Only the
So in the-
society has to do that.
Government will set up a portal to enable them to upload.
Correct, madam. But to feed the primary society, madam, they should have the facilities. ಈಗ ಹಳ್ಳಿಯಲ್ಲಿ ಹಾಲ್ ಹಾಕೋ ಕಡೆ ಅಲ್ಲಿ ಕಂಪ್ಯೂಟರ್ ಇರಲ್ಲ, ಹೆಂಗ್ ಫೀಡ್ ಮಾಡೋದು ಅದೆಲ್ಲ. ಅದಕ್ಕೆ ಸೊಸೈಟಿ ಅವರೇ ಲೆಟ್ ದೆಮ್ ಟೇಕ್ ಎ ಸ್ಟೆಪ್ಸ್ ದಟ್ ಅದೆಲ್ಲ ಮಾಡೋದಕ್ಕೆ.
Entry ಅವ್ರು ಮಾಡಬೇಕು.
RCS ಮಾಡಕ್ ಬರಲ್ಲ.
RCS will set up the portal. Entry will be done by the society.
ಸೊಸೈಟಿನೇ ಮಾಡಿ.
Entry ಅಲ್ಲಿ ಹೋಗ್ಬಿಟ್ಟು ಸುಮ್ನೆ ಎಂಟ್ರಿ ಮಾಡೋದು. DTP ಸೆಂಟರ್ಗೆ ಹೋದ್ರೆ ಆಯ್ತು, ಅವ್ರ ಹತ್ರ ಕಂಪ್ಯೂಟರ್ ಇಲ್ಲ ಅಂದ್ರೆ.
ಪ್ರಶ್ನೆ ಏನಿಲ್ಲ.
ಬಹಳ ದುಡ್ಡಿದೆ. ಇಲ್ಲ ಇಷ್ಟು ಜಗಳ ಆಡಕ್ ಆಗ್ತಾ ಇಲ್ಲ. If all these data are there, tomorrow verification of the data, well, data ಬಂದ್ರೆ ಆಮೇಲೆ ಇನ್ಯಾರು nobody will raise a issue. ಮಿಲ್ಕ್ ಪ್ರೈಸ್ ಕಮ್ಮಿ ಆಗ್ಬೋದು.
Second, these things are available, they should make use of this. Transparency also comes in.
Comes in.
If my lord, all society have, my lord, system is there, my lord, regarding software is concerned. Let them, my lord, give all suggestion to the register, then we'll consider on that point.
ಅವ್ರೇನು ಕೊಡಲ್ಲ. It is not in their interest to give any suggestion.
Amendment.
ಅವ್ರಿಗೂನು they wanted to be in a gray area.
Amendment.
It would be embarrassing for Mr. Patil also to say something, so ಅದಕ್ಕೆ we are not pushing too much.
ಅಮೆಂಡ್ಮೆಂಟ್ ಆಗೋಗಿದ್ರೆ ಇದೆಲ್ಲ.
ಅಮೆಂಡ್ಮೆಂಟ್ ಏನಾಗತ್ತೋ ನೋಡೋಣ, ಅದುವರೆಗೂ ಇದು ಅಪ್ಲೋಡ್ ಮಾಡಿ.
Even whether amended or not, if this is to be available on the system,
Anybody can access it. Yes, ಇದ್ರಲ್ಲಿ ಏನು?
This expire on 23/3/25. Returning officer na scrutiny ಮಾಡೋದಕ್ಕೆ officer na ಯಾರನ್ನೂ appoint ಮಾಡಿಲ್ಲ.
So you were.
Even if they take up on war footing, they will require minimum
195 days to complete.
Completed. Now, the final list to be published 50 days earlier. ಅಲ್ಲಿ ಆ ಸ್ಟೇಜ್ ಇಂದ ಶುರುವಾಗ್ತದೆ. Rule 13.
ಇನ್ನ ಡ್ರಾಫ್ಟ್ ಇನ್ಎಲಿಜಿಬಲ್ ಲಿಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿಲ್ಲ.
ಲಿಸ್ಟ್ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ, ನಾವು ಸಬ್ಮಿಟ್ ಮಾಡಿದ್ವಿ. ಸ್ಕ್ರೂಟಿನಿ ಮಾಡಿ he should send it to the district selection officer.
So clause 2 ಆಗಿಲ್ಲ.
Clause 2 ಆಗಿದೆ.
In clause 2.
ಅಲ್ಲ D2A ದ ನೋಟಿಸ್ ಎಲ್ಲದೂ ಕಂಪ್ಲೀಟ್ ಆಗಿದೆ.
D2A1 ಆಗಿದೆ. Shall prepare notice in respect to members not attending 3 out of 5 and not utilizing so and so in with so and so list ಆಗಿದೆ.
ಹೌದು, ಈಗ ಸಬ್ ರೂಲ್ 3 ದ ಸ್ಟೆಪ್ಸ್ ಅನ್ನ ತಗೊಳ್ಬೇಕು.
2 ನೋಟಿಸ್ ಆಗಿದೆಯಾ?
ಆಗಿದೆ.
3
election officer
is the chief executive shall submit the list of ineligible.
ಸಬ್ ರೂಲ್ 3 ನಮ್ಗೆ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯಾವುದು ಬಂದಿಲ್ಲ ಅಂತ ಇದನ್ನು ಆಗಿದೆ.
Learned AGA accepts notice for respond number 1, 2, 4,
please
5, 6 ನೀವೇನಾ?
lord, please
Scrutiny officer.
please
6. TL Kiran Kumar for 3. Issue emergent notice to respond number 7 returnable by 14th. Counsel. ಅದು ಹೇಳ್ತದೆ. Counsel for the petitioner is permitted to take out hand summons on respond number 7. The grievance of the petitioner in the present matter is that though the procedure and sub-rule 1 and sub-rule Roman 1, subclause Roman 1 and subclause Roman 2 of Rule 2 capital A of sub-rule 2 capital A of Rule 13 capital D of the Karnataka Cooperative Societies Rules 1960 have been completed. The procedure from subclause 3 thereof has not been carried out.
ನಾವು ಮಾಡಿದ್ದೀವಿ, 4 ನಿಂದ ನಡೀಬೇಕು.
Chief Executive shall submit a list.
ಇಲ್ಲಿ ಈ ಕೇಸ್ನಲ್ಲಿ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಯಾವುದು ಬಂದಿಲ್ಲ, ಅದನ್ನು ಇಂಟಿಮೇಟ್ ಮಾಡಿ.
Then 4 ಆಗಿದೆ ಹಾಗಾದ್ರೆ 3 ಆಗಿದ್ರೆ.
Formally, he will have to approve it on verification of our records.
Sub-rule 1, 2, 3 of 2A has been completed. The procedure from sub-rule 4 has not been taken up. Learned AGA seeks for and is granted a week's time to obtain instruction and make a submission as regards the status thereof. Learned AGA is also directed to obtain instruction, make a submission as to whether there is any portal or any information technology infrastructure which has been created or proposed to be created for the purpose of automating the procedures which have to be followed under Rule 13 capital D. Inasmuch as in most of the cases coming up before this court in relation thereto, the allegations made are as regards discrepancies. Since the data is tabulated at the time of elections once in 5 years and not on a regular basis, it would be advisable for the Registrar Corporate Society to set up a portal where all the cooperative societies could upload the data relating to each and every aspect of the member, commencing from the date of membership, payment of membership fees, availing of services, the date and time of availing services, the extent of services availed, the nature of services availed, default, if any, in repaying of the loan if it's a credit cooperative society, and the like. The Registrar of Corporate Societies could also expand the above data points on the basis of the requirements of the Act. An affidavit in that regard to be filed by 14th March, relist on 14th March.
Copy my lord uploaded. Copy of
ಎಲ್ಲ ಕಾಪಿ ಅಪ್ಲೋಡ್ ಆಗುತ್ತೆ, ಯಾವ್ದು ಅಪ್ಲೋಡ್ ಆಗಲ್ಲ? It said act on uploaded copy.
Scrutiny officer appoint again. Our scrutiny information is also subject. But
So 13B 4 ಆಗಿದೆ. Learned AGA accepts notice for respond number 1, 2, 4, 5, 6. TL Kiran Kumar for 2. Issue emergent notice to respond number 7, written out by 14th. Petitioner is permitted to take out hand summons on respond number 7. Adರಲ್ಲಿ clause 1, 2, 3 ಅಂತ ಹೇಳಿದ್ವಲ್ಲ, 1, 2, 3, 4 has been 5 has been complied with. 5 ನು ಬರುತ್ತೆ. Learned AGA seeks for. ಅದೆಲ್ಲ ಡೀಟೇಲ್ಸ್ ಕೊಡಕ್ ಆಗತ್ತೆ. We have only 3 days, 10, 11, 12, 13th is holiday, 14th. 14th is earliest. Then we'll extend. No, we'll extend it because the delay is on their part. We'll just get their information.
Please.
36, Satish Aditya.
Yes. Connected matters file ಆಗಿದೆಯಾ? ನಂಬರ್ ಅದೇ ಆರ್ಡರ್ ಆಗಿದೆಯಾ ಅದರಲ್ಲಿ ಇಲ್ವಾ? Number ಕೊಡಿ, connect with so and so. ಇದು 34 and 35 connect to each other and connect to so and so.
Charge the election notification.
Voting rights, ಅಷ್ಟೇ ಹೇಳಿ. And AGA accepts notice for respond number 1 and 4. TL Kiran Kumar for respond number 2. Issue emergent notice to respond number 3, written out by 3rd April. Counsel for the petitioner is also permitted to take out hand summons on respond number 3. Voting rights. Allowed. Granted. And summons and delivery order.
For reporting settlement, serial number 37, Kashinath Reddy.
Agilva. Mr. Chetan Kumar. Counsel for the petitioner submits that the settlement talks have failed. Relist on. Yadam failed. Relist on 20th, interim order earlier granted is extended. Already. Matine nilwala. What is there in this? Relist on 20th, interim order.
Lord, on submission, earlier matter, my lord, petitioners challenging the notification of the calendar of events, my lord. Now sought for, my lord, to cast the vote, my lord. Let them first, prayer cannot be pressed.
Kodiyadu. 37.
36, my lord, 36.
The third counsel for the petitioner has filed a memo that he would not press prayer 1. Mr. Satisha, file a memo. Accepting this said memo, prayer number 1 is deleted from the prayer column.
Final disposal, serial number 38, Sarvana S.
For the petitioner. The order was directing inquiry.
Hmm.
With respect to the board of members not doing the management of the year 2014 to 17.
Hmm.
But lordships therefore they could not order, they take 3/2024.
3/12/24. Yes.
I had undertaken us to produce a comparative chart because
Hmm.
there are 4 inquiries. With respect of
For all the
charges.
inquiries conducted. ಇವತ್ತು ಕೊಡ್ತಾ ಇದ್ದೀರಾ?
Now I
Counsel for the petitioner has filed a memo. Memo ilwalla. They have filed a comparative statement in terms of para 3 of the order date 3/12/2024. The same is taken on record.
let them ascertain.
Prakash. Copy thereof is directed to be served to the councils for the respondents. Relist on 20th.
39,
None appears for the respondents. Copy thereof is directed.
VP Kulkarni.
Happy for you.
Mr. Shetty. Yes, ready? ಅವರೆಲ್ಲ ಹೋಗ್ತಾರೆ.
Joint register of corporate society.
Hmm.
Thanks to hold an inquiry under section 64.
Hmm.
2 more charges.
42 charges.
Right.
Huh.
Then my lord, the holding inquiry himself, he
Hmm.
delegates the power
Hmm.
to the deputy registrar. Then my lord, the deputy registrar now submits a report after conducting an inquiry. And the inquiry report is submitted to the joint registrar.
Hmm.
Now the joint registrar, my lord, they rejects the the inquiry report submitted by the deputy registrar
Hmm.
and decides to hold an inquiry on 28th now. My humble submission, it is wholly lawful because joint registrar himself is an inquirer.
Hmm.
He has delegated to the deputy registrar. Once it is not listen, the inquiry himself, officer himself cannot want the reject the minority inquiry. All minority. Section 64.
It provides for the registrar may of his own motion by himself or by a person authorized by him.
In this case, he has authorized the deputy registrar to hold an inquiry.
Yes.
Deputy registrar conducts the inquiry, submits a report.
But if he's authorized somebody to hold it, and if he's not happy with the manner in which it's been conducted,
Because himself is an inquiry officer. Under the act, there must be some power to given to him to either to accept the inquiry or reject the inquiry. In this case, joint registrar himself is an inquiry officer. Instead of holding an inquiry himself, he delegates the power of holding an inquiry to the to the deputies.
yes, Mr. Naik. If it is held by the joint registrar himself, then he would not reject his own report. But if his delegate were to hold it,
Authorized to another
that
person.
delegate will substitute the joint registrar is Mr. Kulkarni's submission.
Definition of registrar. Definition of registrar includes the registrar several.
That may be so. But if it's been delegated, with whether you would substitute or it is reporting to the joint registrar.
He himself is an inquiry.
Yes,
Suppose instead of holding an inquiry himself, he can delegate the power to deputy.
yes.
So virtually he is an inquiry officer.
You are a counsel, you have asked your junior to appear. When junior is appearing in the matter, you don't feel that it has been argued properly, so you may step in.
That is the difference.
I think, yeah.
Not that is-
What is it, Anta? Does he substitute as one, if he is delegated, if the deputy registrar was the delegate of the joint registrar, once it's delegated, would he substitute the joint registrar, setting in motion whatever happens subsequently? Or is it on a basis of a reportage by the deputy registrar to give it to the joint registrar, and joint registrar can either accept or reject that?
There is no such thing regarding accepting or rejecting.
There's nothing either ways that ನೀವ್ ಹೇಳಿದ್ದು ಇಲ್ಲ.
He cannot exercise the power.
The section 64 also does not provide expressly as what you are contending, Mr. Kulkarni. So we'll have to interpret it.
He is an inquiry officer. He delegates to the.
It doesn't say that. The registrar may of his own motion by himself or by a person authorized by him by order in writing hold an inquiry into any matter specified. Ashte
Delegate the power.
shall be completed within so and so, however be extended by registrar for reasons to be recorded, provided state government shall on a report made by registrar have the power to further extend. Registrar or the person authorized by him under shall for the purpose of inquiry have the following powers. Ashte
Lords.
doesn't say that it will substitute.
64(5), my lord.
Hmm.
If result of inquiry held, subsection 1 discloses any defects of.
Well, that is different. That is,
That
that
directly
is
we
if the report is accepted.
Please, please.
Illy, the situation is registrar gave it to the deputy registrar gave a report.
Report, my lord.
It is not acceptable to the registrar. So now he is holding another
Inquiry.
inquiry.
He has appointed another inquiry officer, not he has stated in his order that several charges has not been dealt by the. And
So does he have the power to do it? And
yes, that is the question.
is there any decision on this or we'll have to deal with it? If there's a decision, we are bound by it. Otherwise, we'll have to interpret it.
Yes.
State.
29C.
States may not receive under 29C.
29C.
29C, my lord, it's not 64.
May not they- This is the case. I will read from paragraph 3 onwards.
Yes.
In a reply to the argument, it was contended on behalf of respondent, the power of the register of corporate society in 29C has been delegated to the director of sugar, who is designated as the additional registrar of the cooperative society. Therefore, additional registrar exercise power under register, and as such an appeal filed before the government as against the order of the additional registrar of cooperative society was maintainable. In notification number so and so, under the exercise of power conferred on the section to Karnataka government, hereby confers the power to cooperative society and the Karnataka cooperative society, director of sugar, additional cooperative society, so and so. The word register has been defined under section T1 Registrar means person appointed to perform the functions of a registrar, cooperative society under this act. And include the additional registrar, cooperative society, joint registrar of cooperative society, deputy registrar of cooperative society, assistant registrar of cooperative society, appointed as assistant exercising all the powers of the registrar. Thus it is clear, definition of word of registrar includes all other authorities mentioned appointed as assistant registrar in exercising all the powers of the registrar. Section 2E of the act provided that the state government may appoint a person. Register of cooperative society also to appoint officer, including additional register of cooperative society purpose of assisting. Specifically provided that officer person employed in the administration of the act shall be subject to strict direction of control of the state, and register of the officers whom the under this act shall be subordinated to the government. Provision of subsection 4, section 3 of the provides the power of the state government and the registrar. The state section shall not be exercisable and so as to interfere in the decision of authority, except quasi judicial functions, whether original or third authority. Subsection 5 of the 2A of the act controls the state government to confer any person appointed the additional registrar, joint registrar, deputy registrar, assistant registrar, or any powers of the registrar. It is the exercise of power of the registrar respecting the act has been conferred to the additional registrar by notification above. Therefore, it is clear notification of the dated relied upon by learned counsel but cannot be held. By the reason of notification itself, additional cannot be exercised the power of the registrar. By the act, specifically power upon the additional registrar state government of the notification. Similar definition of the word registrar provided in section 2 also cannot be held for the definition. In so the definition only provides the register includes the additional registrar exercise all the power. It also clear from the reason and definition alone. Registrar cannot exercise the power of the registrar. The powers of registrar and have to particularly confer upon that. Such a conference power, the registrar can decide. So and so. Thus, of the delegation.
Delegation.
The power exercised by the registrar was that of the register of the cooperative society as a delegate. Therefore, appeal to the state government, having a state order was competent. Of the section so and so.
Is there any decision on 64, Mr. Kulkarni? This is a different delegation.
The delegation of the joint registrar instead of holding an inquiry, he delegates the power to the registrar. That is the one not. Instead of holding an inquiry.
Is there a decision on section 64 or only 29C you are relying upon?
The person who delegates the power.
Adartha itu 64 alilla. Yes or no, everybody. Then we'll deal with it. See, if there's a judgment, we'll be bound by it. It should not become a per incurium judgment. We'll accept it. Because it should not be something, it seems to be too basic for it not to have been dealt with earlier. He's only asking for an inquiry and it is up to him to accept the inquiry report or not.
He goes on further step. He said he rejects them on the inquiry report. There must be specific power under the act or under the rules to exercise that power. Because he himself is an inquiry officer. He cannot reject them and not the inquiry report submitted by the another inquiry officer.
That we won't agree with you unless there's a decision to the contrary. This is an inquiry which is being given by to a deputy registrar. Deputy registrar, if he does not hold it properly, then it won't substitute the wisdom of the joint registrar.
He is the one for all, legally, my lord, for all the purpose, he is the registrar.
Yaro.
The person who has power has been delegated. In all the legal sense, he is the registrar.
He has the powers, yes. But if you say that the joint registrar cannot reject it, if the delegatee has not done the work properly, then to say that no, the joint registrar has no power to reject it, we don't want to place it at such a high bar.
Inquiry officer cannot accept or reject the matter unless the power says, under the rules or does not say either accepting or rejecting. That is under still.
Please verify if there's any decision on 64. Otherwise, we are not very much in favor of that argument. 64 alidre, we'll accept it. If there's a judgment, we are bound by it, except Allah, we are bound by it. Both the councils seek for and are granted 2 weeks' time to verify if there's any decision rendered under section 64 as regards the delegation of powers of the joint registrar to a deputy registrar and the power of the joint registrar to reject an inquiry conducted by a deputy registrar on such nomination. Relist on 20th. 20th. 20.
Serial number 40. Akshita DJ.
11. 2011.
Re-auditing.
Oh, either 10, 12 ಬಂದಿದೆ.
Re-audit.
So ಇವತ್ತು election matters ಮುಗ್ಸೋಣ ಅಂತೀರಾ? Let us do that. We'll take this, otherwise this will take some time either.
What is
This? A re-verification of the audit was ordered.
ಎಷ್ಟೊತ್ತಾಗ್ಬೋದು ಇದು?
Actual matrix in the ತಂದು ಎಲ್ಲದು ಮಾಡೋದ್ರೊಳಗೇನೆ 1 hour ಆಗಿದೆ.
1 hour. ನಿಮ್ಗೆ ಈ ಕಡೆ
on submission, my lord, pertaining to the my lord division bench, the order is there, my lord, to pertaining to the re-audit.
ನಿಮ್ ಪ್ರಕಾರ 5 ನಿಮಿಷ
ಆ ಸ್ಟೇಜ್ ಮುಗಿದಿದೆ.
ಮುಗಿದಿದೆಯಾ?
Challenge ಮಾಡಿದೆ.
We'll have it on 20th. We'll finish the election matters today.
Please.
20th we'll take it up. The other matters which are being taken up today, relist on 20th. It's made clear that no further adjournment would be granted on that date. All the councils are directed to get ready to address their arguments. Amendment. ಯಾವ್ದ್ರಲ್ಲಿ? ಏನಪ್ಪ?
Respond. That is facts they are bringing
Will allow.
further. Please,
40.4.
if there is any objections, further objections to that, my lord.
IA 1025 has been filed for amendment to the petition to bring on record certain factual aspects. There being no particular objection on behalf of respondent number 1, the said application is allowed. Counsel for the petitioner is permitted to carry out necessary amendment and file amended petition. ಮಾಡಿದೀರಾ? ಫೈಲ್ ಇಟ್, ಅದೇ ಹೇಳ್ತಾ ಇರೋದು. Amended petition. You will have to, you know how to do it, ... Amended petition which shall be filed on or before 12th March 2025, failing which the benefit of the amendment will stand rescinded. Additional objections, if any, to be filed on or before 17th March 2025 after serving a copy thereof on the counsel for the petitioner, relist on 20th.
Serial number 42.
Serial number 60. 60 ಅದರ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ರ ಪೆಟಿಷನರ್ಗೆ? ಹೇಮಂತ್ ರಾಜ್ ಇದು 60. ರವಿಶಂಕರ್ಗೆ ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ? The request of counsel for the petition relist on 21st.
Serial number 42.
ಏನಮ್ಮ?
For the petitioner in that matter, your lordship.
End of the list. ಕೊಡಿ.
Serial number 40.
68 interim order.
Serial number 40.
71 at the request of counsel for the petitioner relist on 21st.
Serial number 42, my lord. I'm appearing for the point number 4. My lord, learning counsel for the petition is an online, my lord. My lord, Mahesh Chaudhary, my lord, Monday actually, today is the part of the matter, quarter number 3. ಅದು ತುಂಬಾ ಹೊತ್ತು ಹಿಡಿಯುತ್ತೆ.
Yes, madam, 42.
It may be had on Monday, your lordship.
We are not going to have it on Monday. We are going to have it only on 21st.
Please.
At the request of counsel for respondent number 4, relist on 21st.
Please.
Grateful, your lordship.
The one also interim order.
My lords, may I make a submission? Serial number 56, my lords.
ಹೇಳಿ.
After 21st, my lords.
ನೀವು ಯಾರಿಗೆ?
I represent petitioner, my lords.
56 at the request of counsel for the petitioner relist on 27th March.
Grateful.
ರೀಚ್ ಆಗದಿರೋ ಮ್ಯಾಟ್ರ್ ಡೇಟ್ ಏನಾದ್ರು ಕೊಟ್ಬಿಡ್ತೀರಾ ಆಮೇಲೆ?
ಇಲ್ಲ ಇಲ್ಲ ಬರ್ತಾರೆ.
ಅಲ್ಲ ರೀಚ್ ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಲಾಸ್ಟ್
ಆಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಸರಿ ಕೊಡ್ತಾರೆ ಅಲ್ಲ.
ಡೇಟ್ ಹೇಳ್ತಾರ.
ಅವ್ರೇ ಹೇಳ್ತಾರೆ.
ಯಾಕಂದ್ರೆ ಈಗಲೇ ಟೈಮ್ ತಗೊಂಡ್ಬಿಡೋದ ಅದೇನೋ ರೀಚ್ ಆಗೋ ತರ
ಬೇಕು ಅಂದ್ರೆ ಈಗ್ಲೇ ಕೇಳ್ತೀವಿ ಅಷ್ಟೇ, ಕಾಯ್ಕಾಗಲ್ಲ ಅಂತ ಕೇಳಿ.
ವೇಟ್ ಮಾಡೋ ಬದಲು.
ಫಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಅದಾದ್ಮೇಲೆ ಫಾಸ್ಟ್ ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ.
ನಮ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 69.
ಹಾ ಸರ್.
ಲಿಸ್ಟ್ ಕಂಟಿನ್ಯೂ ಆಗುತ್ತಾ?
ಇಲ್ಲ
Continue ಇಲ್ಲ.
ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಫಸ್ಟ್. ಹಾ ಎಷ್ಟಿದೆ? 4
ಎಷ್ಟೊತ್ತು ನಡೀತೋ ಅದು ಹೇಳು.
ಇಲ್ಲ ಅದು ಯಾರು ಟೈಪ್
Further arguments, further hearings.
ಆಗ್ತಾವಲ್ವಾ, ಯಾರಿದಾರೋ ಇಲ್ವೋ ಗೊತ್ತಿಲ್ಲ.
ಹಾಗಾದ್ರೆ 69 ಒಂದು ಡೇಟ್ ಕೇಳ್ಬಿಡ್ತೀನಿ ನೋಡಿ.
ಕೇಳಿ
ನಮಗೆ ಅರ್ಜೆಂಟ್ ಇದ್ದಿದ್ದು, ಬಟ್ ಇವತ್ತು ನೋಡಿದ್ರೆ ಪರಿಸ್ಥಿತಿ ಬೇರೆ.
ಕೇಳಿ ಟೈಮ್ ಬೇಕಾದ್ರೆ ಕೇಳಿ.
ಬೇರೆ ದಿವಸ ಬೆಳಗ್ಗೆನೆ ರೀಚ್ ಆಗೋದು.
ಅಲ್ಲಿ ಹೋಗ್ಬೇಡಿ ಏನೋ. ಸೆಕೆಂಡ್ ಲಿಸ್ಟ್ ಆದ್ಮೇಲೆ.
ಐಟಮ್ ನಂಬರ್ 69.
69.
And next or 18th or 21st, any other day. Either 18th.
ಇನ್ಫಾರ್ಮ್ ಮಾಡಿದ್ದೀರಾ?
ಅವ್ರಿಗೆ ಮಾರ್ನಿಂಗ್ ಸಿಗ್ಲಿಲ್ಲ.
ಸಿಗ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಮೂವ್ ಮಾಡಬೇಡಿ.
ಇರ್ಲಿ,
ಮೂವ್ ಮಾಡಬೇಡಿ. ಎಸ್. ಹಾ. For this one, at the request of council for respond number 1 to 3 released on 20th March.
List number 2. Order serial number 1. Viraya.
You are appearing for 6 and 8, Mr. Kumar.
And
What about 7?
7, my lord, I have no instructions.
You appeared for respond number 7.
I did appear before the trial court, secure instructions.
Now with the amendment, whoever has appeared has to appear
Sorry, my lord, I'll appear.
for 2 years thereafter.
File my objections to those interlocutory applications.
Put you a copy.
Served yesterday.
And council for respondent 6 and 8. 6 for a week's time to ascertain if he's going to appear for respond number 7 also. Objections to IA?
1 and 2.
And 2 of 2025 have been filed by council for respond number 6 and 8. The same is taken on record. It having been served on the council for the petitioner. Mr. Raghavan, appellant, Mr. Raghavendra Gayatri, who is the contesting respondent?
I am the contestant.
You are the contesting.
I'm a
Mr.
purchaser. I am in possession of the property.
Yes. An application for injunction, na? Injunction and stay. Hmm. Suit for? Suit? Hmm. ಏನಾಯ್ತು suit ಅಲ್ಲಿ? Dismissed. Hmm. Completely. On what ground?
Property of different number 1.
Hmm.
Therefore, plaintiff has no right to challenge.
Hmm.
In fact, these aviators or transfer is pendentally.
ಆಯ್ತು.
And I heard this for
Pendentality.
pendentally.
Okay.
Transfer
Hmm.
is pendentally.
Hmm.
In fact, this property method was purchased by my father, one Gattamuliyappa, in the name of different number 1 is vide. After his death, when she tried to divest a portion of land to the extent of 10 guntas in favor of her daughter, different number 6, the plaintiff resisted. Claiming that it is a joint family property that should not be divested. Ultimately culminated in filing of suit against mother and brother. What happened was, they did not contest the suit. In the meanwhile, this defendant number 1, my mother, approaches one M. Revanna, who was a local Gram Panchayat chairman during the relevant period, seeking his help to get a sale deed executed in favor of her daughter, because she was illiterate, rustic village woman. This M. Revanna, in collusion with defendant number 7, who was doing real estate business in the locality, and with the help of his own brother, I mean defendant number 7's brother, who incidentally happened to be an advocate, TW1, clandestinely created this exhibit D4 sale deed under the pretext of getting executed exhibit D28 sale deed in the name of defendant number 6. Exhibit D28 sale deed, which is in Kannada language, which has been executed weeks later.
Did defendant number 1 file a written statement during her lifetime?
Yes.
This written statement, with great respect to my lord, was prepared by this DW1 only.
Mr. Counsel, it is a property bought in the name of the mother.
Correct.
The question of you contending joint family property would not arise, cannot be done, because section 14 is very clear. So when section 14 ಇದೆ ಅಂದ್ರೆ ನೀವು joint family property ಅದು ಇದು ಅಂತ ಏನು ಹೇಳಕ್ಕಾಗಲ್ಲ.
She has not had state.
We'll consider it, but on the face of it, for you to make out a prima facie case for an injunction, the property stands in the mother's name. You will have to now be able to convince us later that it is a joint family property which is contrary to the statute. It's not going to be possible. Settlement ಏನಾರು ಮಾಡ್ಕೊಂಡಂಗಿದ್ರೆ ಮಾಡ್ಕೊಳ್ಳಿ, ಇಲ್ಲಾಂದ್ರೆ ನಿಮ್ದೇನು ಇಲ್ಲ.
May I make a submission?
Yes.
Kindly turn to
Just a moment. Yes.
page 30, para 34, my lord, page 69 of the judgment. But the plaintiff is a beneficiary of a portion of the.
That is all, that will come to later. Now, if it's section 14, injunction ಅಂತೂ ಇಲ್ಲ.
Submission for case. During the pendency of the suit, defendant number 7 entered into an agreement of state.
First, tell us how you are entitled to, that is subsequently. When it is purchased in the name of the mother, in what, 14 ಓದಿ? ಓದಿದ್ದೀರಾ? ಓದಿ. ಆಕ್ಟ್ ತಂದಿಲ್ವಾ? ಆಕ್ಟ್ ಕೊಡಿ, ಹಿಂದೂ ಸಕ್ಸೆಷನ್.
In 2024, my lord, the judgment of the Supreme Court. Para 24.
ಯಾವ್ದು ಕೊಟ್ಟಿದ್ದೀರಾ?
Indian particular.
ಹಿಂದೂ ಸಕ್ಸೆಷನ್.
ಅದೇ ಫಸ್ಟ್.
ಆ ಬುಕ್ ಅಲ್ಲೇ ಇದೆ ರೀ, ತೆಗೆದು ನೋಡ್ರಿ.
ಫಸ್ಟ್
ಏನಪ್ಪ ಹಿಂಗ್ ಮಾಡಿದ್ರೆ ನೀವು?
property of the female member to be her absolute property. Any property possessed by a female Hindu, whether acquired before or after the commencement of the act, can be held by her as full owner thereof and not the limited owner. Explanation. In this subsection, property includes both movable and immovable property acquired by a female Hindu by inheritance or device or at a partition or in lieu of maintenance or arrears of maintenance or by gift from any person, whether a relative or not, before or at or after the marriage, or by her own skill or exertion, or by purchase or by prescription, or in any other manner whatsoever.
Or in any other manner whatsoever. Mugitu, any other, this one. You can't claim it to be joint family property. You can only claim inheritance.
Serious dispute. Collusion is there. TW1 is none other than, being an advocate, none other than the brother.
That is all as regard the sale. Not your entitlement as joint family as partition.
This representation has been played on, defendant number 1 is my respectful submission.
We'll consider it. We'll consider it. File the paper book.
Appeal is continuation of suit, my lord. During the pendency of the suit, with great respect, my lord, I say, appellant was enjoying an order of injunction from the honorable trial.
It was an order of injunction.
Yes.
When was it granted?
This was granted. My lord, I have produced order copy also.
Page number?
And it has been confirmed by the.
Page number?
Lord, can I proceed, my lord's kind attention to IA number 1, my lord. I have produced MFA order also.
Page number Eldri.
150.
It's true.
In fact, which has been confirmed by this honorable court in MFA.
And it was not confirmed. That order was rejected. Thereafter, this court has granted.
I'm producing law.
Where is the order of injunction?
Injunction order was granted by the honorable trial court on 25th March.
Where is the order of injunction? Copy ಎಲ್ಲಿ ತೋರಿಸಿ.
ಅಲ್ಲೂ produce ಮಾಡಿದ್ದೀನಿ.
ಪೇಜ್ ನಂಬರ್ ಹೇಳಿ, ಆವಾಗಲಿಂದ 3 ಸತಿ ಕೇಳಿ ಆಯ್ತು.
56.
156 is an affidavit.
I have produced along with IA number 1.
ಇಲ್ಲಪ್ಪ ಇಲ್ಲ. There is no order. ಕೊಡಿ. You are not produced. This is the MFA.
Yes, sir.
We are asking where is the trial court order of injunction? Is it confirmed the order? By only defendant number 7, respondent number 7 had filed it. You had appeared for him.
Had appeared for him. The order is tried not to alienate the property. On that date, that was the order. But that was before a judgment could come.
That is
Now
true.
that there is a judgment which has
Now
come.
that we are considering it, the interim order will extend it for consideration.
The only thing is this, Lord. He is also a beneficiary of a portion of property.
We'll consider all of it, Ms. Shivakumar.
And,
Right now, we'll get the records and then consider it.
kindly just for my sake.
We are only on the, we are not deciding the appeal today.
But I am not. Kindly see my application where photographs are not. I have developed the property also.
You have been permitted to construct, IA1 has been dismissed.
Yes,
That is
I
why we asked for
construct-
the trial court order because the appellate court order was not clear.
I have developed it
You
also.
are developed, you are,
Crores of rupees I have invested also.
you are entitled to use it. It is subject to the suit. You won't be able to claim equities. You have been permitted to go on with the construction. All that is fine.
Yes,
All that will be decided.
Question of
Won't
alienation.
alienate it, that's all.
Alienation, my lord, large extent of the property. If I don't alienate, probably, my lords are aware that the investment and the loans that are drawn that may.
We'll have to consider the appeal now. Now that there's been an injunction from the beginning,
But I'm ready, my lord, even anytime.
let us call for the records.
Yes.
One of, orders on IA 1 of 25.
The stay may not arise, my lord, because that is inconsequential. I don't know why he filed a stay.
Stay is not required. Orders on IA 1 of 25. Considering that there's a interim injunction granted by a trial court on 25th March 2023 in OS number 6922 of 2020, which has been confirmed by order dated 30th May 2023 in MFA number 2609 of 2023, restraining the defendant number 7 and 8 from alienating or creating any encumbrance in respect of the suit property. The benefit of the said order would have to be extended pending consideration of the above appeal. Hence, respond by allowing IA 1 of 2025, respond number 7 and 8. Respond number 7 and 8, defend number 7 and 8 arrow. We can't extend it to beyond that. Don't try doing all these things, Mr. Counsel. Don't try these smart things, please. Your submission is different, your prayer is different. Don't do these things. Respond number 6 and 7 are restrained from any manner alienating the property.
6 minute, there was, she is the daughter of Narayanam.
6 is R. Uma Prasad, defend number 7.
Yes,
SG Shashikala is defend number 8. So the injunction order was as regards defend number 7 and 8.
yes,
So against Uma Prasad and Shashikala.
please.
Respond number 6 and 7 herein, who are defend number 7 and 8 before the trial court, are restrained from any manner alienating the suit scheduled property or any part thereof till the next date of hearing, till disposal of the above appeal. Registry is directed to secure the trial court records. Bandidya?
Bandide.
The trial court records having been secured. When will you get ready?
Any day, even tomorrow, day after, any day.
Or urgent? When will you get ready? ನೀವು ಇಬ್ರು ಮಾತಾಡಿ ಟ್ರೈ ಮಾಡಿ ರೆಸಲ್ಯೂಷನ್ಗೆ. You may end up losing everything. Section 14 will apply from what you are saying. ನೀವು ಶುರು ಮಾಡಕ್ ಮುಂಚೆ ಮಾತಾಡಿದ್ರೆ ಮಿಸ್ಟರ್ ಶಿವಕುಮಾರ್ ಮೇ ಬಿ ಅಗ್ರಿಯಬಲ್. ಶುರು ಮಾಡಿದ್ಮೇಲೆ ಈ ಮೇ ನಾಟ್ ಬಿ ಅಗ್ರಿಯಬಲ್. Relist on 25th March.
Please.
ಅಷ್ಟರೊಳಗೆ ಏನ್ ಮಾಡ್ತೀರೋ ನೋಡಿ.
Serial number 2. Punit Kumar.
I'm filing a memo, my lordship. It contains the letter issued by BBMP and the reply given by the government.
ಎಲ್ಲ ಆಡ್ ಆಗಿದೆಯಾ?
And it is, they have given us the amendment to 2024. There is an amendment which is proposed, Karnataka Birth and Death Registration Act. Starting page number 1 and 2 is the
Amendment. Yes.
The reply given by the government is under consideration by the special commissioner. So once whatever he says, the reply given by the government is still to be considered by the special
to be
commissioner IT.
But what is this amendment?
Amendment is, my lordship, they have given a provision for appeal under 16A. And apart from that, the Aadhaar card requirement is also Aadhaar. We have said that Aadhaar card number and name should be incorporated as mandatory. Regarding that, we have suggested them. So that they have given a reply that there is an amendment which is proposed.
What are the requirements that you want to be incorporated in the eJanma portal?
As far as that Aadhaar card mandatory, my lordship.
Ashtena?
That name and everything will be there, the Aadhaar card. So whatever name will be the Aadhaar card, the same will be reflected in death certificate. So there will be chances of.
No, you are empaneled on the Aadhaar services as a services entity.
That both has to be connected, my lords. That are,
New BBMP, is it now on the empaneled as a services authority?
no, I don't believe so. I don't think so.
But then only it will make sense, otherwise it won't make any sense.
Because it has to be incorporated by the government only, but whatever
You
suggestion
have to register yourself as service agency, service provider.
provided. With regard to that, because that is what it is under consideration by the special commissioner.
What is so considered to be considered?
Whatever instructions he gave, the officers will act on that. That is what I have been told. The reply is not being seen by the, frankly speaking, the
Ashte.
replies.
We can't record this, it will be way, then we'll have to deal with it. The counsel for respondent number 22464 is granted a week's time
2
to make
weeks.
his
my lord.
submission as regards the registration of the BBMP as a service provider under the Aadhaar so-and-so service providing act at the there. Released on
2 weeks.
21st March.
Okay.
Serial number 3. C.D. Subramania.
Affidavit file madadra?
This case appearing for respondent number 5, my lordship.
Affidavits of the petitioners have been filed. Petitioners are before this court seeking for the following leaves. Affidavits, individual affidavits of each of the petitioners have been filed, which reads as under. Learned counsel for the petitioner submits that in terms of the said affidavit and the memo filed yesterday, the petitioner may be permitted to withdraw the above petition. Accepting the affidavit, memo for withdrawal, and the submission made by the counsel for the petitioner, petition is dismissed as withdrawal.
Further arguments, serial number 4. Chandan K. Connected matter.
Mr. Rohn, and now we can take up for argument and finish it.
Concern about one, the lordship raised a concern that the answer declared as for a
That was because Mr. Rohn asked, because the time was constrained. Since we are sitting in there, now that we are here, we can take it up and finish it.
But Lord, let them not interfere with the construction. That is my.
Where is Mr. Rohn?
He is in Lex, my lord, and Kotal 4, my lord.
ಎಷ್ಟೊತ್ತಾಗತ್ತಂತೆ ಇದರ argument?
My lord, have it on my lord, 4 o'clock, my lord. I will let them.
Okay, pass over, we'll fix a date today.
Yes, please.
Further hearing, serial number 5.
Pass over.
My
We'll
lord,
see.
K.V. Narasimhan.
my lord,
Yes,
I appear for the respondents 1 to 5 in this, my lord.
ಏನಾಯ್ತು Mr. Reddy?
My lord, on the last occasion, if your lordships may kindly recollect, on a couple of occasions earlier, my lord, your lordships had directed me to produce
For
a comparative.
CCMS.
Yes. The CMS as developed by the BBMP vis-a-vis the CCMS as developed by the government, my lord.
ಅದು ಇನ್ನೂ ಒಂದು ಮ್ಯಾಟರ್ ಹಾಕಿದ್ದಾರೆ, ದೇ ಆರ್ ಎಕ್ಸ್ಪ್ಲೋರಿಂಗ್ ದಟ್ ಅಂಡ್ 2 weeks ಅಲ್ಲಿ ಮಾಡ್ತೀವಿ ಅಂತ ಹೇಳಿದ್ದಾರೆ. ಪ್ರಾಬ್ಲಿ ದಿಸ್ ವಿಲ್ ನೌ ನಾಟ್ ಸರ್ವೈವ್ ಫಾರ್ ಕನ್ಸಿಡರೇಷನ್.
Very well, my lord.
So the only thing is on merits, we'll have to dispose the matter.
Very well, my lord. If that being the situation, my lord, it may be posted in the usual course, my lord.
None appears for the petitioner and or the contesting respondents to enable them to appear and make the submission released on 19th March.
Obliged, my lord. Obliged.
Past over matters.
Election matters. First one is
List number 1, serial number 1. G. Balakrishna Shastri.
I am for the respondent. To get instruction from the society. It may be taken upon next week, your lordship. I will get instruction, I will make my submission.
And counsel for respondent number 4 seeks fund is granted a week's time to obtain instruction, make his submission. Released on 14th.
Obliged.
Serial number 3. Vijay Kumar.
ಯಾವ್ದ್ಯಾವ್ದು ಎಲೆಕ್ಷನ್ ಇದೆಯೋ? 3. Yes, election matters. Who wants to start?
My lord, may I make one submission with my lord's kind leave?
Yes, Mr. Shetty.
My lord, serial number 10, if my lord could kindly recollect, yesterday, in fact, this matter was passed over in the morning. And thereafter, my lord, in the evening, late evening, it got reached, and a senior advocate, Mr. Rajgopal, sought for today. So the nomination is scheduled to be for tomorrow, my lord, and the elections are to be held on 10.
Come to the election. 10 and 75 ಏನೋ urgency ಅಂತ ಹೇಳಿದ್ರಲ್ಲ, ಅದು ಮುಗಿಸ್ಬಿಟ್ಟು then we'll come to the regular election matters. 10 ತಗೊಳ್ಳಿ.
10, my lord, this is my matter.
Which is your?
Serial number 10.
12. ಇದಾದ್ಮೇಲೆ 12.
Serial number 10, my lord.
Where is Mr. Rajgopal? Yes, Ms. Baswaj.
Total number 18.
My lord, yesterday also the same thing happened, my lord. They requested for passover and the matter did not reach.
ಬೇಗ ಕರ್ಕೊಂಡು ಬನ್ನಿ ಪಾಸ್ ಓವರ್. ಇವಾಗ ಬರ್ಲೇಬೇಕ್ರಿ ಅದು ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಗೆ ಅವ್ರು ಎಲ್ಲೂ ಹೋಗಲ್ಲ. ಬಂದಾಗ ಅದು ಫಸ್ಟ್ ನಿಮ್ಮ ಮ್ಯಾಟ್ರೇ ತಗೊಳ್ಳೋಣ. ಆಯ್ತು.
Please, my lord. Grateful.
Serial number
12.
Suyog Erne.
Lord, serial number 12 is concerned.
Lord, I'm filing a memo here. Lord, what has happened is, after withdrawal of several candidates have withdrawn their applications in SC, ST and OBC category. So, my lord, ultimately the persons who have remained in the fray were equivalent to the posts, my lord, for which elections has to be made. And in the light, my lord, that there are no candidates, and candidates which have remained in the fray was equivalent to the posts of the committee members. So far as SC, ST and OBC backward classes, the election officer has announced the results, my lord. This is what, my lord, the.
Announce the results.
That is 14B says so, my lord.
ಯಾವಾಗ ಅನೌನ್ಸ್ ಮಾಡಿದ್ರು?
14B, same day, my lord, is required to announce same day. On the date of withdrawal of nominations, my lord, after all nominations are withdrawn, then, my lord, so far as these three categories are concerned, my lord, only so much, my lord, your lordship says, Vitla Grameen Sahakara Bank, Vitla Bantwal ತಾಲೂಕು 9/3/2025 ನಿಗದಿಪಡಿಸಿದ ಆಡಳಿತ ಮಂಡಳಿ ನಿರ್ದೇಶಕರ ಸಾಮಾನ್ಯ ಚುನಾವಣೆಗೆ ಸಾಮಾನ್ಯ ಪರಿಶಿಷ್ಟ ಜಾತಿ ಪರಿಶಿಷ್ಟ ಪಂಗಡ ಹಿಂದುಳಿದ ವರ್ಗ ಎ ಮತ್ತು ಹಿಂದುಳಿದ ವರ್ಗ ಬಿ ಮಹಿಳೆಯರ ಮೀಸಲಿನ ಸ್ಥಾನಗಳಿಗೆ ಸ್ಪರ್ಧಿಸಿದ ಅಭ್ಯರ್ಥಿಗಳಲ್ಲಿ ದಿನಾಂಕ 3/3/2025 ನಾಮಪತ್ರ ವಾಪಸ್ಸಿದ ನಂತರ ಈ ಕೆಳಗೆ ಕಂಡ ಸ್ಥಾನಗಳು ಅವಿರೋಧ ಆಯ್ಕೆಯಾಗಿದ್ದು ಅವುಗಳ ವಿವರ. So far as now, my lord, election is fixed only for.
When was this declared?
My lord, same day, my lord, on
ಏನ್ ಡೇಟ್ ಇಲ್ಲ ಏನಿಲ್ಲ ಇದಕ್ಕೆ?
3/3 ಅವ್ರು
ಇವಾಗಲೇ ಬರ್ಕೊಂಡು ಬಂದಂಗಿದೆ.
ಯಾವ್ದು ಇಲ್ಲ ಸರ್, ಆವಾಗ್ಲೇ ನಿನ್ನ ನೈಟ್ ಕಳಿಸಿದಾರೆ ನಮ್ಗೆ ಅವರು. ಅಲ್ಲ 9th ಡೇಟ್ ಫಿಕ್ಸ್ ಅಷ್ಟೇ.
Submission is, my lord, regarding, my lord, withdrawal is.
ಡೇಟ್ ಆಫ್ withdrawal ಲಾಸ್ಟ್ ಡೇಟ್ ಯಾವತ್ತಿರುತ್ತೆ ಆವತ್ತು ಅವರು ಮಾಡ್ತಾರೆ. withdrawal ಆಗಿ ಫ್ರೇಯಲ್ಲಿ ಎಷ್ಟು ಜನ ಉಳಿತಾರೆ ಅಂತ ಗೊತ್ತಾಗುತ್ತೆ ಅವರಿಗೆ. That day.
My lord, withdrawal is, my lord, not as a proper form, my lord. Kindly see, my lord, page number 21.
So this has been passed on 3/3.
3/3.
ಏನ್ ಡೇಟ್ ಇಲ್ಲ ಇದರಲ್ಲಿ?
ಅದ್ರಲ್ಲಿ ಇಲ್ಲ ಸರ್, ಇವರು ಯಾವ್ದ್ರಲ್ಲೂ ಡೇಟ್ ಕಾಣಲ್ಲ.
ಡೇಟ್ ಇಲ್ಲದೆ ಹೆಂಗ್ ಮಾಡ್ತಾರೆ?
Before that, my lord.
ಎಲ್ಲದರಲ್ಲೂ ಡೇಟ್ ಇಲ್ಲ ಸರ್.
Before that, my lord, kindly see, my lord, page number 21 of the petition.
21. Yes.
Item number 10, my lord. ನಾಮಪತ್ರ ಹಿಂತೆಗೊಳ್ಳುವ ಬಗ್ಗೆ ಅರ್ಜಿ ನಮೂನೆ 15ರಲ್ಲಿ ಲಿಖಿತ ಮೂಲಕ ಖುದ್ದಾಗಿ ರಿಟರ್ನಿಂಗ್ ಅಧಿಕಾರಿಗೆ ನೀಡತಕ್ಕದ್ದು. In respect of, my lord, it is admittedly, my lord, is not given proper form.
You not rejected it, you have accepted it.
But we are not rejected, my lord. We say that, my lord, we are not.
Then you should have rejected form 15 ಪ್ರಕಾರ ಇಲ್ಲ ಅಂತ ರಿಜೆಕ್ಟ್
We
ಮಾಡಬೇಕಾಗಿದೆ.
say that, my lord, that is the reason, my lord, we say that, my lord, at the time of scrutiny, my lord, please.
Mr. Naik, you have accepted this withdrawal. Once you accept his withdrawal, that application is no longer there.
Acceptance, my lord, regarding, my lord, after, my lord, scrutinizing, my lord, we reject it.
ಅದಕ್ಕೆ ನಿಮ್ಗೆ ಆಗ್ಲಿಂದ ಕೇಳ್ತಾ ಇರೋದು ವೆನ್ ವಾಸ್ ಇಟ್ ರಿಜೆಕ್ಟೆಡ್ ಅಂತ.
On, my lord, 2/3/2020.
Overly ಹೇಳಕ್ಕಾಗಲ್ಲ.
At, my lord,
Give us the document.
12:30.
The withdrawal was at 2/3/2025 at 11:09 AM.
Please, my lord. Not, my lord, they
No.
cannot now say.
As
that, my lord,
per-
all the 25 was scrutinized within, my lord's 9 minutes.
As per, my lord, as per the, my lord, my
They may
instruction.
also, my lord, because one of the, lords, one after the other, lord, they are bringing out the new reasons. That is not stated.
Time and date will be
my
mandating in all the matters.
Regarding, my lord, my instructions is, my lord, on 12:30, my lord, they say that, my lord, they will give endorsement regarding after some.
12:30 ಅಂದ್ರೆ after 11:09.
ಇದರಲ್ಲಿ ಹೇಳಿಲ್ಲ regarding, my lord, that has been not mentioned in the our endorsement itself. That's my submission.
But Subramania, all this will be rendered academic in view of announcement of election.
Now, lord, kindly see, in the morning, lords, they could have made this submission. But he doesn't say anything, lord.
He appeared in the morning.
I came late.
Returning officer, lord, will have to say that, lord, they appear for the ban. Lord, returning officer, my lords, has not published, even till today, my lords, there is nothing, my lords, so far as the information of declaring the results.
These are serious allegations. If they are found to be true, we'll have to deal with it. You'll be forcing us to deal with it, actually.
Either it should have been published in the notice board, my lords. Even that is also not, lords,
You produce
Rule
their-
requires so, my lord. Rule 14B requires
produce the original
if it is equivalent, then it should be done then and
And
there.
AGA is directed to secure the original files relating to the elections released on 10th at 2:30 PM, please.
that, there is, lords, then shall not be given effective.
What will be given effective in 2 days, Mr. Subramania?
I think elections ಅಂತಿದೆ. Now they say.
For general category, he is also a candidate.
Lord, is,
His application is accepted in the general category, my lord, not.
General category is withdrawn.
No, not that withdrawal he has not accepted. He has, so he was put in general category. His ballot paper I have produced, my lord. In the list, his name is there in the general category. Chittaranjan.
Chittaranjan
He is
ST.
serial number 3, correct. Chittaranjan. NS. What the returning officer says is, the later one is defective. His application for this backward category is defective. So he has to reject that. Instead of that, he,
ಒಳ್ಳೆ ಕ್ಯಾರೆಟ್ ಇದೆ.
instead of that, he allowed him to contest the general
Lord, he
category.
has signed it. He has mentioned the date and the time. It is his signature. The sole intention, Lord, is that if I am removed, Lord, from the array of, Lord, the contestant, then, Lord, only one person will remain, and that is why, Lord, they want declaring me as elected.
It's up to you what you want to present before the court. Whatever you present, we'll deal with it.
Please.
But if you keep presenting like this, then this only reflects very badly on all of you. If one application is bad because there are two, the same person has proposed two, then both applications should have gone. If we are accepting one application and rejected another application, that was not available for rejection of any other application because there's only one application with only one proposer.
The first one we reject, the second one, my lord,
ನೀವ್
is invalid. That is how.
ನೀವ್ ಯಾರು ರಿಜೆಕ್ಟ್ ಮಾಡಕ್ಕೆ ನಿಮ್ದಲ್ಲ ಅವರು.
ಅಲ್ಲ ಅವರೇ ರಿಟರ್ನಿಂಗ್ ಆಫೀಸರ್.
ನೀವ್ ಯಾಕೆ
ಅವ್ರಿಗೆ ಫೋನ್ ಮಾಡಿ ಕೇಳ್ಕೊಂಡೆ.
why are you taking the why do you want to be in trouble? You can also be in trouble.
They are to conduct the elections. Not we are only the spectators.
ಅವ್ರು ಹೇಳಕ್ಕೆ ಬಿಡ್ತಾ ಇಲ್ಲ ನೀವು.
My lord, my special submission is, my lord, regarding two application, whichever, my lord, earlier, my first regulation, my lord, that isn't considered. Other than, my lord, kindly see, my lord, that is the reason, my lord, I stated in, my lord, they say that, my lord, ನಾವು ತಗೊಳ್ತೇವೆ ಅಂತ ಹೇಳ್ತಾ ಇದ್ದಾರೆ. They are not given, my lord, withdrawal. Kindly see, my lord, annexure D. They very clearly say that. Page number 22, my lord. ಮೇಲೆ ಸಲ್ಲಿಸಿದ ಎರಡು ನಾಮಪತ್ರಗಳ ಎರಡು ನಾಮಪತ್ರವನ್ನು ಪರಿಗಣಿಸಬೇಕಾಗಿ ಹಾಗೂ ಸಾಮಾನ್ಯ ಸದಸ್ಯದ ನಾಮಪತ್ರವನ್ನು ಹಿಂತೆಗೆಯುತ್ತೇನೆ. ಮೈ ಲಾರ್ಡ್, ತಗೊಂಡಿಲ್ಲ ಅಂತ ನಾನು.
ತೋಡ್ತೀನಿ ಅಂದ್ರೆ ಏನ್
ರಿಗಾರ್ಡಿಂಗ್, my lord, they say that, my lord, in respect of that is concerned, my lord, they give proper.
ಹಿಂದೆ ತೆಗೆದುಕೊಂತೀನಿ
ಪಡೆಯುತ್ತೇನೆ
ಅಷ್ಟೇ.
Strict grammar, my lord, he is interpreting. I will withdraw. Kannada. ಶುದ್ಧ ಕನ್ನಡ.
ಗ್ರಾಮರ್ ಕ್ಲಾಸಸ್ ಹೇಳ್ಕೊಡು.
No, my lord, I'm not like that. My lord, say that, my lord,
You look at the new,
please,
look at the contents of the letter and what you have done.
please.
He said 2A OBC consider ಮಾಡಿ ಅಂತ.
ಹೌದು.
ಸಾಮಾನ್ಯ
Application ಅವರು
is not a future
in respect of my lord, application first is respect of the GM category is concerned, my lord, 1245 ಕೊಟ್ಟಿದ್ರು ಅವರು. ಆಮೇಲೆ 2A 253 ಕೊಟ್ರು. First application they given my lord in ಸಾಮಾನ್ಯ.
when ಸಾಮಾನ್ಯ ಅವ್ರು ವಿಡ್ರಾ ಮಾಡಿದ್ದಾರೆ ಅಂದ್ರೆ ಎರಡನ್ನೂ ಕೊಡ್ಕೊಡುದು ನೀವು.
ಅಲ್ಲ, ಎರಡು ಕೊಡಕ್ ಬರಲ್ಲ ಅಂತ.
ಎರಡು ವಿಡ್ರಾ ಅಂತ ಬಿಡ್ಬೇಕಾಗಿತ್ತು, ಅದು ರಿಜೆಕ್ಟ್ ಇದು ಅಂತ. ಇವಾಗ ಸಾಮಾನ್ಯದಲ್ಲಿ ಯಾಕೆ ತೋರಿಸಿದೀರಾ ಅವ್ರ ಹೆಸರು?
Rule regarding my lord in person. Please, my lord.
You can't defend this.
Well, at the my lord, I will produce the all documents regarding the.
But what about the election tomorrow? ಒಂಥರ ಆಪರೇಷನ್ ಸಕ್ಸಸ್ಫುಲ್ ಪೇಷಂಟ್ ಡೆಡ್ ಇದು. You'll have to challenge.
Application of not the results of the election itself is in doubt, but that they have not done it.
No, that we'll deal with. We can't say anything now. Now, what do you want to do? You want to contest tomorrow or you don't want to contest tomorrow? In general?
Not under the general.
You have announced ಆಗಿರೋ general.
But they have signed this.
2A OBC is already been declared. Even if for tomorrow declared today, even if we take it as that, it's been declared. That is the event which has happened. Unless you challenge, we can't look into it.
Series of events that would suffice, my lords, for this honorable court to consider. Because, my lords, in fact, yesterday also, my lords, I approached them. Yesterday evening, my lords, that we have served them. It is not that, my lords, today morning we have served them. Yesterday evening itself.
Yesterday night at 8:30.
You decide what you want to do.
Sir.
The AG is direct secure the original records released on Monday, 10th at 2:30 PM.
Serial number 75, Devi Prasad Shetty and connected matters.
My lord, these are.
Urgency ಅಂತ ಇದೆ.
My lord, regarding urgency, my lord, division bench has been specific direction given to the.
Division bench has given a direction for it to be
Hold the
disposed.
election. Hold the elections. To regard that regard, my lord, the AG.
So without this disposal, they can't hold the election.
Please. That is it.
Time bound direction has been given by the division bench.
Please.
We'll have to dispose this.
Even conduct the election.
ಕೊಡಿ division bench order ಕೊಡಿ. Division bench order.
But it is not against to this revision.
Twenty-five three ಏನಾಯ್ತು? ಏನಾಯ್ತು? 25-3 ಏನಾಯ್ತು? 25-3 ಇದೆ ಇನ್ನ, sorry, 4-3 ಇಂದ 25-2 ಅಂತ. So what is the order here? ಇಲ್ಲೇನು order ಇರೋದು? What is the interim order? F and G are stayed. What are F and G?
bylaw. These, my lord, the registrar is, my lord, are directing us to incorporate, my lord, these two societies as a representative of the apex.
Society, my lord, as per the government order, my lord, two newly constituted, my lord, taluks, my lord.
ಮತ್ತೆ ಕೋಲಾರ ಚಿಕ್ಕಬಳ್ಳಾಪುರನ
That
ಇದು DCC ಬ್ಯಾಂಕ್ ಅದು ಬೇರೆ
ಬೇರೆ
ಅದು ಮಿಲ್ಕ್
union.
because of split of the talukas and districts. ಅದಕ್ಕೆ ಹಿಯರಿಂಗ್ ಏನಪ್ಪ ಕೇಳ್ತಾ ಇರೋದು. Because if we don't dispose this,
Please, my lord.
they can't file a calendar of events on 25th
Also, my lord,
March.
two new talukas, my lord, introduced.
25th March ಗೆ ಅವ್ರು ಫೈಲ್ ಮಾಡಕ್ಕಾಗಲ್ಲ, ಮತ್ತೆ ಡಿಲೇ ಆಗತ್ತೆ. ಇವಾಗ ಎಲೆಕ್ಷನ್ ಆಗ್ಬೇಕು ಬೇಡವಾ?
May submit.
It will hear you on merit. We are not saying no, but you have to address arguments for us to hear. ಸುಮ್ಮನೆ ಕೂತ್ಕೊಂಡ್ರೆ ಆಗಲ್ಲ, ನೀವು ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಬೇಕು.
My lords, the only difficulty is here, my lords, there is a stay. The matter was heard before the previous bench, my lords. At that point of time, after the lengthy argument, learned senior counsels for the petitioner submitted, they do not have any difficulty in giving representation to these two people. Then finally, the matter was not finally heard and the matter is before. Now, my lords, in the writ appeal, they come and they insist that we issue calendar of events. In fact, we have also told to the court that we'll produce the calendar of events by 25th of this month. But the point is, my lords, these two talukas, as per their own bylaws, they have to be represented. They have to be given two directors' posts that they are not ready to give. One, my lords, and secondly, the people before my lords, they are not the federal society. They belong to one particular cooperative society, which is a primary society. The main federal society
We will
does.
take it up today. Yeah, who is appearing? ಎಲ್ಲಿ ಇಬ್ರು ಇಲ್ಲಿ ಬೇಕಲ್ಲ, ನೆಕ್ಸ್ಟ್ ಮ್ಯಾಟ್ರಿಗೂ ಬೇಕು. ಸೊ ಇದು ಇವತ್ತು ತಗೊಂತೀವಿ, ಅದಾದ್ಮೇಲೆ ತಗೊಂತೀವಿ, ಅಜ್ಜನ್ ಆಗಲ್ಲ.
Great.
ಇವಾಗ 25th ಕ್ಯಾಲೆಂಡರ್ ಆಫ್ ಇವೆಂಟ್ಸ್ ಕೊಡ್ತಾರೆ, ವಾಟ್ ಎವರ್ ಡಿಪೆಂಡಿಂಗ್ ಆನ್ ಇಟ್.
Great.
ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಸ್. ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ಸ್ ಯಾರಪ್ಪ ಶುರು ಮಾಡ್ತೀರಾ?
Serial number 3, Vijay Kumar K.
ನೀವೇನ ಓಪನಿಂಗ್ ಬ್ಯಾಟ್ಸ್ಮನ್? ನೆಕ್ಸ್ಟ್ ಯಾರು ರೆಡಿ ಆಗಿ? ಎಸ್ 13. D2 na 13-2 na?
13D2.
D2.
Days where 6 months of the date of election of the board, where registered post and an opportunity shall be given to such member to file their objections if any within 15 days date of the notice. The instant case blood, such a procedure not followed while declaring the eligible voters list.
15 days notice has not been given.
6 months of the to the date fixed for election of the board.
ಕೊಟ್ಟಿದಾರ ನೋಟಿಸ್? ನೋಟಿಸ್ ಕೊಟ್ಟಿಲ್ಲ. No notice at all. Who appears for the chief executive?
And
Awaiting service on respond number 5 idea.
5, please.
So this we can't take up without them.
Please. Other matters is, my lord, already. Those who are
Awaiting service on respond number 5, relist on 20th March.
Serial number 5, my lord.
ಅವ್ರು ಬಂದು ಅವ್ರು ತೋರ್ಸ್ಬೇಕು, ಇವ್ರು ತೋರ್ಸಕ್ಕಾಗಲ್ಲ.
Serial number 5, my lord.
Respond number 5 ನಿಮ್ ಫ್ರೆಂಡಾ? ನಿಮ್ ಫ್ರೆಂಡ್ ಅಲ್ವಾ? The registrar, the cooperative society is directed to inform respondent number 5 of his presence being required before this court on 20th March 2025 with all the original records. Please. ಇದಾಗೋವರೆಗೂ ಆಗಲ್ವೇ?
Serial number 5.
5 is concerned.
ಬಂದಿದಾರ ರೆಸ್ಪಾಂಡ್
There.
ಇದ್ದೀರಾ ಫಾರ್ R6? Yes. 13?
D.
Same ಇವಾಗ ಹೇಳಿದ್ದೆ.
ಅದೇ.
They themselves give statement of objection filed matter. They admit that the notice has been issued on 23/1/2005, paragraph 6 of the statement of objection.
23/1/2000? 6 months ಆಗಿಲ್ವಲ್ಲಪ್ಪ?
Lords, as per instructions, regular post was sent to all the, as per instructions, my lord, post was sent to all the members 6 months prior to this thing, my lords. And as a matter of abundant caution, before 45 days.
Give us when it was sent and give us the document for that.
Because, my lord, as per the law, my lord, they will send through the, my lord, RPID, my lord, register post. Let them, my lord, they produce that.
ಅದೇ ಕೇಳ್ತಾ ಇರೋದು.
I've sought for that and they're saying they do not have that.
They don't have it. No. And it's not been sent.
My lord, before 45 days, it has served through hand, my lord, to all the petitioners here in our office bearers from last 15 years, my lord. It was under the knowledge that.
Have you complied with your requirement of giving it 6 months before by register post?
I do not have documents to show.
So if you don't have documents, that means you have not sent it. So we'll hold that you have not complied with this and we'll hold them to be eligible and they vote to be counted.
That regard, my lord, the judgment is there, my lord, this honorable court is concerned. To 13D is concerned, my lord. So mandatory, it is mandatory and.
ಹೌದು.
My lord, they have an alternative remedy to agitate under section 70.
Why? You don't do your duties properly, they have alternate remedy.
Well,
only if you do something properly, or if there's a doubt, we'll send them to alternate, otherwise no.
Even if their votes is taken into consideration, my lords, they are not complied with the bylaws, my lords. They cannot be eligible members to become.
You are not complied with your duties. You can't say that. Sorry.
No, one submission.
Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner was that they were declared ineligible without following the requirements of clause Roman 2 of sub-rule 2A of Rule 13 capital D of the Karnataka Cooperative Societies Rules 1960, inasmuch as no notice 6 months prior to the date of election had been served on the petitioners by register post and no opportunity had been given to them to file their objections, if any, within 15 days of service of notice. Statement of objections, this court, wide, its order dated 28/1/2025 has permitted the petitioner to cast their vote, in pursuance of which the petitioner have cast their vote on the elections held on 9/2/2025. Respondents have filed a statement of objections. A perusal of the statement of objection indicates that the respondents claim that notice has been issued on 23/1/2025 at para 6 of the said statement of objection. The election, as aforesaid, being held on 9/2/2025, even if the notice were to be issued on 23/1/2025, the same would not qualify the requirement of clause 2 of subsection sub-rule 2A, 2 capital A of Rule 13D of the rules. The same not having been issued within 6 months prior to the date of elections. In that view of the matter, and they consider opinion that the declaration and or holding the petitioners to be ineligible is not sustainable in view of the contravention of clause 2 of so and so. As such, I pass the following order. Writ petition is allowed, a certiorari is issued. The voters list dated 21/2/2025, insofar as the petitioner is concerned, is quashed. The declaration or the declaration by the respondent society or the petitioner to be ineligible voters is set aside. The petitioners having already cast their vote, the respondents are directed to count the said votes and declare the results of the election, if not otherwise injuncted in any other proceedings, within a period of 7 days from today.
As contents, ma'am, we left open for respondent number 6 to agitate under section 70 regarding eligibility.
Where are you going to agitate now? In the next election?
They are not, they do not comply with the bylaws. They are not eligible.
The respondent, that will also, good that you reminded us. Respondent number 1 is directed to, respondent number 1, 2 and 3 are directed to take necessary action against the chief executive officer of respondent number 3 for not having complied with the mandatory requirements of clause 2 of sub-rule 2 capital A of rule 13D and file necessary report of the action taken within 4 weeks from today.
Please.
Serial number 6, Devi Prasad Shetty.
Matter, I appear for the 6th respondent, 5th respondent.
Yes.
My lord, we have filed a memo, my lord, application for.
Filed a memo for?
Application, my lord, for announcement of the election.
You are filing it.
No, I've already filed, my lord.
Still illa.
24th February.
Agide, 24th February.
But this was the case, my lord, where the delegate was sent, my lord, he was not given the opportunity to vote. Delegation form was not accepted. Subsequently, my lord, this honorable court allowed him to cast his vote, my lord, and he has casted his vote. And thereafter, my lord, the said society, my lord, which had now elected body, my lord, subsequently they delegated the same person, my lord, to
Delegated same person.
yes.
The petitioner is before this court seeking for the following leaves. The grievance of the petitioner was that despite the petitioner being a delegate of respondent number,
Fifth response.
ಅದು ಯೂನಿಯನ್ ಅದು
Of 4, my sorry.
ನೀವು ಸೊಸೈಟಿನೇ ಹಾಕಿದ್ದೀರಾ?
Please.
A resolution is passed not authorizing
The petitioner in the above matter is represented by its president. The grievance of the president was that the president, being the delegate, was not permitted to vote at the election or the 5th respondent union to be held on 2/2/2025. This court, vide interim order dated
31/25.
31/2025, permitted the petitioner to cast the vote on behalf of the president to cast the vote on behalf of the petitioner.
Society.
Subsequently, before the elections were held, the society, the petitioner society has nominated the president as the delegate. And the petitioner has thereafter voted as the delegate. In that view of the matter, nothing further survives in the present matter except for direction to be issued to respondent number 4 to declare the results of election unless otherwise injuncted by any other in any other proceeding. As such, the above petition is disposed of, directing respondent number 4 to announce the election results within 7 days from the date of receipt of a copy of this order as observed above.
92 also belongs to the same society.
Yadu?
92 also, my lord.
But there, my lord, there's violation of 13D. my lord, and they had filed an appeal, my lord, appeal also went against them. And the only thing is, their vote cannot be.
92 ಅಂದ್ರೆ ಇವಾಗ ಫೈಲ್ ಸಿಗಲ್ಲ ನಮ್ಗೆ ಇಲ್ಲಿ. ಅಕ್ಕಪಕ್ಕದಲ್ಲೇ ಸಿಗತ್ತೆ 92 ಎಲ್ಲಿ ಸಿಗತ್ತೆ ನಮ್ಮ ಸಿಕ್ಕೇ ಬಿಡ್ತು 92 ಫೈಲ್. 92 ಆನಂದ್ petitioner.
Notices were issued in this matter.
ಏನ್ ದೇವ್ ಸರ್
By counting the vote of the petitioner.
ಕೌಂಟಿಂಗ್ ಆಗಿಲ್ವಾ?
Counting ಆಗಿ. ಅದೇ ನಮ್ಮ vote counting count ಆಗ್ತದೆ. Count ಆಗಿ declare.
ಇದರಲ್ಲಿ 5 or 6 sir.
Their votes are not counted.
Respond number so and so is directed to count the votes,
Their vote
including
cannot
that
be-
of the petitioner.
Their vote cannot be
Considered.
counted.
Okay?
Sorry,
13D is
it is already complied, my lord. That is what senior was.
The 13D, and
ಯಾವ್ದು 92 ಅಲ್ಲ 6 ಅವ್ರು ಹೇಳ್ತಾರೆ.
6 ಅಲ್ಲ.
6 ಅಲ್ಲಿ is been a delegate.
Yes.
that is okay. The 60.
Respond declare the results of the election by counting the votes including that of the petitioner and announcing the result within 7 days.
My lord, but 13D violation is there, my lord, and
ಯಾವ್ದ್ರಲ್ಲಿ?
ಇದ್ರೊಳಗೆ 92, my lord.
92 ಅಲ್ಲ ಇವಾಗ 6 ಅಲ್ಲಿ.
Sorry, sorry.
Yes. 92 ಏನ್ ಆನಂದ್?
My lord, notices were issued. And my lord, some of the petitioner, they filed objections also. The objections were not considered and my lord, they were not placed in the same ineligible voters list. It can be disposed of.
We have been issued notice.
Yes, please.
They have passed orders.
Yes.
You can't have any other grievance.
Yes.
Appeal was also filed, that was also rejected.
Petitioner is before this court seeking for the following reliefs. The petitioner, the grievance of the petitioner was that the objection which had been submitted by the petitioner in pursuance of a notice issued under clause 2, Roman 2 of sub-rule 2A of rule 13 of so-and-so rules had not been considered properly. As regards same, the petitioner had also filed an appeal before the
I have submitted objections to CEO, addressed to CEO, that is placed before the district election officer, deputy commissioner.
appeal ಯಾರ ಮುಂದೆ ಹಾಕಿದ್ರಿ?
ಅಲ್ಲ, deputy commissioner, district election officer.
That was rejected on 26/7/24.
Respondent number 3.
Where do we get these details?
Annexure E, my lord. Page 26. Idinalli, it is a proceedings my lord drawn by the district election officer.
ಏನಂತ ಹೇಳಿದಾರೆ ಅವರು?
30 by
ಆದೇಶ ಮಾಡಿ ಮತ್ತೆ ನಮ್ಮನ್ನ ineligible voters list ಅಲ್ಲೇ place ಮಾಡಕ್ಕೆ ಹೇಳಿ. He has considered the objection submitted and then he passed an order placing the names of the petitioner in the ineligible voters list prepared by the chief.
The order has been passed.
Yes.
It had been filed before the deputy commissioner who has considered and passed an order on 26/7/2024, holding the petitioners to be ineligible. A detailed analysis of the facts having been made by said deputy commissioner, and on facts it's being found that that the petitioner is an ineligible member, and they consider opinion that the said finding on fact cannot be disturbed in the present proceedings. As such, no grounds being made out, petition stands dismissed. ಇದರಲ್ಲಿ vote ಮಾಡಿದ್ರಾ?
Vote ಮಾಡಿದ್ರು.
vote ಮಾಡಿದ್ರು.
That has
The
to be counted.
Separate seal.
respondents, respond number,
Returning officer. Respondent number,
92.
respondent number 5
respond number 5
was subsequently implemented.
is directed to count the votes excluding that of the petitioners
And declare.
and declare the results of the election within 7 days of the receipt of this order, subject to there being no other order injuncting such declaration.
Serial number 8. Kantaraju CS.
Cost is complied, Your Honor, needful done.
8. Cost paid,
Cost paid.
ಏನ್ ಇದ್ರಲ್ಲಿ?
That, Rule 13D, Your Honor, not complied there.
What is the violation?
They have not served the prior to 6 months, they have not served the notice.
13D, my lord.
R5.
Mr. DM Krishna? DM Krishna na TM Krishna?
DM.
DM ಅಂತ ಬಂದಿದೆ.
DM ಕೃಷ್ಣ.
ಮಿಸ್ಟೇಕ್ ಅದು?
ಇಲ್ಲ,
ಇಲ್ಲ,
same,
correct.
same.
DM TM ಅಲ್ವಾ?
D, so.
D ನ?
DM.
ಕರೆಕ್ಟ್. ಎಲ್ಲಿ ಬಂದಿದ್ರಾ?
Is present before morning session idru sum.
ಇವಾಗ ಎಲ್ಲಿ? ನೀವು ಲಂಚ್ ಕೊಡ್ಸಿಲ್ಲ ಅವ್ರಿಗೆ.
ವಕಾಲತ್ ಹಾಕಿದಾರೆ ಅನ್ಸುತ್ತೆ. ಫೈಲ್ಡ್ ವಕಾಲದ್ದೆ.
ಏನ್ ನೋಟಿಸ್ ಕೊಟ್ಟಿದಾರಾ ಇಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ.
ಕೊಟ್ಟಿಲ್ಲ sir.
ಕೊಟ್ಟಿಲ್ವಾ?
ಏನ್ ಗ್ರೌಂಡ್ಸ್ my lord, 13D is not complied.
ಇವ್ರ ಗ್ರೌಂಡ್ ಬಟ್ ಅವ್ರ ಏನ್ ಕೊಟ್ಟಿದಾರಾ ಇಲ್ವಾ?
ಕೊಟ್ಟಿಲ್ಲ. ಅವರೇ ಹೇಳ್ಬೇಕು.
ಅವ್ರ ಇಲ್ದೆ ಹೆಂಗ್ ಹೇಳೋದು ಅದು? ಮಿಸ್ಟರ್ DM ಕೃಷ್ಣ ಅಬ್ಜೆಕ್ಷನ್ಸ್ ಹಾಕಿಲ್ಲ.
Next week.
ನೋಡಿ ಎಲ್ಲಿದ್ದಾರೆ ಕರ್ಕೊಂಡ್ ಬನ್ನಿ ಪಾಸು.
Sir, they said earlier morning session ಅಲ್ಲಿ no objection ಅಂತ ಹೇಳಿದ್ರು.
ನೋ ಅಬ್ಜೆಕ್ಷನ್ ಅಲ್ಲ, ನೋಟಿಸ್ ಕೊಟ್ಟಿದಾರಾ ಇಲ್ವೋ? Because we are directing action to be taken against the chief executive officer.
Yes.
Now we are not leaving it just like that. So ಅವ್ರ ಮೇಲೆ ಆಕ್ಷನ್ ತಗೊಳ್ಬೇಕು ಅಂದ್ರೆ ಅವ್ರ ಸಬ್ಮಿಷನ್ ರೆಕಾರ್ಡ್ ಮಾಡ್ಬೇಕು. ಈ ಸುಮ್ನೆ ಬಿಟ್ಟು ಅವ್ರೆಲ್ಲ ಆಲ್ collusion is happening. Disciplinary action ತಗೊಂಡ್ರೆ ಅವಾಗ they'll probably next time. ಪಾಸು.
Serial number 10.
10.
Dada Khalandar.
ಎಲ್ಲಿ?
Petitioner.
ಏನ್ ನಡೀತಾ ಇದೆ?
Service.
ಇನ್ನ ಎಷ್ಟೊತ್ತು ನಡೆಯುತ್ತೆ?
From 2:30 it's going on.
ಇನ್ನ ಎಷ್ಟೊತ್ತು ನಡೆಯುತ್ತೆ? ಪಾಸ್ ಓವರ್.
Twenty-one. Sandesh TB.
Yes.
Lords, the petitioner challenging the order of the point number 2, my lords, the annexure B, my lords.
Annexure F.
Lords, now
That's point
challenging
number
the
2.
annexure F, my lords. The annexure F, my lords, the order passed by the annexure deputy registrar of cooperative societies has been rejected, my lords, on the ground that, my lords, the petitioner are not given the resignation to the CEO of the society, my lords. The CEO itself has created the false resignation letter, my lords, and sent to the assistant registrar of cooperative societies, my lords. And
Need to give it to CEO. What do you have to show?
lords, the PO have created the my resignation letters, my lords, they sent to the assistant registrar of cooperative society, my lords. The on section 29B clearly stated that, my lords, the once any directors have given a resignation letter, they have to put before the meeting, my lords. They have not conduct the meeting agenda, my lords. Straight away they sent to the assistant registrar. Based on that, my lords, the deputy registrar has passed an order of appointing the special officer to the society, my lords. That has been challenged before the deputy registrar, my lord. The deputy registrar ultimately concluding that, my lords, they kindly see the annexure F, my lords, page 71, my lords, in the last paragraph.
Yes.
ಹೊಸನಗರ ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘ ಕೊಳ್ಳೇಗಾಲ ತಾಲೂಕು ಚಾಮರಾಜನಗರ ಜಿಲ್ಲೆ ಇದರ ಮೇಲ್ಮನವಿದಾರರು ಕ್ರಮ ಸಂಖ್ಯೆ 1ರಿಂದ 6 ತಮ್ಮ ವಕೀಲರ ಪರವಾಗಿ ಮಂಡಿಸಿರುವ ಪ್ರಮಾಣೀಕೃತ ಹೇಳಿಕೆ, ದಾಖಲಾತಿ ಪ್ರತಿಗಳನ್ನು ಮತ್ತು 3ನೇ ಎದುರುದಾರರು ಸಲ್ಲಿಸಿರುವ ಹೇಳಿಕೆ, ಖಂಡಿಕೇಶರ ಹಾಗೂ ಉಳಿಕೆ ಎದುರುದಾರರು ಸಲ್ಲಿಸಿರುವ ಹೇಳಿಕೆಯನ್ನು ಘನ ನ್ಯಾಯಾಲಯದಲ್ಲಿ ಪರಾಮರ್ಶಿಸಿದ್ದು, ಮೇಲ್ಮನವಿದಾರರು ಕ್ರಮ ಸಂಖ್ಯೆ 1 ಹೊರತುಪಡಿಸಿ ಉಳಿಕೆ 2ರಿಂದ 6ನೇವರೆಗೆ ಮೇಲ್ಮನವಿದಾರರು ನ್ಯಾಯಾಲಯಕ್ಕೆ ಹಾಜರಾಗಿದ್ದರೂ ಸಹ ಮೂಲ ಮೇಲ್ಮನವಿ ಅರ್ಜಿಗೆ ಪ್ರಮಾಣೀಕೃತ ಹೇಳಿಕೆಯನ್ನು ನೀಡುವುದಾಗಲಿ ಮುಖ್ಯ ಸಾಕ್ಷಿಯ ವಿಚಾರಣೆ ಪ್ರಮಾಣ ಪತ್ರ ಸಲ್ಲಿಸದೇ ಇರುವುದನ್ನು ನ್ಯಾಯಾಲಯವು ಗಮನಿಸಿ ಕೆಳಕಂಡ ಆದೇಶವನ್ನು ಹೊರಡಿಸಲಾಗಿದೆ.
ತಿರಸ್ಕರಿಸಿದ್ದಾರೆ. ಅದನ್ನು ಪುರಸ್ಕರಿಸಿದ್ದಾರೆ. 29B.
29B, my lords, kindly see.
Your contention is that they have fabricated your,
Please, my lords,
and you did not know about it.
please. 29B, my lords. Resignation of member of board of a office bearers of a cooperative society. A member of the board of a cooperative society or an officer bearers of a cooperative society may resign his membership of the board or an office bearers of a society as the case may be in writing under the hand addressed to the chief executive, and it shall become vacant on the expiry of 15 days from the date of such communication, unless within the said period 15 days such member of the board office bearers withdraws such resignation in writing under his hand and address to the chief executive. The chief executive shall place a letter of resignation before the meeting of the board conveyed the next after the communication of such letter.
Yes, you are appearing for the chief secretary. 6 to 10. So you submitted it.
I have no dispute regarding my.
Hmm.
Fact, page number 17 contains compensation
17.
of their petition.
Hmm.
Contains the NTM of a director who has submitted the resignation. And the very version of the business that created the documents. NTM cannot be enforced.
I'm only regarding petitioner number 1 and 2, my lords.
After submitting the resignation letters.
All of you had submitted together.
I'm disputing only regarding the petitioner number 1 and 2, my lords. Apart from other directors, they have given a resignation.
ಎಲ್ಲರೂ ಹೋಗಿದ್ದಾಗ ಅವರು so many of them have resigned.
So many of the resigned, my lord. The annexure B, my lord, the assistant registrar passed an order stating that there is no quorum, therefore the.
ಇವಾಗ ಅಷ್ಟು ಜನ ರಿಸೈನ್ ಆದ್ಮೇಲೆ ಇನ್ನೇನು ಉಳಿಯುತ್ತೆ?
ಅಲ್ಲ, ನಾವಿಬ್ರು ರೆಸಿಗ್ನೇಷನ್ ಕೊಡ್ಲಿಲ್ಲ ಅಂದ್ರೆ ಬೋರ್ಡ್ ರಿಮೈನ್ಸ್ ವಿಲ್ ಕಂಟಿನ್ಯೂ ಬಿಕಾಸ್ ದಿ quorum has.
Only 2 of you.
ಹೌದು.
Only 2 of you, how will the quorum remain?
ಅಲ್ಲ, ಟೋಟಲ್ ಔಟ್ ಆಫ್ 11 members ಅಲ್ಲಿ 5 members they have given a resignation. The minimum quorum is 7, my lords.
6 to 10. 6 to 10. Only 5.
5, my lord. 7 is the quorum, my lords.
There are 6 petitioners.
But none of them were revoked their resignation after submitting the resignation.
Yes, but was it placed? Who is appearing for the society?
Society now.
No, my lord.
Society.
For the chief executive officer. R5 served and no representation. ಯಾರು ಬರಲ್ಲ ಅಂದ್ರೆ ಏನಿದೆ?
Warrant should be issued, my lord.
NBW.
Please. Because, my lord, as per the, my lord, 7 members has been received. That is the reason.
He is supposed to come and give us the
Please,
document.
Please.
He doesn't engage any counsel. You are not authorized to appear.
Please.
Madam, we are having a lot of trouble with your societies and the chief executive officers.
Please.
They have been served, they are not coming. AGA cannot appear for them
We
as
can't
per
appear.
your rhythm.
Because societies are private bodies, my lords, they're represented by the chief executive.
Now they are not coming. We will start issuing NBWs to all of them. We are also directing action against the chief executive officer for not complying with 13.
Please, please, ma'am, because
Because
they-
without seeing the records. Now, the issue here is whether the resignation was placed before the board or not.
they have to say that.
Sandesh is saying, no, it was not placed. He is saying it has been placed. How do we make out? Without them.
We'll also advise the registrar department to give one circular to all the societies so that whenever any matters are before court that they have to represent. We'll advise, ma'am.
Can you also get them onto CCMS so that they get it?
That CCMS, yeah,
So they are
thousands,
not,
thousands, they're not departments, they'll not have the, like, for example, a primary society in a village may not have access to a net and all.
ಯಾರ್ಯಾರಿಗಿದೆಯೋ ಅದ್ರ ಹೋಗುತ್ತೆ.
We'll try and.
100% ಯಾವ್ದು,
Yes.
there's no foolproof system.
Please. But at least when a matter comes before the court, they have to come and represent themselves. They should be at least,
We can't, they've been served.
please.
We can't take a decision either way because of no document.
We will advise the department to issue some kind of
The dispute in the above matter is that the petitioner have not submitted their resignation and the alleged resignation has never been placed before the board by the chief executive officer. Counsel for respond number 6 to 10 hours submit that resignation has been submitted by them and it's been placed before the board. The chief executive officer, though served, has chosen not to be present before this court. If it is an order to be passed against the chief executive officer and chief executive not being present, the matter is different. But on account of the chief executive officer not being present, this matter cannot be taken up since the records placed before the board are not before this court for consideration. In that view of the matter, the first and second respondents are directed to issue necessary directions to all the chief executive officers coming under their jurisdiction that they are required to appear before the concerned court where notices are served. And if there is non-appearance and the same is brought to the notice of the first and second respondent, they would be taking necessary action against such chief executive officer. In the present matter, respondent number 5, having been served and not being represented, issue NBW to respondent number 5, returnable by, issue bailable warrant, returnable to respondent number 5, returnable by 27th March for a sum of rupees 20,000, please. The second respondent is also directed to inform the fifth respondent about the above order. The fifth respondent shall be present before this court on 27th with the original records relating to the above matters.
Interim order next.
Interim order earlier granted is extended till next date.
Legal number 25. Mahesh Arupi, non-connected matters.
Consistently absent.
Service matter ಏನು ಬಹಳ ನಡೀತಾ ಇತ್ತು.
The High Court employee.
ಅದು ಇನ್ನ ಇಂಪಾರ್ಟೆಂಟ್.
ಹೈಕೋರ್ಟ್ ರಿಜಿಸ್ಟ್ರಿ ವಿರುದ್ಧ ಕೆಲಸ ಮಾಡಬೇಕು ಎಷ್ಟು ಕಷ್ಟ ಇದೆ.
ಏನು ಹೇಳಲ್ಲ. ಎಸ್.
Milord, the
ಯಾವ್ದು ತಗೊಳ್ಬೇಕು ಮಿಸ್ಟರ್ ರಾಜಗೋಪಾಲ್?
this is Milord 3536. 3536 of 2005, 25.
3536. Varun, you have filed impleading application.
Pleading application.
ನೀವ್ಯಾರು?
Near the contestants, your lordships.
Contest.
I appear for the
25.4.
fifth respondent bank.
Application IA 1 of 25 has been filed by one other contestant to come on record on the ground that any order passed.
Five. Contestants are five, not one.
Five,
Please.
filed by 5 contestants to come on record on the ground that any order passed would adversely affect them, accepting the reasons stated in IA 1 of 25. The said application is allowed. The person named therein are brought on record as respond number 6 to 10. Counsel for the petitioner to carry out necessary amendment and file amended clause title. Yes, good. Itkodi,
Lord, the grievance
See.
in the writ petition is
25.4. ಅದೇ ಯಾವ್ದದು? ಏನ್ pleading?
40-204.
Yes.
35, 36 ಇದೆ ನನ್ನ.
The grievance in all these petitions are the same
Same.
grounds?
Same. One question I would like to address is, my lord, by way of rejoinder, some affidavits and some documents have been filed on behalf of the society to show there is a compliance of provision under the rules they said so. For that, it necessitated for me to file the rejoinder. That may kindly be looked into. My lord, two documents I have placed on record.
Copy ಕೊಟ್ಟಿದ್ದಾರೆ.
Last night, my
lords, it was given to me.
If they want to inquire, let they can inquire. Otherwise,
ಇಲ್ಲ, they are ready.
and then it is not a reason I am paying for the purpose of seeking adjournment. It's a very important document.
We are not, we did not say anything.
Yes. My lord, these two documents reflect that there are
ಇಲ್ಲ, ಏನ್ issue ಏನ್ ಹೇಳಿ?
issue is there. Registered post, what they are claiming, which are sent, there is no dispute, of course. But out of which, my lord, out of 11,444 registered posts, 10,162 registered posts returned back to the society.
ಏನಿದೆ document?
Unserved.
ಏನಿದೆ?
ಅದೇ ನಿಮ್ಮನ್ನ ಅನರ್ಹ ಮಾಡ್ತಾ ಇದೀವಿ, ಯಾಕೆ ಮಾಡಬಾರ್ದು, ಅಬ್ಜೆಕ್ಷನ್ ಫೈಲ್ ಮಾಡಿ ಅಂತ.
ಅಲ್ಲ, ಎಲ್ಲಿದೆ document to show that it's been returned back?
It is 28 to 2025 rejoinder with document I have uploaded given by the society only.
ನೋಡಿ.
It is Annexure C. We filed on 3/3/2025.
Annexure C of?
Annexure C, my lord, in our rejoinder.
Rejoinder. ಇಲ್ಲ, ಇಲ್ಲಿ rejoinder ಇಲ್ಲ. ಇದು petition.
May I give my copy?
ಬರೀ petition ಇದೆ.
I have filed my affidavit in writ petition 2043.
Could you lodge this? Page 6, my lord. First document.
Yes.
This is Town Cooperative Bank, Pascote. It is signed by the officer concerned, general manager. Melkanda first paragraph may not be necessary, my lord. If necessary, I can. Anyhow, a very short letter. ಮೇಲ್ಕಂಡ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ತಮ್ಮ ಬ್ಯಾಂಕಿನ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣೆ ಸಂಬಂಧ ಸದರಿ ಚುನಾವಣೆಯಲ್ಲಿ ಮತ ಚಲಾಯಿಸಲು ಅರ್ಹತೆ ಹೊಂದಿಲ್ಲದ ಅನರ್ಹರಿಗೆ ಸಹಕಾರ ಸಂಘಗಳ ಸಂಖ್ಯೆ ಸೋನ್ಸು 6 ತಿಂಗಳಿಗೆ ಮೊದಲು ಅನರ್ಹತಾ ವಿಷಯ ತಿಳಿಸಿ ಅನರ್ಹತೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಕ್ಷೇಪಣೆ ಇದ್ದಲ್ಲಿ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿ ನೀಡಿದ್ದ ನೋಟಿಸ್ಗಳ ಪೈಕಿ ವಿತರಣೆಯಾದ ಮತ್ತು ವಿತರಣೆಯಾಗದ ಪ್ರಕರಣಗಳ ವಿವರ ನೀಡಲು ಕೋರಿ ಅರ್ಜಿ ಸಲ್ಲಿಸುವುದು ಸರಿಯಷ್ಟೇ. ಈ ವಿಷಯಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಮೂಲಕ ತಮಗೆ ತಿಳಿಯಪಡಿಸುವುದೇನೆಂದರೆ 9/2/25 ಜರುಗಿದ ಆಡಳಿತ ಮಂಡಳಿ ಚುನಾವಣೆ ಸಂಬಂಧ ಚುನಾವಣಾ ಪೂರ್ವದ 6 ತಿಂಗಳಿಗೆ ಮೊದಲು ಅನರ್ಹ ಸದಸ್ಯರ ಪಟ್ಟಿಯಲ್ಲಿದ್ದ ಒಟ್ಟು 11,044 ಮಂದಿಗೆ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮ ಸಂಖ್ಯೆ ಸೋ ಅಡಿಯಲ್ಲಿ ಅನರ್ಹತಾ ವಿಷಯವನ್ನು ಮತ್ತು ಅವರ ಅನರ್ಹತೆಗೆ ಸಂಬಂಧಿಸಿದಂತೆ ಆಕ್ಷೇಪಣೆ ಸಲ್ಲಿಸಲು ಸೂಚಿಸಿ ನೋಂದಾಯಿತ ಅಂಚೆ ಮೂಲಕ ನೋಟಿಸ್ ಕಳುಹಿಸಿಕೊಟ್ಟಿದ್ದು ಸದರಿ ನೋಟಿಸ್ಗಳ ಪೈಕಿ 10,162 ನೋಟಿಸ್ಗಳು ಸದಸ್ಯರ ವಿಳಾಸಗಳಿಗೆ ವಿತರಣೆಯಾಗದೆ ಬ್ಯಾಂಕಿಗೆ ವಾಪಸ್ಸಾಗಿರುತ್ತೆ. ಉಳಿಕೆ 880 ನೋಟಿಸ್ಗಳು ಬ್ಯಾಂಕಿಗೆ ವಾಪಸ್ಸು ಬರದ ಕಾರಣ ಸದರಿಯವುಗಳು ವಿತರಣೆಯಾಗಿರುತ್ತವೆ ಎಂದು ಪರಿಗಣಿಸಿದ ಮಾಹಿತಿಯನ್ನು ಈ ಮೂಲಕ ತಿಳಿಯಪಡಿಸಿದೆ.
Who is appearing for the Chief Executive Officer?
I appear for the 5th respondent bank. Please.
Now, to what address did you send?
The last known address to the bank, my lords, we have dispatched.
Which is the
Please,
address?
my lords,
What
I
do
have
we have to show that it has been sent to that address? What have you produced?
my lords, I have produced the barcode, my lord, of the
Where is it?
affidavit, my lords, I have filed on 21st February in WP number 2043 of 2025.
2043. 43, first matter.
First matter.
ID. When did you file it?
Page, I have filed it on 21st February, my lords.
Page number?
Page number 46, my lords.
the details of the consignment sent to all the 11,044 members, along with their names and share numbers.
Yes,
Page 46 to page 267.
it's been addressed to you, Mr. Rajgopal.
No, the- But my submission is the sending registered post is not an empty formality. Suppose, my lord, if it is not, admittedly it is returned.
Have you-
Admittedly it is returned.
Have you updated your address?
Because
Have you updated the address? Have you changed your address?
Petition and ಯಾವ್ದಾಗಿದೆ?
there is no change of address, majority
No
of
change.
the members.
Then why did not you? What is the reason for return?
My lords, that I am not aware, my lords, because
You'll have to give us that reason.
I will file an affidavit to
If
them.
it's returned for refused, then
There may be
Then
three.
give us
my
a
voice would be loyal.
chance ಇಲ್ಲ. ಇನ್ನೊಂಥರ ಬರುತ್ತೆ ಅದು ಅಷ್ಟೇ.
I will file an affidavit,
So all these which have been returned,
please.
you'll have to classify it as whether returned for on account of refusal to accept, unclaimed or whatever.
Intimation delivered and not.
Unclaimed.
Yes.
You'll accept that.
I will file an affidavit.
But if it is no such person,
I will also indicate the addresses which are sent, which it is sent to.
you'll have to come up with something. Madam, this whole thing is a fiasco about the register post. 11,000 into 30 rupees. 3.5 ಲಕ್ಷ ರೂಪಾಯಿ ಪಾಪ ಖರ್ಚು.
We have paid it.
ಅದಕ್ಕೆ we are saying ಹಾಲಿನ ಬೆಲೆ ಜಾಸ್ತಿ ಆಗ್ತಾ ಇದೆ.
It is of no use. but-
This money is being wasted for things which is not required. Must be some other way that could make it cheaper and more efficient.
In the batch of writ petitions, my lord, we have took up a contention that the rules are mandatory in nature discretion. Government said, no, it is mandatory, our writ petition, they made us to dismiss those writ petitions confirmed by the division bench.
There are some of these societies which have 30,000-40,000 people.
Correct, absolutely, that we have argued all those points. As per the lordship said, you have to follow, otherwise, there's no elections.
As long as the rule is there, we can't do anything.
Now, that's the reason we said it's a discretion, one, they're not mandatory, you hold so.
That is for the state to know.
But government said, no, it is mandatory, they have to follow because they keep an eye on society. They should see that why should be lost the matter, they succeeded.
Only the
Bank is in
government,
the
my lord,
control of the
this honorable court has
administrator. You'll
also
have to
passed.
secure
It is mandatory.
Aitappa, but this is very unwieldy procedure. And there are so many members. There has to be
Paper
something.
publication.
WhatsApp, paper publication, ಎಲ್ಲ email ತಗೊಳ್ಳಿ member ಆಗಿದ್ದೆ. Best email ತಗೊಂಡು ಎಲ್ಲ ಅವ್ರು ಕಳಿಸ್ತಾ ಇರ್ರಿ. ಅವಾಗ everything is transparent.
In respect of my lord, if objection is received, my lord, then my lord, election officer should hear the both sides. That is the reason, my lord, notice should be go the private person, those who are, my lord, member of the society. That is the intention of the law.
ಆಯ್ತು.
ಅಲ್ಲ ಆಮೇಲೆ ಪೇಪರ್ ಪಬ್ಲಿಕೇಶನ್ ತಗೊಂಡ್ರೆ ನೋಟಿಸ್ ಹೋಗಲ್ಲ ಅಂತ.
ಇವರು 18,000 ತಗೊಂಡ್ ಬರ್ತಾರೆ, 11,000 ತಗೊಂಡ್ ಬರ್ತಾರೆ ಅಂತ ಇಟ್ಕೊಳ್ಳಿ. 11,000 ಅಕ್ನಾಲಜ್ಮೆಂಟ್ ಇವಾಗ ನೋಡ್ಕೊಂಡು ಅದನ್ನ ರಿಕನ್ಸೈಲ್ ಯಾರು ಮಾಡೋರು? ನಿಮ್ದ?
Yes.
33,000 ಹೆಂಗೆ? How do we do that?
Alternative ways also the act.
Division bench will confirm ಆಗಿದೆ.
That's why, my lord. in the-
Majority is in my favor.
ನಮ್ದು ಒಂದು ಓಟ್ ಸೇರಿಸ್ಬಿಡಿ. Since we are discussing elections.
That's why recently one petition has been filed, my lord, challenging that amendment.
ಇದೆಯಾ?
ಅದೇ ಮೊನ್ನೆ ಪ್ರೊಫೆಸರ್.
ಅಲ್ಲ ಅದು 20.
ಅದು ಬೇರೆನಾ?
ಅದು ಬೇರೆ. Section
A4 and A5.
F5, please, my lord. So minimum service.
ಅದು ಹೋದ್ರೆ ಇದು
Conditions ಅದು. ಇದು 13(2)A.
13D.
Deemed to be served would be if it is returned or unclaimed. There's no doubt about it. But today's time and age, you could look at emails.
WhatsApp also,
ಎಲ್ಲರ ಹತ್ರನೂ email ಇದೆ.
WhatsApp
email ಇಲ್ದೆ.
probably would be the best.
ಎಲ್ಲರ ಹತ್ರ ವಾಟ್ಸ್ಆಪ್ ಇದೆ. ಏನಿಲ್ಲ ಅಂದ್ರೆ ಮೂವಿ ನೋಡಕ್ಕಿದೆ.
ನನ್ನ ಹತ್ರ ಇಲ್ಲ. ನನ್ನ ಹತ್ರ
ಮೂವಿಗಿಂತ ಸೀರಿಯಲ್.
ನೀವೇ ಇಲ್ಲ ಅಂತ ಹೇಳ್ಬೇಡಿ. ಯಾರು ನಂಬಲ್ಲ ಆಮೇಲೆ. Something has to be worked out, otherwise this will continue. Please. This time we'll do this, but afterward, every time to be doing this will be a problem. Any amendments, anything proposed?
Even on this, we'll have it across the learned age.
Right, council for respond number
5 minutes,
5. Seeks fund is granted. ಎಷ್ಟು ದಿನ ಬೇಕಾಗತ್ತಪ್ಪ?
3 weeks minutes.
3 weeks time to place on record the details of the register post which have been sent to the members, details of service thereof, details of service or non-service thereof,
Including the addresses.
including the addresses to which it has been sent. Relist on 27th March. Agata,
Next week.
list on 3rd April. Until then, we can't announce the results. Or we should say, go file election petition and simple ಆಗಿ ಮಾಡ್ಬಿಟ್ಬಿಡುವ.
ಅದೇ ಬೆಸ್ಟ್.
ಅದಾದ್ರೆ ನಾವು ಹೊರಗೋದೇ ಇರ್ಲಿಲ್ಲ, ಹೊರಗಡೆನೆ ಇರ್ತಾ ಇದ್ದೆ.
With my lord's kind leave.
Disputed ಅಂದ್ರೆ ನೀವು ಕೊಡಬೇಕು. Have you given the updated address?
Start from the beach.
27 will apply. General clauses.
All sent together.
ಅದು ಅಲ್ಲೇ ಪೋಸ್ಟ್ ಆಫೀಸ್ ಅಲ್ಲೇ ವೇಸ್ಟ್ ಬಾಸ್ಕೆಟ್ ಅಲ್ಲಿ ಹೋಗಿದೆ ಅನ್ಸುತ್ತೆ.
With my lord's kind leave.
Yes.
My lord, serial number 10, since Mr. Rajgopal has come.
Yes. You are keeping track of him.
My lord,
10. ಯಾಕೆ? ನಿಮ್ಗೆ ಏನ್ ಸುಧಾರಿಸ್ಕೊಳ್ಳೋದು? ಅವ್ರು ಹೇಳೋ ಒಳಗೆ ನೀವು ಸುಧಾರಿಸ್ಕೊಳ್ಳಿ. ಹೇಳಿ ಶೆಟ್ರೆ.
my lord, the bylaws of the milk cooperative society, that is the Chikka Kurabarahalli society. The bylaws, my lord, with regard to the area of operation that stood prior to 28/8/1998 was in respect of 4 villages. Chikka Kurabarahalli, Dodda Kurabarahalli, Hebbadara Metlu, Mattu and Banikuppe. 1998 August, my lord, there was a request from this Banikuppe and Hebbadara Metlu members indicating that, my lord, there is a separate milk society. And by virtue of that, my lord, there was an amendment to bylaw wherein these 2 villages were excluded from area of operation
Of
the
which
Chikka Kurabarahalli Milk Society, which is the subject matter of this writ petition.
But you have made only Chikka Kurabarahalli party here.
Yes, that is the only society, my lord. That is the name. Chikka Kurabarahalli Society, Milk Society was the main milk society. Wherein, my lord, the area of operation was in respect of 4 villages.
And you are
By
all
virtue of-
residing in
We are all members of Dodda Kurabarahalli.
Dodda Kurabarahalli.
Yes. But, my lord, thereafter, if your lordships could kindly see page, my lord, 30, page 30. My lord, there was an amendment to the bylaw wherein, my lord, these 2 villages who had requested for a separate milk union, they were excluded, and there is this Dodda Kurabarahalli and Chikka Kurabarahalli continued with regard to the area of operation. Now, my lord, the effect of amalgamation or the division of a cooperative society under section 14, it will not take away the membership right unless and until, my lord, the procedure that is contemplated under section 14 of the act, wherein, my lord, the membership, if they make a request to change of membership, my lord, then only it can be taken away. Thereafter, after 1998, till 2003, when the elections were held again, my lord, there were nearly 4 elections, wherein the members were nearly 116. If my lord could kindly, may I persuade your lordships to kindly look into the audit report, wherein, my lord, the total number of members are indicated. May I directly take your lordships to page 45, my lord, page 45. The society which is subject to an audit, wherein, my lord, the total number of members are indicated at page 50. May I request your lordships to kindly take page 50, my lord? Page 50.
Yes.
Baga 2, if my lords could, at tabular column, page tabular column 13, 1-3.
Yes.
The total ವರ್ಷ ಆರಂಭದಲ್ಲಿ ಇದ್ದ ಸದಸ್ಯರು 116, ಹಿಂದಿನ ಸಾಲು 116. That is the total number of members. Now, once again, may I request your lordships to kindly look into page 58. That is the next audit. Page 58. Total number of members are 116.
Yes.
Once again, my lord, page 69 may kindly be looked into, page 69. Again, in the same column, my lord, 116. Till 2023, my lord, the members of Chikka Kuruparalli as well as Dodda Kuruparalli are the members, and their names were reflected in the eligible voter list as well as the membership list.
Yes.
My lord, if my lords could kindly turn to page 72. Page 72.
Yes.
My lord, this is the total number of members list, Sherudara Patti. May I request your lordships to kindly turn to page 78.
160 ಆದ್ರು.
160 ಆದ್ರು. 160 ಅಲ್ಲಿ ಕೆಲವರು ineligible members ಇದು separate list ಮಾಡಿದ್ದಾರೆ, ಅದನ್ನು ತೆಗೆದಿದ್ದಾರೆ. My lord, thereafter there was an election in the year 2023. May I request your lordships to kindly, my lord, my lord, there were some disturbances in the election due to want of quorum. A special officer was appointed. Your lordships would find at page, my lord, 87.
Yes.
Page 87. This is an order passed under section 31 subclause 1, wherein for want of quorums, may I read the prastavane, my lord? Chikka Kuruparalli ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘ ಹೇರೋಹಳ್ಳಿ ಹುಬ್ಳಿ ಕನಕಪುರ ತಾಲೂಕು ಇವರ ಆಡಳಿತ ಮಂಡಳಿಗೆ ದಿನಾಂಕ 6/9/2023 ಚುನಾವಣೆ ನಡೆಸಲಾಗಿದ್ದು 12 ನಿರ್ದೇಶಕರು ಅವಿರೋಧವಾಗಿ ಆಯ್ಕೆಯಾಗಿರುತ್ತಾರೆ. ದಿನಾಂಕ 7/9/2023 ರಂದು ಸಂಘದ 7 ನಿರ್ದೇಶಕರು ಸ್ವ ಇಚ್ಛೆಯಿಂದ ರಾಜೀನಾಮೆ ನೀಡಿದ್ದು, ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿಯಲ್ಲಿ ಕೋರಂ ಕೊರತೆ ಉಂಟಾಗಿರುತ್ತದೆ. ಈ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಸಂಘದ ಆಡಳಿತ ಮಂಡಳಿ ಸ್ಥಾನದಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘದ ಅಧಿನಿಯಮ 1959 ಪ್ರಕರಣ 31 ಅನ್ವಯ ಸಂಘಕ್ಕೆ ವಿಶೇಷಾಧಿಕಾರಿಯನ್ನು ನೇಮಕ ಮಾಡಲು ಕೋರಿರುತ್ತದೆ. ಈ ಆದೇಶದಲ್ಲಿ so by virtue of an order dated 3/10/2023 invoking the provisions of section 31, my lord, the special officer was appointed.
Yes.
Now, this special officer, my lord, thereafter, some of the members approached this honorable court by filing a writ petition, seeking a direction to the special officer to hold an election. Your lordships would find at page 93. Page 93. My lord, there is an order by this honorable court, wherein this honorable court directs to hold an election. My lord, page 98. Writ petition is allowed. Returning officer is directed to issue a calendar of events and conduct the election on or before 7/3/2025. The process to be started from where it has been interrupted. It is needless to observe that the election process to be continued as per the amended bylaw. My lord, the election which was obstructed or which was not conducted, my lord, in that election my name was reflected in the electoral list as an eligible voter. Now, my lord, this CEO along with this special officer and returning officer, my lord, they restrict the numbers of members now to only 60. If my lord could kindly peruse page 91.
91 ಅಂದ್ರೆ ಹಿಂದೆ ಹೋಗುತ್ತೆ.
ಅದೇ ಹಿಂದೆ page 91. My lord, only 60 eligible voters are finding their names in the list, and the reason for exclusion of these petitioners is not forthcoming. No notice has been issued. my lord, if at all they contend that, my lord, due to the division of the cooperative society under section 14, my lord, the procedure that has been contemplated, and that too, my lord, due to efflux of time, 1998 amendment, till 2023, my lord, we have been participating in the election. Now, all of a sudden, without reason, without notice, my lord, this we have been excluded from the eligible voters list.
Are you participating in the elections in the other, what is the other society which has been formed
My
now?
lord, we are not members in that society.
What is that society?
My lord, that is a milk union, milk society, my lord, where in the name of their name, the village name, it is taken place. Dodda Korobrahalli, my lord, there is no milk society. We are part of Chikka Korobrahalli society only. Dodda Korobrahalli as well as Chikka Korobrahalli.
Bifurcation ಆದ್ಮೇಲೆ ಇನ್ನೇನು ಆ society ಹೆಸರೇನು?
ಅದು, my lord, your lordship me.
ಅದು ಎಬ್ಬಿದರ ಮೆಟ್ಟಲು ಬನ್ನಿಕುಪ್ಪೆ.
ಹೆಬ್ಬಿದರ ಮೆಟ್ಲು ಬನ್ನಿಕುಪ್ಪೆ.
ಅದರಲ್ಲಿ you are not participating?
No. We are not members of that society. We continue to be in the Chikka Korobrahalli society. There is no dispute to that effect also, my lord, because 1998 till 2023, for a period of 25 years, we have been members, we have been casting vote, we have been contesting.
Our question was very simple, Ms. Shetty, whether are you a member of Ebbadara Metlu?
No, my lord. We are not the members of that society.
Yes. Anything else?
My lord, may I add on one submission to that? If their contention on the ground that, my lord, there is an area of operation is restricted to one village, that is Chikkakorabrahalli, as per the amended bylaw. My lord, whether the bifurcation of the society will take away the right of a member who is an existing member, unless that is where the procedures that are contemplated under section 14 is followed, and their names are deleted by issuing notice. That would be my added submission, my lord, because I continue to be the member.
Yes. Yes. Who is? You are appearing. Yes, Mr. Rajgopal.
85, 86. The society was registered. The date when it registered, my lord, it having an area of operation with respect of 4 villages.
Chikkakuruburalli, Dodkuruburalli, Ebbadara Metlu, and Banikuppe.
In 1998, it is not bifurcation. We amended the bylaw. And by virtue of the amendment of bylaw, 3 villages are concerned, it's put outside the area of operation of the present society. Those societies are Chikkakuruburalli, Doddakuruburalli, Ebbadara Metlu, Banikuppe. Now, Chikkakuruburalli is only society having an area of operation. All other 3 societies are now outside of the area of operation of the society. Let me kindly go to 30 minutes. Their own document I would like to establish.
Where are the petitioners residing?
They are with Chikkakuruburalli.
Chikkakuruburalli.
Yes.
Your area? The area of operation in Nimdu? Doddakuruburalli. But your name is Chikkakuruburalli.
Namdi Chikkakuruburalli, out to Doddakuruburalli.
Mr. Shetty, where are you residing, all the petitioners?
Doddakuruburalli.
Doddakuruburalli, my lord.
Doddakuruburalli, yes.
I kindly go to page 30 for a moment.
30.
Their own document I wanted.
Yes.
The general body resolution of 1998. Last is Khali Iddante at the heading. Khali Iddante, Sangada Karyavyapti, Chikkakuruburalli, Doddakuruburalli, Ebbadara Metlu, Banikuppe. Page 30 minutes.
Yes.
ಪಕ್ಕದೊಳಗೆ ತಿದ್ದುಪಡಿ ಆದ ನಂತರ ಚಿಕ್ಕಕುರುಬರಹಳ್ಳಿ ಗ್ರಾಮ. This is then my lord, your lordship page and this is their own document I wanted to demonstrate. But I may kindly go to page 37. After commented what is the Bible at page 37, column number 5. Page 37.
Yes.
ಸಂಘದ ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಚಿಕ್ಕಕುರುಬರಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸೀಮಿತವಾಗಿರುತ್ತದೆ. Forum number 5. They wanted to put up a contention that these 2 villages are not 2 separate villages, which are commonly known as Kurubarahalli. Therefore, they rely upon the entry in the revenue record. That is the next document we refer to. RTC ಹಾಕಿದ್ದಾರೆ.
Kuruburalli, Eravalli.
Eravalli Hobli, Korobrahalli village.
contest that, they wanted to contest that, Kurubarali one day, they are there. Then when I was office make IBC, the audit report, page 66 make IBC, 65. 23-24 audit report.
Yes.
I column number 4. Kandala Karya Kshetra, Upaniyama Sankhya and Visi. Kandala Karya Apti Upaniyama Sankhya, either Muda, Yanda, Muda, Ramaya.
ಎಲ್ಲಿ ಓದ್ತಾ ಇದ್ದೀರಾ?
65.
65.
Baba one audit report of computer.
Yes. Yes. ಸಂಘದ ಹೆಸರು ಕಾಲಮ್ ನಂಬರ್ ಸಂಘದ ಕಾರ್ಯಕ್ಷೇತ್ರ
Kandala Upaniyama Sankhya and Visi.
ಚಿಕ್ಕ ಕುರುಬ್ರಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಮಾತ್ರ.
Then we not even office then.
But then why did you have 116 people there?
In this case, my lord, especially, there is a serious intelligence by the officers. They are imposing these restrictions upon the society to make these persons included in the voters list. That is the reason, Lord, when the election was had to be conducted, a galata had taken place. Election was postponed for that reason. Then we not want a surprising.
What society is this? Milk producers.
Milk producers cooperatives.
Are they supplying milk to your society?
Yes, my lord.
Supply the milk not necessary for the member. Ultimately, my submission is, Lord, so far as voting is concerned, persons who are the shareholders and members, they alone in the members of the society. There are by virtue of the amendment of bylaw, whether they cease to be the members of the society, they cannot become the voters of the society. May that is the structure of the cooperative society start for a moment. The candy scheme in section 16 of the cooperative society.
Yes.
Below section 16, subsection 1. Subject to the provisions of section 17, no person shall be admitted as a member of the cooperative society except following name the clause A. An individual who needs the services of such cooperative society and is residing in the area of aforesaid society and is competent to enter into a contract under section 1870. General section 17 may kindly be seen for a moment. Blood 17, disqualification for membership. Clause E, who is not eligible for membership under section 16.
So not resident of.
Not resident. Then may kindly see how a adjudicating process is also provided. May kindly go to subsection 2. If a member becomes subject to any of the disqualifications specified in subsection 1, he shall be deemed to have ceased to be the member from date when disqualification was incurred. It's a deeming provision. Then 2A may continue to see. If any person is found to be a member or continuing as a member in both more cooperative society, that is another ineligibility. Subsection 3 is important. If any question arises as to whether a member is deemed to have ceased or has ceased to be a member under subsection 2 or 2A, registrar may either so moto or on a report made to him, giving an opportunity he has to decide.
Yes.
So suppose if there's a dispute between me and themselves, if their friends are a member of the society, I say you deemed to be because he used to be the member because of the deemed provision. Bylaw was amended, area of operation is excluded. So far as your village is concerned, you cease to be the member. Therefore, you are not a member.
They have to go before the registrar.
There is section 18 capital A may kindly be seen. There is one more provision. Capital A.
Yes.
Roman 3. Cessation of membership title. Roman 3 what is disqualification and cessation.
Yes.
Lord, I have got the oldest judgment of our High Court for the another single second. What is the effect of bylaw amendment and other things?
Yes.
That paragraph 6 may kindly be seen. Section 17 subsection 2 of the Act stated, if a member incurs any disqualification specified in subsection 1, he has been deemed to have ceased to be a member from the date when disqualification was incurred. This censure membership will apply in respect of the disqualification mentioned in clause A, B, and C of section 17(1), but say will not apply disqualification mentioned in clause B. Reason is the person is a member of a cooperative society, not eligible to become member of another cooperative carrying the same business. In that way, this is the law of our High Court is confirmed by the division bench. And an appeal to the division in 2005, here Karnataka. Paragraph 5, they extracted section 17. Then para 6 may kindly is. A reading of the aforesaid provision would indicate that person is ineligible for admission to a member of a cooperative society. He has incurred any disqualification as envisaged clause A, B of so and so. For our purposes, clause A, section 70 relevant. If a person is already a member of a cooperative society, carrying business in financial sector, is ineligible for admission as a member. Subsection 2 of section 17 states, if a member is subject to any disqualification specified clause A to B, he shall be deemed to have ceased to be a member from the date when the qualification has occurred. The legislature knowingly has used the expression deemed to deem the person who has acquired the disqualification contemplated under so and so 17 of ineligible to be a member of the society. Right, it is a case what happened was there is an ineligibility to hold membership which similar to cooperative societies. Ex-Melod is the person, the petitioner, who enrolled as a member and two cooperative societies having similar business. That was the subject matter before dissolvement. An argument was deeming provision would be applicable not only for one society. Because of his default, he ceases to be the member for both the cooperative. Ernest Single just said, no. His membership remains with the first society. But he is going to lose his membership because of the second society is concerned. Why it is said so is, after incurring disqualification, he deemed to be ceased to be the member of the society. Which society is a question answer. Ultimately, my submission is, under the scheme of the Act, if a disqualification is noticed, he deemed to be ceased to be the member, their membership proceeds to its session.
We understand your argument on that, but your amendment took place in the year
1998.
1998. ತಪ್ಪು ಮಾಡ್ಬಿಟ್ವಿ ಮತ್ತೆ
Murder is prohibited and IPC still murder is going on. Why it cannot be continued and taken?
Now let us test your argument. 1998, you say deemed to have vacated, deemed to have been disqualified.
Yes.
Because he is not residing in.
Yes, we are not disqualified. The effect of this, that's the reason I wanted to.
ಅದಕ್ಕೆ disqualification we are testing.
One aspect of the matter. We enroll these persons as a member of the society. Then our area of operation society is extended to that limit. Up to 1998. In 1998, bylaw was amended. This bylaw was not installed either by anybody else. It stands because of our amendment. Our area of operation is now restricted to Chikkakurubarahalli village.
Yes.
That is our area.
We understood your argument. That's why we are.
Consistent with the bylaw, it could not revive their membership. They should be thankful to us. We extended some service to them. It doesn't mean that their membership is revived. It is already ceased to be enforced.
Yes. ಆಯ್ತಾ?
It's a matter of consideration. Then,
That is what we are considering.
Lordship said, that very recently this honorable has taken the view, returning officer is directed to complete the election process only in accordance with the amended bylaws of the society.
Yes.
The Lordship may kindly see that order. And council is. And count 30.
Yeah.
Page 14 annexure article. Page 14 annexure article.
Yes. Counter Allah.
Lords may kindly take it, page 98, my lord.
Yeah, matter is in page 98.
Page 98. We have also produced that order.
Returning officer is directed to issue calendar of events, conduct the on or before the process to be start from where it was interrupted. Observe that it is continued as per the amended bylaws. So what is? What is the reference in amended bylaws as per the judgment?
My lord, that order came to be passed in a context wherein, my lord, some of the members approached this honorable court seeking a direction to hold the election because special officer was appointed. In that context,
let us ask the questions.
Please, my lord, I'm sorry.
Who were the petitioners who were in one? Who were the petitioners in that petition? Those 60.
Please.
ಅವರೇ ಬಂದ್ಬಿಟ್ಟು ನಮ್ದೇ ಅಮೆಂಡ್ಮೆಂಟ್ ಹೇಳ್ಬಿಟ್ಟು ನಮ್ದೇ ಆರ್ಗ್ಯುಮೆಂಟ್ ತಗೊಂಡು ಅದು ಆರ್ಡರ್ ಮಾಡಿಬಿಟ್ಟು ನಾವು ಆನ್ ದಟ್ ಬೇಸಿಸ್ ಯು ಕೆನಾಟ್ ರಿಲೈ. ಆಯ್ತು.
That election was postponed. Then when are these people consistently emphasizing the registrar to allow them to participate in the election process of Super Kurbalahandi village.
Yes.
Then when are assistant registrar instructed the assistant administrator to convene a special general body meeting among the persons of these two villages, send a report to us.
Yes.
Report is also placed on record.
Yes.
So last week, kindly see the report I wanted to show. Madam, may kindly take my counter.
Yes, clearly. Counter page number.
That is page 11.
11. It's counter, right? Anything. Caveat, counter illama. Counter illa. Writ to caveat to IA. Statement of objections. Yes.
Madam, may kindly go to page number 11.
11.
Annexure article. Reference download. ತಮ್ಮ ಕಚೇರಿಯ ಮೌಖಿಕ ಆದೇಶ ದಿನಾಂಕ 25/11/24. ತಮ್ಮ ಕಚೇರಿಯಿಂದ ಯಾವ ಒಂದು ಸಹಕಾರ ಸಂಘಗಳ ರಾಮನಗರ ಉಪವಿಭಾಗ. What he said is, ಮೇಲ್ಕಂಡ ವಿಷಯ ಮತ್ತು ಉಲ್ಲೇಖಕ್ಕೆ ಸಂಬಂಧಿಸಿದಂತೆ ಮೇಲಿನ ಉಲ್ಲೇಖ ತಮ್ಮ ನಿರ್ದೇಶಕರು ಚಿಕ್ಕಪುರಬರಹಳ್ಳಿ ಹಾಲು ಉತ್ಪಾದನಾ ಸಂಘದಲ್ಲಿ ದೊಡ್ಡಪುರಬರಹಳ್ಳಿ ಗ್ರಾಮದ ಸದಸ್ಯರನ್ನು ಸಂಘದ ಸದಸ್ಯರು ನಿಯುಕ್ತಿಗೊಳಿಸುವ ಬಗ್ಗೆ ಸಂಘದಲ್ಲಿ 2 ಗ್ರಾಮದ ವಿಶೇಷ ಮಹಾಸಭೆಯನ್ನು ಸಂಘದ ವಿಶೇಷಾಧಿಕಾರಿಗಳ ಅಧ್ಯಕ್ಷತೆಯಲ್ಲಿ ಕರೆದು ನಿರ್ಣಯಿಸಿ ಕೈಗೊಳ್ಳುವಂತೆ ನೀಡಿರುವ ತಮ್ಮ ಮೌಖಿಕ ಆದೇಶದಂತೆ ದಿನಾಂಕ 9/12/24 ಸೋಮವಾರ 10:30ಕ್ಕೆ ಸರಿಯಾಗಿ ಸಂಘದ ಆವರಣದಲ್ಲಿ ಸಂಘದ ವಿಶೇಷಾಧಿಕಾರಿಯಾದ ರವೀಂದ್ರ ಅಧ್ಯಕ್ಷ ಸಭೆ ಸೇರಿದ್ದು, ಈ ಸಭೆ ದಿನಾಂಕದಂದು ಸಂಘದ ದಾಖಲೆಗಳ ಪ್ರಕಾರ 112 ಸದಸ್ಯರು ಇರುತ್ತಾರೆ. ಈ ವಿಶೇಷ ಸಭೆಗೆ 100 ಜನ ಸದಸ್ಯರು ಹಾಜರಿದ್ದು ಹಾಜರಿ ಪುಸ್ತಕ ಸಹಿ ಮಾಡಿರುತ್ತಾರೆ. ದೊಡ್ಡ ಕುರುಬರಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ ಸೇರಿದ 40 ಸದಸ್ಯರು, ಚಿಕ್ಕ ಕುರುಬರಹಳ್ಳಿ ಗ್ರಾಮಕ್ಕೆ 60 ಒಳಪಟ್ಟಿರುತ್ತಾರೆ. ವಿಶೇಷ ಮಹಾಸಭೆಯ ಆಹ್ವಾನ ಅದೆಲ್ಲ ಆದ್ಮೇಲೆ ನೆಕ್ಸ್ಟ್ ಪೇಜ್ ತಾವು ನೋಡಿ, ಪ್ಯಾರಾಗ್ರಾಫ್ ಪೇಜ್ 29/11/98 ಮಾನ್ಯ ಸಹಕಾರ ಸಂಘಗಳ ಸಹಾಯಕ ನಿಬಂಧಕ ರಾಮನಗರ ಉಪವಿಭಾಗ ರಾಮನಗರ ಆದೇಶದಂತೆ ಸಂಘದ ಉಪನಿಯಮ 2 ತಿದ್ದುಪಡಿ ಮಾಡಿ ಗಂಜಿಕುಪ್ಪೆ, ಹೆಬ್ಬಳ್ಪಟ್ಟಿರು, ದೊಡ್ಡಕುರುಬಾಳಿ ಗ್ರಾಮಗಳನ್ನು ಸಂಘದ ವ್ಯಾಪ್ತಿಯಿಂದ ಬಿಡುಗಡೆಗೊಳಿಸಲಾಗಿತ್ತು. ಈ ಗಂಜಿಕುಪ್ಪೆ ಮತ್ತು ಹೆಬ್ಬಳಪಟ್ಟಿರು ಗ್ರಾಮಗಳು ಪ್ರತ್ಯೇಕ ಹಾಲು ಉತ್ಪಾದಕ ಸಂಘ ಸ್ಥಾಪನೆಗೊಂಡಿದ್ದು ದೊಡ್ಡ ಕುರುಬನಹಳ್ಳಿ ಗ್ರಾಮದಲ್ಲಿ ಹಾಲು ಉತ್ಪಾದಕ ಸಂಘ ಸ್ಥಾಪಿಸಿದೆ. ಚಿಕ್ಕ ಕುರುಬನಹಳ್ಳಿ ಹಾಲನ್ನು ಪೂರೈಸುತ್ತಿದ್ದು ಹಿಂದಿನ ಸಾಲಗಳ ಆಡಳಿತ ಮಂಡಳಿ ಸದರಿ ಗ್ರಾಮದ ಭಿನ್ನಾಭಿಪ್ರಾಯ ಉದ್ಭವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ದೊಡ್ಡ ಕುರುಬನಹಳ್ಳಿ ಗ್ರಾಮ ಸದಸ್ಯರನ್ನು ಅರ್ಹ ಮತದಾರರ ಪಟ್ಟಿಯಿಂದ ಬೇರ್ಪಡಿಸಿ ಚುನಾವಣೆ ಪ್ರಕ್ರಿಯೆ ಕೈಗೊಂಡಿರುವುದನ್ನು ದೊಡ್ಡ ಕುರುಬನಹಳ್ಳಿ ಗ್ರಾಮಸ್ಥರು ಆಕ್ಷೇಪ ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾರೆ. ಈ ಕಾಂಟೆಕ್ಸ್ಟ್ ಅಲ್ಲಿ ಈ ಸೆಟ್ ಇವರು ಮೆಂಬರ್ ಹೌದು, ನೀವು ಅವ್ರನ್ನ ಎನ್ರೋಲ್ ಮಾಡ್ಕೊಂಡು ಅವ್ರಿಗೆ ವೋಟಿಂಗ್ ರೈಟ್ ಕೊಡಿ ಅಂತ ಈ ಪಾಸ್ಗೆ ರೆಸಲ್ಯೂಷನ್. ನಾನು ರಿಪಿಟಿಷನ್ ಏನಕ್ಕೆ ಹಾಕ್ತೆ, ಏನ್ ಪ್ರೇಯರ್ ಕೇಳಿದೆ ಅಂದ್ರೆ ನನ್ನ ತಗೊಳ್ಳಿ.
Without making them a party. You are restricting, you are ousting them without making them a party.
For me, they are not members, they are not related to me, they are not shareholders.
Howdu.
That's a player I sought for. If you lot him make, I see the player. Election ಮಾಡ್ಕೊಂತ ಇಲ್ಲೇ ಬಂದ್ರು, ಏನೋ ಆರ್ಟಿಫಿಷಿಯಲ್ ಆಗಿ ಮಾಡಿದ್ರು ಅನ್ನೋದಲ್ಲ.
Yes, we are seeing where it is interrupted in view of the calendar of events dated so and so, in view of the mandate of the government order dated so and so. Is your prayer.
Complete the election process, enable to conduct the elected body by way of democratical correspondence society without being influenced by the letter correspondence interstate between 1, 2 to 4 dated 19/12/2024 as per annexure L. This prayer I insisted at the time of disposing of the repetition. Therefore, lawsuit said election should be completed by virtue of the bylaw of the society.
Without making them a party.
They are not our.
That is what you are saying.
It's a matter of record.
That is what now we are. Yes, now can you hear our, Mr. Rajagopal, now can you hear our question? You have argued, same thing you are repeating now. So now you answer our question first. Now you are referred to section 16. 16 only who can be a member. That is a pre-qualification at the time of membership. Now fact remains that you have made them members. They were members. Now you are saying that they became disqualified. ಅದೇ ಹೇಳ್ತಾ ಇರೋದು ನೀವು. ಆಪರೇಷನ್ ಆಫ್ ಲಾನೇ ನೀವು ಹೇಳ್ತಾ ಇರೋದು.
This period is excluded from the area of operation of our society.
Yes.
Therefore, they would not continue to become the members of our society. It is an operation law. It is not necessary I have to disqualify this. Because of this amendment, keyword provision which comes into picture.
That's what you contend.
It's not taken support from the law.
Yes. We'll deal with that.
Yes.
Third, petitioner is before this court. Petitioners are before this court, seeking for the following reliefs. Initially, the fifth respondent society, which is a milk producers cooperative society, had been established for carrying on its business in Chikkakuruburalli, Doddakuruburalli, Yebbadara Metlu, and Banikuppe, and had enrolled members from each of the said villages. Subsequently, on 28/8/1998, an amendment was carried out by virtue of which the area of operation of the fifth respondent cooperative society was restricted to Chikkakuruburalli, only. However, the membership continued as is and was reflected in the balance sheets, and elections were held in persons thereto post 1998 till the year 2023. In the year 2023, the names of the petitioners were deleted from the list of eligible members. A list of eligible members was published without the names of the petitioners being included in the said list. It is challenging same the petitioners are before this court, contending that the petitioners are also members and their names need to be included in the eligible voters list, in addition to the 60 eligible voters as approved by a second respondent at Annexure L. The submission of Shri Mahesh Kiran Shetty, learned counsel for the petitioner, is that though by amendment in the year 1998, the operation of the activities of the society were restricted to Chikkuruburalli, not only were the petitioners continued as members of the society, but also the petitioners were supplying milk to the fifth respondent society, which has been accepted by the fifth respondent society. The petitioners have participated in all the elections post 1998 until now, and as such, the deletion of their names could not have occurred without even as much as issuing a notice to them. His submission is that there cannot be a removal of the petitioners' names without following the principles of natural justice. He also relies on Section 14 of the Karnataka Cooperative Societies Act 1959 to contend that if at all there was any division of the cooperative societies, the procedure under Section 14 would have to be followed. Shri M. R. Rajagopal, Senior Counsel appearing for respondent number 4, would submit that post the amendment on 28/8/1998, the area of operation of the fifth respondent being restricted to Chikkuruburalli, any person who is not resident of Chikkuruburalli was automatically disqualified from being a member.
They incur ineligibility to become a member of the society.
Disqualified from being a member of the fifth respondent society on account of having incurred ineligibility for being a member in terms of Section 16 of the Act of 1959. His submission is that it is only an individual who needs the service of such cooperative society and is residing in the area of the operation of society and is competent to enter into contract under the Contract Act 1872, who could be a member of the society. Now that Dodkuruburalli has been excluded from the area of operation of the society, fifth respondent society, a person residing in Dodkuruburalli cannot be a member of the fifth respondent society. And in this regard, he relies upon Section 17, subclause E of subsection 1 of Section 17, to contend that no person shall be eligible for admission as a member of the cooperative society if he is not eligible for membership under Section 16. This, he submits, is an automatic disqualification which occurs after the amendment on 28/8/1998. Since post that date, the person who was not residing within the jurisdiction of Chikkuruburalli became ineligible to become a member. ಒಂದೊಂದೇ ಇದು ಮುಗಿಸೋಣ. We'll deal with all your submissions. ಅದಾದ್ಮೇಲೆ ಏನು ಮಾಡಿಲ್ಲ ಅಂದ್ರೆ ಹೇಳಿ, ಅದನ್ನು ಡೀಲ್ ಮಾಡೋಣ. ಅಲ್ಲ, ಒಂದೊಂದ್ಸತಿ ಮಿಸ್ ಆಗತ್ತೆ, ಅದು ಹೇಳಿ. Not for member. Some you succeed, some you don't, Mr. Rajagopal. Can't tell it. Not eligible for membership under Section 16. He also relies upon Section 18, capital A, to contend that a person shall cease to be a member of a cooperative society in terms of clause Roman 3 of subclause A of Section 18, capital A, when he incurs a disqualification and cessation. This he relates to and reads with clause E of subsection 1 of Section 17 and clause A of subsection 1 of Section 16 to contend that firstly, there is no eligibility of membership on part of the petitioners post the amendment on 28/8/1998, since they were members included, they were included as members in view of subsection, clause E of subsection 1 of 17, they became disqualified and they ceased to be a member in terms of clause Roman 3 of clause A of section 18A. In this regard, he relies upon the decision of a coordinate bench of this court dated 5th January 2004 in WP number 35194 of 2003, more particularly para 9 thereof, 6 thereof, which is reproduced hereunder for easy reference. By relying on Lingaraju's case, he submits that once the disqualification occurs, it is automatic, resulting in ineligibility, and therefore the removal of the names of the petitioner from the list of eligible voters is proper and correct. He relies upon the decision of a division bench of this court in ILR 2005, Karnataka 5673, more particularly para 6 thereof, which is reproduced hereunder. By relying on Tumkur grain merchants, either an appeal, appeal. He relies on the said judgment in Lingaraju's case had been taken up on appeal in ILR 2005 Karnataka 5673, and the division bench of this court confirmed the decision of the learned single judge, and in this regard he relies upon para 6 thereof, which is reproduced hereunder for easy reference. By relying on the decision of the division bench of this court, he once again submits that there is a deeming provision under section 17 as regard the disqualification, and that deeming provision kicked in subsequent to the amendment on 28/8/1998. He also relies upon a decision of this court as regards the fifth respondent society in WP number 161 of 2025, dated 14th February 2025, to contend that this court had directed the election process to be continued as per the amended bylaws. And therefore, he submits that since the election is to be as per the amended bylaws, as amended on 28/8/1998, the petitioner cannot be said to be members, let alone eligible members to vote at the election to be carried out. Anything else? Heard, so and so peruse papers. The points that would arise for consideration are: one, whether the petitioners can be said to be persons who are not eligible to become members of the fifth respondent society to respondent society, or in the alternative, are they deemed to have been disqualified in terms of section 17, ceasing to be members under section 18, capital A of the Karnataka Co-op Societies Act 1959. Two, whether the order passed by this court in WP number 161 of
2025.
Dated 14th February 2025, can be pressed into service by the petitioners to contend that the petitioners are ineligible and they are ineligible to participate in the elections. 3, what order? The references made by Shri M.R. Rajgopal and Senior Counsel as regards section 16, 17 and 18 have been placed here and above. What would be required to be referred to is the amendment which occurred to clause A of subsection 1 of section 16 on 11/2/2013. It is by virtue of the said amendment that the words, inverted commas, and is residing in the area of the operation of the society were included with effect from 11/2/2013. These words were not in existence prior to that date. Admittedly, the petitioner Fifth Respondent Society had been established long ago and the amendment was carried out on 28/8/1998. As on 28/8/1998, admittedly, the petitioners were members of the Fifth Respondent Society and there was no restriction on a person who is not residing in the area to be a member of the society in terms of Clause A of subsection 1 of Section 16, which came to be added, which restriction came to be included only on 11/2/2013. Thus, insofar as the present case is concerned, the date on which the petitioners became members of the Fifth Respondent Society, there was no qualification of the petitioners to be members residing in the area of operation of the society. Even post the amendment in the year 1998, till 2013, the requirement was not, the requirement was not present due to the amendment having come into force only on 11/2/2013. Thus, it cannot be contended that from the date of the amendment on 28/8/1998, the petitioners became ineligible and or became disqualified and or ceased to be members of the petitioner society post the amendment dated 28/8/1998, since the eligibility criteria under Clause A of subsection 1 of Section 16 did not require it to be so. Thereby, the operation of Clause E of subsection 1 of Section 17 would not have occurred on 28/8/1998, bringing into force the disqualification under Clause 3 of subclause 3, Roman 3 of Clause A of Section 18, capital A. If at all, it can only be contended by the Fifth Respondent Society that this ineligibility came into force on 11/2/2013. The amendment which has been brought in is by way of insertion and not by way of substitution. Therefore, the inserted provision would only be prospective in nature and not retrospective in nature. And as such, the requirement of eligibility would not be made retrospective insofar as the petitioner society, the Fifth Respondent Society is concerned for the provision of 17 and 18 capital A to be made applicable to the petitioners. In that view of the matter, I answer point number 1 by holding that the petitioners, having been members of the society prior to the amendment, having been members of the society on the date of the amendment, and continuing to be members of the society thereafter, when there was no ineligibility in terms of Clause A of subsection 1 of Section 16, they would continue to be members even as on today. And the disqualification under Section 17 and cessation of membership under Section 18 capital A would not be applicable insofar as the petitioners are concerned. Answer to point number 2. The submission of Sri Rajgopal and its senior counsel is that in view of the orders which have been passed in WP number 161 of 2025, the elections are to be held as per the amended bylaws. On inquiry as to who the petitioners were in the said petition, it is submitted that those are the persons who are residing in Chikkakuruburalli, who are the eligible members post the amendment on 28/8/1998. If that be so, the so-called eligible members had not made the so-called ineligible members a party to the said proceedings, and the order passed is behind the back of the petitioners who are not parties thereto. Hence, the said order, in my considered opinion, cannot be made use of against the petitioners who had not been notified about the said order. Impleading application there.
That is not.
That
That is not considered.
dismiss
It is not dismissed. Your Honor may kindly see page 90.
My lord, in view of the disposal of the writ petition, IAs were not considered
IAs
for
do not survive
consideration
for
and
consideration.
would not survive for consideration.
That is the
consideration.
observation.
Lord, there they opposed our IA.
They cannot be held to be applicable to the petitioners. Though it is contended that the petitioners had filed a impleading application, the said implementing application was held not to survive or in view of the disposal of the petition. Be that as it may, as held supra, even as per the amended bylaws, the petitioners would continue to be members and cannot be said to be ineligible, disqualified, or cease to be members of fifth respondent society, and as such, fourth respondent. ಇದುವರೆಗೂ ಎಲ್ಲ ಫಿಫ್ತ್ ಹೇಳಿದೀವಲ್ರಿ ಎಲ್ಲ ಫೋರ್ತ್ ಎಲ್ಲ ಫಿಫ್ತ್ ಮಾಡಿ ಫಿಫ್ತ್ ಎಲ್ಲ ಫೋರ್ತ್ secretary fourth respondent. Hence, even on that ground, the said order dated 14th February 2025, insofar as the membership of the petitioner is concerned, would not be applicable. In that view of the matter, I pass the following order. Writ petition is allowed. A mandamus is issued directing the respondent number
4, my lord, 4 returning officer.
2 and 4.
respondent number 4 to include the names of the petitioners in the eligible voters list. Include subject to the eligibility under section 13 under rule 13D2A. ಅದೇ ಅಲ್ವಾ ಅದಕ್ಕೆ rule 20 ಅದೇ it refers to, and section 20 A4 and A5 within a period of 15 days from the date of receipt of copy of this order, and thereafter
Election is scheduled on 18th. 18/3 is the election.
within a period of 1 week from the date of this order. You have only created this problem. So your election illa.
9th is the nomination ballots.
Your election will be postponed.
Please.
Please.
After, include the name of the petitioner after compliance with rule 13D of the so-and-so rules 1959.
1960.
Needless to say, in terms of timeframes fixed therein, needless to say, until then the elections cannot be held. You again special officer idara. Until then, the administrator shall continue to perform his role and duties.
Please, madam. We're grateful.
This will be successful somewhere else when you will use the same order.
Serial number 26. Manjunath Eshwar J. and connected matters.
I am appealing for petitioners 26 and 26-1, your lordship.
26.
I have taken specific contention that the fourth respondent society has not complied rule 13D.
In what portion of it? What has not been complied?
Rule 13D is not been complied with.
13D ಅಲ್ಲಿ 12 item ಇದೆ.
2A, your lord.
2A ಅಲ್ಲಿ 12 item ಇದೆ.
Sorry. Notice have not been issued prior to 190 days, your lordship.
Yes, who appears CEO. ಏನ್ ಡಾಕ್ಯುಮೆಂಟ್ ಏನಿದೆ? ಯಾವತ್ತು? Not 8 months, 6 months. Why you did not issue before 6 months? So ಇದೆಲ್ಲ 26.123 1 and 2 same, huh?
Yes, your lord.
3/125.
Yes, sir.
We'll direct you to take action against the CE.
According to the Millard in 36 Millard, the only members.
Mr. Reddy, notice under clause 2 of subsection 2A was issued only on 3/125.
Then has resigned in the month of October, and thereafter vice president and some other members have resigned, and they created a vacuum and special officer was appointed.
ಏನ್ ಎಲೆಕ್ಷನ್ ಆದ್ರೇನು it has to be as per that. Prior to 6 months. Until then, administrative will continue. ನೀವು ಕಿತ್ತಾಡಿದ್ರೆ administrative will get in. ನೀವು ಕಿತ್ತಾಡಬೇಡಿ, you will be there. ಆಯ್ತು, now it will have to be redone.
Election has been done, Your Lordship. As per the interim order, we have casted our vote. It has to be counted, Your Lordship. The result has to be declared.
The intention of the law is very clear. The 13D notice if given to the members, if any objections, my lord, they come before the.
ಇವ್ರು notice ಕೊಡ್ತಾ ಇಲ್ವಲ್ಲ.
That is, he say that, my lord, now ಎಲ್ಲ election ಅವರೆಲ್ಲ reason ಮಾಡ್ಬಿಟ್ಟಿದ್ರು, ಮಾಡ್ಲಿಕ್ಕೆ ಆಗಲ್ಲ ಅಂತ ಹೇಳಿ.
ಅವ್ರ vote ಎಲ್ಲ use ಮಾಡಿ, that's all. Now you take action against this earlier CO. At that time was supposed to issue. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioners is that the petitioners were included in the list of ineligible voters without compliance with clause 2 of
13D.
clause Roman 2 of Rule 2 capital A of Rule 13D of the Karnataka Cooperative Societies Rules 1960. Inasmuch as no prior notice of 6 months by register post had been issued to the petitioners. Learned counsel for respond number 4. On inquiry, submit that notice had been issued on 3/1/2025 by register post. Even if the said submission were to be accepted, the elections having been held on 4/2/2025, the notices have not been issued 6 months prior. Hence, the question of including the names of the petitioners in the ineligible list would not arise. This court-wide order dated 1/2/2025 has permitted the petitioner to cast their vote in the election subject to the outcome of this petition. The petitioners have cast their vote and the same have been kept in a separate ballot box.
Yes, sir.
In view of my finding that the petitioners could not be held to be ineligible voters without compliance with the aforesaid requirements, I pass the following order. Petition is partly allowed. The respondents are respond number 5. He is directed to announce the result of the election by taking into account the votes of the petitioners, by counting the votes of the petitioners and announcing the result within a period of 7 days from today, subject to there being no other injunction in any other proceedings. Respond number 1 and 2 are directed to take necessary action against the Chief Executive Officer of respond number 4 for non-compliance with the requirements of Rule 13D of the rules of so and so. A report to that effect to be filed within a period of 4 weeks from today. In all the above matters, 26. 75.
For impedance.
Pending IAS do not survive for consideration.
7.
I appear for petitioner, my lord.
Yes, idralenu.
ಇದರಲ್ಲಿ 13D2 is not complied.
ಯಾವುದು again no 6 months.
No, 6 months notice is not issued.
ಯಾರು?
Society, appear for the society. We have not complied with the.
Not complied. Very nice, very proud. ಯಾಕೆ ನೀವು ಮಾಡಲ್ಲ ಇದು? ಇವ್ರಿಗೂ ಒಂದು ಸರ್ಟಿಫಿಕೇಟ್ ಕೊಟ್ಬಿಟ್ಟು. ಸೇಮ್ ಆರ್ಡರ್. ಡೇಟ್ಸ್ ಮಾತ್ರ ಚೇಂಜ್ ಮಾಡ್ಕೊಳ್ಳಿ. Election date is 23/2/25. Respond number 4 is directed to announce the result. 1 is directed to take action.
Impleading.
One of the member of the.
Does not survive for consideration.
28. Sandesh Didi.
The petitioner is a society, my lords, the authority has passed an order under section 6310 to redo the audit of the society for the year, my lords, 2021, my lords. In the meanwhile, my lords, the Assistant Registrar of Cooperative Societies has passed an order for conducting the 64 inquiry against the society, my lords. My grievance is that, my lords, once the re-audit order passed madidmele, so after the finishing of the re-audit, my lords, then they have conducted the 64 inquiry, my lords, because the entire allegation is that, my lords,
Is there any prohibition for that?
not prohibition, my lords, the re-audit ಮಾಡಿದ ಮೇಲೆ they have to conduct the 64 inquiry because the entire allegation
Parallelly ಆದ್ರೆ ಏನಂತೆ?
ಅಲ್ಲ ಪ್ಯಾರಲಲ್ಲಿ ಮಾಡೋದಕ್ಕೆ ಸಮಸ್ಯೆ ಏನು ಅಂತ ಅಂದ್ರೆ
ನಾವು ಸ್ವಲ್ಪ ಪುಷ್ ಮಾಡಕ್ಕಾಗಲ್ಲ.
ಅಲ್ಲ ಹಾಗಲ್ಲ 63 ಅಲ್ಲಿ ಆಡಿಟ್ ಆದ್ಮೇಲೆ ಬೇಸ್ಡ್ ಆನ್ ದಿ ಆಡಿಟ್ ಮೇಲೆ ದೇ ಹ್ಯಾವ್ ಟು ಕಂಡಕ್ಟ್ ದಿ 64 ಎನ್ಕ್ವೈರಿ.
Not on the basis of audit. If there is any discrepancy, they can conduct.
Please.
ಅಲ್ಲ ಡಿಸ್ಕ್ರಿಪ್ಷನ್ಸ್ ಬಟ್
Not on the basis of audit.
ಅಲ್ಲ ಆಡಿಟ್ ರಿಪೋರ್ಟ್ ಏನ್ ಬರುತ್ತೆ ದಟ್ ಆನ್ ದಟ್ ಬೇಸಿಸ್ ಮೇಲೆ ದೇ ಹ್ಯಾವ್ ಟು ಕಂಡಕ್ಟ್ ದಿ 64 ಎನ್ಕ್ವೈರಿ.
You have to be open for all of this. No.
ಅಲ್ಲ ಸೈಮಲ್ಟೇನಿಯಸ್ಲಿ ಎರಡು ಮಾಡೋದಕ್ಕೆ ಬರಲ್ಲ ಐದರ್ 60
ಮಾಡಕ್ ಬರಲ್ಲ ಅಂತ ಎಲ್ಲಿದೆ ಹೇಳಿ?
ಅಲ್ಲ there is no bar in the act, my lords, but
That we won't accept.
in the normal circumstances, my lords, 63 is the first.
Fund cooperative societies, you function properly, no problem. If you're not functioning properly, they'll take action.
Kindly see the allegations, my lords, all the 64 and the 63, all and the one and the same, my lords. Therefore, my lords, 63 first, ಆದ್ಮೇಲೆ ಬೇಕಿದ್ರೆ 64 ಮಾಡ್ಲಿ ಅಂತ.
63 scope ಬೇರೆ, 64 scope ಬೇರೆ.
Please.
63 scope ಏನ್ ಹೇಳಿ?
63 is the audit of the society.
ಅಷ್ಟೇ.
Now the audit of the society have not conduct properly, therefore the authority have passed an order to conduct the re-audit. Now that.
So that doesn't absolve you from any liability under 64 inquiry.
ಅಲ್ಲ re-audit ಆದ್ಮೇಲೆ ಮಾಡಿದ್ರೆ better.
Does it absolve you from any 64 inquiry?
ಅಲ್ಲ in the 64 inquiry, my lords, in the allegations on 2021 ನಲ್ಲೂ ಕೂಡ ಈ ರೀತಿ ಆಗಿದೆ, so therefore we conduct the 64 inquiry. Once we finish the 63
Next year ಮತ್ತೆ ಹಂಗೆ ಮಾಡ್ತೀವಿ ಅಂತ.
ಅಲ್ಲ re-audit ಆದ್ಮೇಲೆ ಮಾಡ್ಲಿ ಅಂತ, therefore, my lords.
Not necessary.
I am not against the 64 inquiry, my lords. Once they finish the 63 audit.
DGA accepts notice for respond number 1 to 4. Petitioner is before this court seeking for the following reliefs. The grievance of the petitioner is that a notice of inquiry under section 64 has been ordered by respond number 3, Assistant Registrar of Cooperative Societies on 26/9/2024 at Annexure B, when a re-audit had already been ordered on 25/10/2023 at Annexure A. The submission of Shri Sandesh TB, learned counsel for the petitioner, is that both a re-audit under section 63 and an inquiry under section
63 under
64.
section 6310, my lords.
6310 and a inquiry under section 64 cannot be carried out simultaneously. Section 60, subsection 10 of section 63 is reproduced hereunder for easy reference. A perusal of the said provision would indicate that defects having been pointed out in the audit carried, a notice or an order could have been passed for correcting the said defects. Section 64 is reproduced hereunder for easy reference. Section 64 relates to an inquiry to be conducted by the registrar or any person of his own motion, by himself or by a person authorized by him, as regards the matters touching the constitution, working and financial condition of the cooperative society. The inquiry under section 64 is a larger inquiry as regards the constitution, working and financial condition of the cooperative society, whereas a re-audit under subsection 10 of section 63 is only for correcting the defects and or rectifying the defects in the audit report already filed. Thus, I am the considered opinion that pending the re-audit under subsection 10 of 63, the inquiry under section 64 cannot be interdicted. In that view of the matter, no grounds being made out, the petition stands dismissed at the stage of admission itself.
30 board matter. Kantaraju CS.
Voting, your cooperative society.
And AGA accepts notice for respond number 134. TL Kiran Kumar for respond number 2. Issue emergent notice to respond number 5 written out by 3rd April. Counsel for the petitioner is also directed to take out handsomers to respond number 5. Voting rights, same order. Process fee and purpose.
Kindly permit the and.
And delivery. Sir, one day na?
75. 75.
Chandan or the court or date court cuts were. When do you want it? How long will you take?
Lord, it's for me to conclude the arguments. He has actually concluded.
You wanted to recap and then ಹೇಳಿದ್ರಿ. Recap is 15. Right.
I would take some time, my lord, because
ಎಷ್ಟು ಹೇಳಿ?
maybe around 1.5 2 hours. Maybe post lunch on it would be
2
easy,
hours.
because it's quite a bit your lordship is aware of it. 14 should be fine, my lord, if your lordship is okay.
14th will all these things be going on. We'll have it on 24th, 17th or 24th.
24th is fine, my lord. 17th, I'm having some inconvenience.
ಬೇರೆ ಏನು ಹಾಕೊಂಡ್ಬಿಡಿ ಅವತ್ತು. ನಾವು ಹೇಳಿದ್ರೇನು ಹೇಳ್ಬಿಡಿ. 24th at 2:30 PM.
At 2:30, my lord, the interim order may be extended.
Interim order earlier.
And my lord, one.
We'll deal with and dispose of the matter.
Let them not interfere, my lord. ಬಂದಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ? The problem here is ಎಲ್ಲರಿಗೂ ತೊಂದರೆ ಕೊಡೋದು ಅಲ್ಲಿರೋರು.
Statement has been made by the additional advocate general, so we'll.
No, ಇವ್ರ ಪಾಪ ಹೇಳ್ತಾರೆ, but there they do not follow that. That's the problem.
ನೀವು ರಿಟರ್ನ್ submission ಎಲ್ಲ ಮಾಡಿ ಬೇಗ ಹಾಕಿ. You 2 hours.
Everything is ready, my lord. Actually, we were halfway through in the meantime.
2 hours ಅಂತೆಲ್ಲ I don't think.
I will try to finish it as
That
soon
is
as
requiring 2 hours.
I will try to finish ASAP, my lord.
Yes, ಮಾಡಿ.
Grateful.
75. David Prasad Shetty is selected by.
ಸೋಮವಾರ ಹಿಯರ್ ಮಾಡ್ಬೋದು. ಏನಂದ್ರೆ just I will explain to you.
Yes.
Urgency ಇದೆ ಅಂದ್ರೆ ನಮಗೆ ಏನು ತೊಂದರೆ ಇಲ್ಲ. Contempt ನೊಳಗೆ and other writ of it, they given an undertaking, they have to notify the election in what date we will conduct. Now matter is posted on 25th of March.
23rd of March, they have to give the calendar of events. Before that, we have to pass an order.
Not the calendar of events. I think it is not correct information.
ಅಲ್ಲ ನೀವೇ ಬಸವರಾಜುನೇ ಆರ್ಡರ್ ಕಾಪಿ
What the lordships in the writ appeal said is, you give us a timetable when you are going to conduct the election process. You give the timetable on 25th March.
They can't give it without this matter being
It
disposed.
could be just a Monday. 25th March is somewhere else. About 3 weeks are there.
Mr. Patil, you are also there?
Yes, he is our captain. Therefore, I am following him.
Mutual Appreciation Society.
A term of committee was about to expire.
Already there. Ready.
Please,
Yes.
term of the committee was about to expire. Election calendar, etc. was not
Other
published.
matters will not reach properly. You can leave. No need to wait. ಎಲ್ಲ ಡೇಟ್ ಕೊಡ್ತಾರೆ.
Serial number, my lords, 101. Application for vacating stay is there by mistake, they have posted it in B group.
Yeah.
The urgency is this, my lords, so now
If you have
administrative.
urgency, you can wait till
I'll wait.
this gets over, then we'll give you a date. Until
I'll
then,
wait.
let's not disturb Mr. Patil.
Surprise, Tuesday, Monday or Tuesday,
It will be coming only on 14th.
14th, out of Bangalore. So at least
Then
on
it will come
12th,
on 20th and 21st.
12th, my lord.
Interim orders, my lord.
20th.
Interim orders extended.
Out of 20th.
20th.
Yes, Mr. Patil, in
Please.
ಶುರು ಮಾಡ್ತಾರೆ. You wait.
The term of the Board of Directors of Kolar DCC Bank was about to expire. As elections were not held,
ಮೈಸೂರು ಕೋಲಾರ.
that's somehow
ಬೆಂಗಳೂರು ಪಕ್ಕದಲ್ಲಿದೆ ಅಂತನಾ?
WP ಒಂದು small sheet ಕೊಟ್ಟಿದ್ದೇವೆ.
ಯಾವ್ದು ತಗೊಂಡ್ಬೇಕು ಇವಾಗ ನಿಮ್ಗೆ petition? Which?
21521.
Yes, we have that.
One small sheet ಕೊಟ್ಟಿದ್ವಿ. Your Lordship may kindly have it, have
ಇನ್ನ
it.
ಒಂದ್ಸತಿ ಕೊಟ್ಬಿಡಿ. ಒಂದ್ ಸಿನಾಪ್ಸಿಸ್ ಒಂದ್ ಕೊಟ್ಟಿದ್ದಾರೆ.
ಅದೇ ಸಣ್ಣದು ಒಂದೇ.
Synopsis is being
Date
given
is
by the
also
state.
given as synopsis.
Yes.
ಯಾವ ಪೇಜ್ನಾಗ ಐತಿ ತೆಗೀರಿ. As the calendar etc. were not, preparation for election was not made. WP 20-454 of 23 was filed, seeking a direction for holding the election
Yes.
as per the calendar of events dated 31/5/23. This writ petition was filed on 11/9/23. Ultimately, on 3/7/24, petition was allowed with a direction to hold the election within 3 months from the date of the order. The term of the board was to expire on 18/11/23.
Expired already before the.
Expired, and therefore, administrator was appointed. A meeting, a general body meeting was held on 12/8/2023 to amend the bylaw. In that regard, a writ petition 19-414 of 23 and 19-741 of 23 were filed, saying in that meeting, proper discussion was not made and amendment of bylaw was not decided. This court allowed those writ petitions. Page 28 is the order.
ಏನ್ amendment ಏನಿದು?
Amendment ಏನಂದ್ರೆ 2 new talukas were created.
Same issue.
Same issue.
Of
Therefore,
Kolar
bylaw
and
to provide representations to them, Chelur and this. Therefore, on that, those petitions were allowed on 21/9/23, that is before appointment of administrator, with a direction to call a special general meeting and take up the subject. Special general meeting was held on 6/11/23.
So this amendment was subsection 5 of section 12 amendment.
ಹೌದು, ನಾವೇ ಪ್ರಪೋಸ್ ಮಾಡಿದ್ದು.
Yes.
ಮಾಡಿ 6/11/23ಗೆ it was meeting was held. And amendment was resolution was passed for amendment, providing a representation for those 2 talukas. Proposal to amend the bylaw was filed on 7/11/23. This date is of some material importance, my lord. 7/11/23. This proposal was rejected by an order dated 20th February 24, after the administrator was appointed.
Who rejected the amendment?
Joint registrar. He is the registrar for registering the bylaw.
So in terms of subsection 5 of section 12, the amendment suggested was placed before the meeting,
yes,
the
TM.
SGM.
No, it is not suggested. It was our own proposal.
Your own proposal.
Our own proposal.
Not under subsection 5 of.
No. Then it was passed. It was filed on 7/11/23. It is rejected by an endorsement dated 20th February 24. ಇದು ನಮ್ಮ ಪ್ರಕಾರ 3 ತಿಂಗಳ ನಂತರ ಮಾಡಿದ್ದಾರೆ. ದರ್ ಇಸ್ ಡೀಮ್ಡ್ ರಿಜಿಸ್ಟ್ರೇಷನ್ ಅಂತ ಅವ್ರು ನಮ್ಮ ಕೇಸು ನಾನು ತೋರಿಸ್ತೇನೆ ಅದು. Thereafter, for 6 months, no further action was taken. ಈ ಮೊದಲಿನ ರಿಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ 3 monthsಗೆ ರಿಸೀಟ್ ಆಫ್ ದಿ ಆರ್ಡರ್ 3 monthsಗೆ ಇಲೆಕ್ಷನ್ ಮಾಡಬೇಕು ಅಂತಿದ್ದನ್ನ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ, ಏನು ಪ್ರಿಪರೇಷನ್ ಮಾಡಿಲ್ಲ ಅಂತ ಹೇಳಿ, ಎ ಕಂಟೆಂಪ್ಟ್ ಪಿಟಿಷನ್ ವಾಸ್ ಫೈಲ್ಡ್ ಆನ್ 31/7/24. Notice in that contempt petition was issued on 2/8/24. Promptly on 3/8/24, the joint registrar issues a 12/5 direction to make the same amendment with a little change. It is that which is
What
now.
you had proposed, which was rejected. The same amendment is now suggested.
The little change, he seeks to do it. ಇದನ್ನ ನಮ್ಮ ಪ್ರಕಾರ he did it
only to avoid the contempt. So that within 3 months ಮಾಡಿಲ್ಲ ಇದು proceeding pending ಇದೆ ಅಂತೇಳಿ ಅದಕ್ಕಾಗಿ ಮಾಡಿದ್ದಾರೆ ಅಂತೇಳಿ we have filed the writ petition. We have pointed out three aspects.
What is the relief you are asking here?
We are asking this 12(5) annexure D 12(5) endorse ಮೊದಲನೇದು ಎಂಡಾರ್ಸ್ಮೆಂಟ್ 20ನೇ ತಾರೀಕಿಗೆ ಕೊಟ್ಟ ಎಂಡಾರ್ಸ್ಮೆಂಟ್ ರಿಜೆಕ್ಷನ್. ಎರಡನೇದು ಈಗ ಅವರು ಇಶ್ಯೂ ಮಾಡಿದ ನೋಟಿಸ್ 380 ಇಶ್ಯೂ ಮಾಡಿದ ನೋಟಿಸ್ annexure F and the corrigendum annexure G.
In corrigendum ಏನು that is
380 the ನೋಟಿಸ್ಗೆ ಒಂದು corrigendum ಕೊಡು.
Now where is your amendment that you had proposed on
Please, my lord.
6/11/27/11/6/11?
ಅದಕ್ಕಿಂತ ಮೊದಲು ತಾವು ಒಂದ್ ನಿಮಿಷ ಇದನ್ನ ನೋಡಿದ್ರೆ ಪೇಜ್ 23 ತಾವು ನೋಡಿದ್ರೆ
Yes.
ಆಡಳಿತ ಮಂಡಳಿ ಬ್ಯಾಂಕಿನ ಕಾರ್ಯನಿರ್ವಹಣೆಗೆ ಇಲ್ಲಿ 12 ತಾಲೂಕು ಆದ್ರೆ 10 ಸೀಟ್ ಇಟ್ಟಿದ್ರು. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 4 ಬ್ಯಾಂಕಿನ ಕಾರ್ಯವ್ಯಾಪ್ತಿಗೆ ಬರುವ 2 ಜಿಲ್ಲೆಯ ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳಿಂದ ಒಬ್ಬ ನಿರ್ದೇಶಕಿ.
ಇದೇನ್ ಸೊಸೈಟಿ ಇದು?
ದಿಸ್ ಇಸ್ ಫೆಡರಲ್ ಸೊಸೈಟಿ ಮಿಲ್ಕ್ ಯೂನಿಯನ್ ಡಿಸಿ ಬ್ಯಾಂಕ್
DCC ಬ್ಯಾಂಕ್ ಮಿಲ್ಕ್ ಪ್ರೊಡ್ಯೂಸರ್ಸ್
ಅಲ್ಲ ಮಿಲ್ಕ್ ಪ್ರೊಡ್ಯೂಸರ್ ಸೊಸೈಟಿನು ಮೆಂಬರು. ಅದರೊಳಗೆ ವುಮನ್ ಮಿಲ್ಕ್ ಪ್ರೊಡ್ಯೂಸರ್ ಸೊಸೈಟಿಗೆ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಅಂಡ್ ಕೋಲಾರ್ ಪುಟ್ ಟುಗೆದರ್ 1 ಸೀಟ್ ಕೊಟ್ಟಿದ್ರು.
Each one by itself is a problem. If you
Problem.
include both of them, it will become a bigger problem.
1 ಸೀಟ್ ಕೊಟ್ಟಿದ್ರು. ಆಮೇಲೆ ಸೀರಿಯಲ್ ನಂಬರ್ 5 ಕೈಂಡ್ಲಿ ಸಿ. ಬ್ಯಾಂಕಿನ ಕಾರ್ಯವ್ಯಾಪ್ತಿಗೆ ಬರುವ 2 ಜಿಲ್ಲೆಯ ತಾಲೂಕು ಮಟ್ಟದ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘಗಳಿಂದ ಚುನಾಯಿಸಲ್ಪಡುವ ನಿರ್ದೇಶಕ ಹೌಸಿಂಗ್ ಸೊಸೈಟಿಗೆ 1 ಸೀಟ್ ಕೊಟ್ಟಿದ್ರು.
So which society will you choose for 4 and 5? On what basis?
This is the existing bylaw.
ಬ್ಯಾಂಕಿನ ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಬರುವ 2 ಜಿಲ್ಲೆಯ ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳಿಂದ
ಚುನಾಯಿತ ಒಬ್ಬ ನಿರ್ದೇಶಕರು.
ಸೊ ಎಷ್ಟು ವುಮೆನ್ ಮಿಲ್ಕ್ ಇದೆ?
ಇದು ಎಕ್ಸಿಸ್ಟಿಂಗ್ ಇದ್ದಿದ್ದು ಹೀಗಿತ್ತು. ಕೈಂಡ್ಲಿ ಸಿ
5 ಅಂತೂ ಗೃಹ ನಿರ್ಮಾಣ there will be plenty
ಅವರಿಗೆ ಅಂದ್ರೆ ಅವರ್ ಮೇನ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆಂಟ್ ಈಸ್ ಪ್ರೈಮರಿ ಅಗ್ರಿಕಲ್ಚರಲ್ ಕ್ರೆಡಿಟ್ ಸೊಸೈಟೀಸ್. ತಾಲೂಕಾ ವೈಸ್ ಫಾರ್ ಈಚ್ ತಾಲೂಕಾ 1 seat. Therefore there will be 12 directors. ಈ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಒಂದು ನೋಡ್ಬೇಕು. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಹಕಾರ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕಿನ ನಾಮಿನಿ ಒಂದಿದೆ.
ಅದು ಓಕೆ.
ಸರ್ಕಾರದ ನಾಮಿನಿ ಒಂದಿದೆ. ಒಟ್ಟೆಲ್ಲ ಕೂಡಿ ಮೊದಲ 21 ನಿರ್ದೇಶಕರು ಇದ್ರು. ನಾವು ಈ ಇದನ್ನ ಮಾಡಿದ ನಂತರ ಜನರಲ್ ಬಾಡಿ ಮಾಡಿ ಜನರಲ್ ಬಾಡಿಯಲ್ಲಿ ವಾಟ್ ವಾಸ್ ಪ್ರಪೋಸ್ಡ್ ವಾಸ್ ಈ ಅದರ್ ಸೊಸೈಟೀಸಿಗೆ 1 ಸೀಟ್ ಇದ್ದಿದ್ದು ಸೀರಿಯಲ್ ನಂಬರ್ 6 ಒಂದ್ಸಲ ನೋಡ್ಬೇಕು. ಪೇಜ್ 23 ಸೀರಿಯಲ್ ನಂಬರ್ 6
1 2 3 4 ಮತ್ತು 5
ಅಂದ್ರೆ ಮಹಿಳಾ ಸೊಸೈಟಿ, ಹಾಗೇನೆ ಹಾಲು ಉತ್ಪಾದಕರ ಸೊಸೈಟಿ, ಹೌಸಿಂಗ್ ಸೊಸೈಟಿ ಇವನ್ನ ಹೊರತುಪಡಿಸಿ ಉಳಿದ ಎಲ್ಲಾ ಸೊಸೈಟಿಗಳಿಗೆ ಒಬ್ಬರು ಅಂತಿತ್ತು ಮೊದಲಿದ್ದಿದ್ದು. ಈಗ we proposed ಈ ಸೀರಿಯಲ್ ನಂಬರ್ 5 and 6 ಹೌಸಿಂಗ್ ಸೊಸೈಟಿಗೆ 1 ಸೀಟು, ಉಳಿದವರಿಗೆ 1 ಸೀಟು. ಪೇಜ್ 43.
This was the proposed amendment.
Proposed amendment ನಲ್ಲಿ ಈ 5 and 6 ಟುಗೆದರ್ 2 ಸೀಟ್ ಇದ್ದಿದ್ದನ್ನ ಹೌಸಿಂಗ್ ಸೊಸೈಟಿಯನ್ನು ಅದರ್ ಸೊಸೈಟೀಸ್ ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆನ್ಸಿಗೆ ಸೇರಿಸಿ 1 ಸೀಟ್ ಮಾಡಿದ್ರು.
ಆಯಾ ಜಿಲ್ಲೆ ಆಯ್ತು, ಬ್ಯಾಂಕಿನ ಕಾರ್ಯ
ಹಾ,
ಬರುವ
ಆಮೇಲೆ
ಜಿಲ್ಲೆಯ ಹಾಲು ಉತ್ಪಾದಕರು, ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳ ನಿರ್ದೇಶಕರು ಒಂದು.
ಆಮೇಲೆ ಏನ್ ಮಾಡಿದ್ವಿ ಅಂದ್ರೆ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕಿನ ನಾಮಿನಿ ಇದ್ದದ್ದನ್ನ ಡಿಲೀಟ್ ಮಾಡಿದ್ವಿ.
ಇವಾಗ 4 ಅಲ್ಲಿ ಹಾಲು ಉತ್ಪಾದಕರು ಮಹಿಳಾ ಸಂಘ,
ಅದು ಹಾಗೆ ಉಳಿತು.
ಮತ್ತು ಇತರ ಜಿಲ್ಲಾ, ಓಕೆ, ಅದು ಒಂದೇ ಆಯ್ತು. ಬಟ್ ಇನ್ನೊಂದು ಅಡಿಷನ್ ಕ್ಲಾಸ್ ಹಾಕಿದ್ದೀರಾ.
ಒಂದು ಇನ್ನು 2 ತಾಲೂಕಾಗಿತ್ತು, 2 ಸೀಟ್ ವೇಕೇಟ್ ಆಗ್ಬೇಕಲ್ಲ, ಚೇಂಜ್ ಆಗ್ಬೇಕು. ಸೊ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ನಾಮಿನಿ ಪೇಜ್ 44.
ಅಲ್ಲ, 4 ಅಲ್ಲಿ ಬ್ಯಾಂಕಿನ ಕಾರ್ಯ ವ್ಯಾಪ್ತಿಗಳ ಬರುವ 2 ಜಿಲ್ಲೆಯ ಹಾಲು ಉತ್ಪಾದಕರು ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳಿಂದ
ದೇಶಕ್ಕೆ ಮೊದಲಿದ್ದ ಹಾಗೆ ಇಟ್ಕೊಂಡ್ವಿ.
ಬ್ಯಾಂಕಿನ ಕಾರ್ಯವ್ಯಾಪ್ತಿಗೆ
ಬರುವ 2 ಜಿಲ್ಲೆಯ ಒಬ್ಬ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘ
ಮತ್ತು ಇತರ
ಜಿಲ್ಲೆಯ ಇತರೆ ಸೊಸೈಟಿಗಳು ಅವು 2 ಕೂಡಿ ಒಂದೇ ಮಾಡಿದ್ವಿ.
ಇತರ ಜಿಲ್ಲಾ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳಿಂದ ಮಹಿಳಾ ಅಂತ ಮಾಡಿದ್ದೀರಾ. ಮುಂಚೆ ಇದ್ದಿದ್ದು
ನಂಬರ್ 4 ಮೊದಲಿದ್ದ ಹಾಗೆ ಉಳಿಸ್ಕೊಂಡಿವಿ.
4 and 6 have got combined.
ಅಲ್ಲಲ್ಲ, 6 ಮೇಲೆ ನಮೂದಿಸಿದ 1, 2, 3, 4 ಮತ್ತು 5 ಹೊರತುಪಡಿಸಿ ಬ್ಯಾಂಕಿನ ಕಾರ್ಯವ್ಯಾಪ್ತಿಗೆ ಬರುವ ಇನ್ನಿತರೆ ಸಹಕಾರ ಸಂಘಗಳು ಅಂತೇಳಿ ಒಂದು ಕಾನ್ಸ್ಟಿಟ್ಯೂಯೆನ್ಸಿ ಇತ್ತು.
ಎಲ್ಲ ರೀತಿಯ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳಿಂದ ಅಂತ ಮಾಡಿದ್ರಿ. ಸೊ ಯು ಆಡೆಡ್ ಒನ್ ಮೋರ್ qualification, one more set of applicants.
ಆದ್ರೆ 5 and 6 ಏನಿತ್ತಲ್ಲ, ಗೃಹ ನಿರ್ಮಾಣಕ್ಕೆ ಒಂದು, ಇತರೆ ಸೊಸೈಟಿಗಳಿಗೆ ಒಂದು,
ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘಗಳಿಂದ ನಿರ್ದೇಶಕರು, ಅದನ್ನ ಸೇರಿ ಒಂದು ಮಾಡಿದ್ರು.
ಅದನ್ನ ಮತ್ತು 6ನೇದರಲ್ಲಿ ಅದರ್ ಸೊಸೈಟೀಸ್ ಅದರ್ ದನ್ 1, 2, 3, 4 ಅದು ಎರಡನ್ನು ಸೇರಿಸಿ ಒಂದು ಅಂತ ಮಾಡಿದ್ವಿ.
ಸೊ HBCS ತೆಗೆದಾಕ್ಬಿಟ್ರಿ.
HBCS ಅನ್ನ ಅದರ್ ಸೊಸೈಟಿಗೆ ಸೇರಿಸ್ಬಿಟ್ರಿ. ಸೊ ಒಂದೇ ಸೀಟು, ಅಲ್ಲಿ 1 ಸೀಟ್ ಸಿಕ್ತು. ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಹಕಾರ ಬ್ಯಾಂಕ್ ನಾಮಿನಿ ಸೀರಿಯಲ್ ನಂಬರ್ 8 ಅವರನ್ನ ತೆಗೆದ್ವಿ.
ಕರ್ನಾಟಕ ರಾಜ್ಯ ಸಹಕಾರ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್
ನಾಮಿನಿನ ತೆಗೆದ್ವಿ. ಸೊ 2 ಸೀಟ್ ವೇಕೇಟ್ ಆಯ್ತು. ಮೇಲೆ ಫಸ್ಟ್ ಇದರೊಳಗೆ 12 ತಾಲೂಕಿಗೆ 10 ಅಂತ ಏನಿತ್ತಲ್ಲ, ಅದನ್ನ 12 ಮಾಡಿ, 12 ತಾಲೂಕಿಗೆ 12 ಮಾಡಿ.
DCC ಬ್ಯಾಂಕ್ ಇಂದ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಹೆಂಗ್ ತೆಗಿತೀರಾ ನೀವು?
DCC ಬ್ಯಾಂಕ್ ಇಂದ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕಿಗಲ್ಲ. ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಇಸ್ ನಾಟ್ ಅವರ್ ಮೆಂಬರ್. ಆಸ್ ಎ ಫೈನಾನ್ಸಿಂಗ್ ಬ್ಯಾಂಕ್ ಒಂದು ನಾಮಿನಿನ ಇಟ್ಕೊಂಡಿದ್ದು. ಈಗ ನಮಗೆ ಮ್ಯಾಕ್ಸಿಮಮ್ ಪರ್ಮಿಸಿಬಲ್ 21. 2 ತಾಲೂಕಿಗೆ ಹೊಸ ಸೀಟ್ ಕೊಡಬೇಕಾಗಿತ್ತು. ಇದಕ್ಕೆ ಜನರಲ್ ಬಾಡಿಯಲ್ಲಿ ಅಲ್ಟಿಮೇಟ್ಲಿ ದೇ ಸೆಡ್ these 2 seats are to be made vacant and those new taluka should be given. ಈ ಅಮೆಂಡ್ಮೆಂಟ್ ಜನರಲ್ ಬಾಡಿಯಲ್ಲಿ ಪಾಸ್ ಆಯ್ತು. ಇದನ್ನ ಫೈಲ್ ಮಾಡಿ ಅದನ್ನ 7(1)ಕ್ಕೆ kindly see annexure D.
Yes. This was passed on 6/11 meeting.
ಹೌದು, it was passed on 6/11.
Yes.
Annexure D page 45. ಅದರಲ್ಲಿ ರೆಫರೆನ್ಸ್ ಅನ್ನ ನೋಡಬೇಕು.
ಉಲ್ಲೇಖ 1 7/11.
ಬ್ಯಾಂಕಿನ ಪ್ರಸ್ತಾವನೆ 7/11/23. This order is passed on. ಇದು ಕೋಲಾರ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಕಡೆಯಿಂದ so and so ಪ್ರಸ್ತಾವನೆಯನ್ನು ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. ಮೇಲ್ಕಂಡ ಪ್ರಸ್ತಾವನೆಗೆ ಮಾಹಿತಿಗಳನ್ನು ಸಲ್ಲಿಸಲು ಸೂಚಿಸಲಾಗಿದ್ದು, ಉಲ್ಲೇಖ 5 ಅನ್ವಯ ದಾಖಲಾತಿ ಮಾಹಿತಿ ಸಲ್ಲಿಸಿರುತ್ತಾರೆ. 6/11/23 ವಿಶೇಷ ಸಾಮಾನ್ಯ ಸಭೆ ನಡೆಸಿ ಬ್ಯಾಂಕಿನ ಉಪವಿಧಿ 4(1)(9)(a)ಗಳಿಗೆ ತಿದ್ದುಪಡಿ ತರಲು ನಿರ್ಣಯಿಸಿ ಪ್ರಸ್ತಾಪಿತ ಉಪವಿಧಿಯ ಅನುಮೋದನೆ ಕೋರಿ ಈ ಕಚೇರಿಗೆ ಸಲ್ಲಿಸಲಾದ ಪ್ರಸ್ತಾವನೆಯನ್ನು ಪರಿಶೀಲಿಸಲಾಗಿ 25/10/23 ಸರ್ವವಿಧಿ ಸದಸ್ಯರ ವಿಶೇಷ ಮಹಾಸಭೆಯ ಅಧಿವೇಶನ 6/11/23 ಸೋಮವಾರದಂದು 11:30 ಗಂಟೆಗೆ ಬ್ಯಾಂಕಿನ ಕೇಂದ್ರ ಕಚೇರಿಯ ಆವರಣದಲ್ಲಿ ನಿಗದಿಪಡಿಸಿ ನೋಟಿಸ್ ನೀಡಿರುತ್ತಾರೆ. ಆದರೆ ಸದರಿ ನೋಟಿಸ್ನಲ್ಲಿ ಪ್ರಸ್ತಾಪಿಸುವಾಗ ಉಪವಿಧಿ 4(1) ಮತ್ತು 9(a)ಗಳಲ್ಲಿ ಹಾಲಿ ಉಪವಿಧಿಯ ಅವಕಾಶಗಳನ್ನು ತಿಳಿಸಿರುತ್ತಾರೆ. ನಂತರ ಉಪನಿಯಮ ತಿದ್ದುಪಡಿಯಾದ ನಂತರದ ಅಂಶವನ್ನು ತಿದ್ದುಪಡಿಗೆ ಕಾರಣಗಳು ಎಂದು ಈ ಕೆಳಕಂಡಂತೆ ವಿಷಯವನ್ನು ಪ್ರಸ್ತಾಪಿಸಿರುತ್ತಾರೆ. ಹೈಕೋರ್ಟ್ ನಲ್ಲಿ ಆ ರಿಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಆರ್ಡರ್ ಆಗಿದ್ದು ಅದಕ್ಕಾಗಿ ಅದನ್ನ ಮತ್ತೆ ಮೀಟಿಂಗ್ ಕರೆದು ಇಟ್ಟಿರೋದು ಅಂತೇಳಿ ಹೇಳಿದ್ದಾರೆ ಅಂತ ಹೇಳ್ತಾರೆ. ಹೇಳಿ then he says this format of notice is not valid because you should have said why you are amending the bylaw etc. reasons ಕೊಡಬೇಕಿತ್ತು. page 50. ಆದರೆ 3ನೇ ಕಾಲಂನಲ್ಲಿ ಉಪನಿಯಮದ ನಂತರ ತಿದ್ದುಪಡಿಯಾದ ನಂತರದ ಉಪವಿಧಿಯ ಅವಕಾಶಗಳನ್ನು ಸದಸ್ಯರ ಗಮನಕ್ಕೆ ಸಾದರಪಡಿಸಿರುವುದಿಲ್ಲ. ಈ ಕಾಲಂನಲ್ಲಿ ಮಾನ್ಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶದಂತೆ ಕ್ರಮವಿಡಬೇಕಾಗಿದ್ದು ತೀರ್ಮಾನಕ್ಕಾಗಿ ವಿಷಯವನ್ನು ಮಂಡಿಸಿದೆ ಎಂದು ನಮೂದಿಸಲಾಗಿದೆ. ಉಚ್ಚ ನ್ಯಾಯ ಸದರಿ ಆದೇಶವು ಬ್ಯಾಂಕಿಗೆ ವಿಶೇಷ ನೀಡಿದಂತಹ ನಿರ್ದೇಶನವಾಗಿದ್ದು ಪ್ರಸ್ತಾಪಿತ ಉಪವಿಧಿ ತಿದ್ದುಪಡಿಯ ನಂತರ ಅವಕಾಶಗಳು ಯಾವುವು ಎಂದು ಸದಸ್ಯರಿಗೆ ತಿಳಿಸತಕ್ಕ ಜವಾಬ್ದಾರಿಯನ್ನು ಬ್ಯಾಂಕು ನಿರ್ವಹಿಸಿರುವುದಿಲ್ಲ. ಪ್ರಸ್ತಾಪಿತ ಉಪವಿಧಿಯು ಪಾರದರ್ಶಕವಾಗಿರದೆ ಎಲ್ಲಾ ಸದಸ್ಯರ ಗಮನಕ್ಕೆ ಪ್ರಸ್ತಾಪಿತ ಉಪವಿಧಿಯ ಅಂಶಗಳ ಮೇಲೆ ಚರ್ಚೆಯಾಗುವ ಬಗ್ಗೆ ಮಾಹಿತಿ ಇಲ್ಲದಿರುವುದನ್ನು ಗಮನಿಸಿದೆ. ಮುಂದುವರೆದು ತಿದ್ದುಪಡಿಗೆ ಕಾರಣಗಳನ್ನು ಸಹ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶಾನುಸಾರ ಎಂದು ನಮೂದಿಸಿರುತ್ತೆ. ವಿಶೇಷ ಸರ್ವ ಸದಸ್ಯರ ಸಭೆಯನ್ನು ಕರೆಯಲು ಆದೇಶಿಸಿರುತ್ತದೆ ವಿನಾ ಉಪನಿಯಮ ತಿದ್ದುಪಡಿಯಾದ ನಂತರದ ಅಂಶದ ಹಾಗೂ ತಿದ್ದುಪಡಿಗೆ ಕಾರಣಗಳನ್ನು ಪ್ರಸ್ತಾಪಿಸಿರುವುದಿಲ್ಲ. ಗೌರವನೀಯ ಉಚ್ಚ ನ್ಯಾಯಾಲಯದ ಆದೇಶವನ್ನು ಸಮಯೋಚಿತವಾಗಿ ಸದಸ್ಯರ ಗಮನಕ್ಕೆ ತರದೆ ಗೌಪ್ಯವಾಗಿಟ್ಟಿರುವುದನ್ನು ಗಮನಿಸಿದೆ. 25/10/23
available in public domain.
ಅದೆಲ್ಲದೂ ಆದ ನಂತರ ಕೈಂಡ್ಲಿ ಸಿ ಈ ಪೇಜ್ 51 ನಲ್ಲಿ
Writ petition number was mentioned in the notice.
ಹೌದು ಆರ್ಡರ್ ಆಗಿದೆ ಅಂತ. ಬ್ಯಾಂಕಿಗೆ ಪೇಜ್ 51 ಬ್ಯಾಂಕಿಗೆ ಹೆಚ್ಚಿನ ಮಟ್ಟದಲ್ಲಿ ಹಣಕಾಸು ನೆರವು ಸಾಲ ನೀಡುವ ಸಂಸ್ಥೆಯಾಗಿ 3 ಹಂತದ ಕೃಷಿ ಹಣಕಾಸು ವ್ಯವಸ್ಥೆಯ ಪ್ರಮುಖ ಮತ್ತು ಮೊದಲ ಘಟ್ಟದ ಸಂಸ್ಥೆಯಾಗಿ ಕಾರ್ಯನಿರ್ವಹಿಸುವ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಬೆಂಗಳೂರು ಸಂಸ್ಥೆಗೆ ಪ್ರಸ್ತಾಪಿತ ಉಪವಿಧಿಯಲ್ಲಿ ನಾಮಿನಿ ನಿರ್ದೇಶಕ ಸ್ಥಾನ ಕೈಬಿಟ್ಟಿರುವ ಬಗ್ಗೆ ಉಲ್ಲೇಖ 4ರ ಪತ್ರದಲ್ಲಿ ವ್ಯವಸ್ಥಾಪಕ ನಿರ್ದೇಶಕರು ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಇವರು ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮ ಸ್ವಯಂಸೋದಂತೆ ಬ್ಯಾಂಕಿನಿಂದ ಒಬ್ಬರನ್ನು ನಾಮನಿರ್ದೇಶನ ಮಾಡಲು ಅವಕಾಶ ಇರುವುದರಿಂದ ಕೋಲಾರ ಮತ್ತು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಸಹಕಾರ ಬ್ಯಾಂಕಿನವರು ಉಪವಿಧಿ ಸಂಖ್ಯೆ 9A ಕೋರಿರುವ ತಿದ್ದುಪಡಿಗೆ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕಿನಿಂದ ಆಕ್ಷೇಪಣೆ ಇರುತ್ತದೆ ಎಂದು ತಮ್ಮ ಅವಗಾನೆಗೆ ತರಬಯಸುತ್ತೇನೆ ಎಂದು ತಕರಾರು ವ್ಯಕ್ತಪಡಿಸಿರುತ್ತಾರೆ. ಕೋಲಾರ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾ ಕೇಂದ್ರ ಸಹಕಾರ ಬ್ಯಾಂಕಿನ ಹಣಕಾಸು ಸಂಸ್ಥೆಯಾದ ಕರ್ನಾಟಕ ರಾಜ್ಯ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ನಿಯಮಿತ ಇವರ ತಕರಾರು ಪರಿಗಣಿಸಬೇಕಾದಂತಹ ಅಂಶವಾಗಿದ್ದು ಸದರಿ ಬ್ಯಾಂಕಿಗೆ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕಿನಿಂದ ನೀಡಲಾಗುತ್ತಿರುವ ಸಾಲ ಸೌಲಭ್ಯ ಮತ್ತು ವಸೂಲಾತಿ ಪ್ರಕ್ರಿಯೆಯ ಆಗುಹೋಗುಗಳನ್ನು ಹಣಕಾಸು ಸಂಸ್ಥೆ ಹಿತ ಕಾಪಾಡುವ ಅವಶ್ಯಕತೆ ಕಂಡುಬಂದಿರುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ನಿಯಮ 6162 ಪಾಲನೆಯಾಗುವ ಹಿನ್ನೆಲೆಯಲ್ಲಿ ಪ್ರಸ್ತಾಪಿತ ಉಪವಿಧಿ ಸಂಬಂಧಿಸಿದಂತೆ ಈ ಕೆಳಕಂಡಂತೆ ಆದೇಶಿಸಲಾಗಿದೆ. ಕರ್ನಾಟಕ ಸಹಕಾರ ಸಂಘಗಳ ಅಧಿನಿಯಮ 12ನೇ ಕಾಲಮಿನ ಉಪಕಲಂ 2ರ ಮೇರೆಗೆ ಸರ್ಕಾರದ ಅಧಿಸೂಚನೆ ಸಂಖ್ಯೆ ಸೋಯನ್ಸೋದ ಅನ್ವಯ ದತ್ತವಾಗಿರುವ ಅಧಿಕಾರವನ್ನು ಚಲಾಯಿಸುತ್ತಾ ಸೋಯನ್ಸೋ ಅಶ್ವಥ್ ನಾರಾಯಣ್ ಸೋಯನ್ಸೋ ಆದ ನಾನು ಪ್ರಸ್ತಾವನೆಯಲ್ಲಿ ವಿವರಿಸಿರುವ ಕಾರಣಗಳಿಂದಾಗಿ ಕೋಲಾರ ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲಾ ಸಹಕಾರ ಕೇಂದ್ರ ಬ್ಯಾಂಕಿನ ಸೋಯನ್ಸೋ ಕೈಗೊಳ್ಳುವಲ್ಲಿ ನಿಯಮ ಸೋಯನ್ಸೋ ಅವಕಾಶಗಳನ್ನು ಪಾಲನೆ ಮಾಡದಿರುವುದರಿಂದ ಉಪವಿಧಿ 4 ಮತ್ತು 9A ತಿದ್ದುಪಡಿಯನ್ನು ತಿರಸ್ಕರಿಸಲಾಗಿದೆ. 22-24 ಈ ತಿದ್ದುಪಡಿ ತಿರಸ್ಕಾರ ಮಾಡಿದ ನಂತರ then your lordship may kindly see.
So you don't want funds from Apex banks?
Funds from Apex bank, actually ಇವರು ಬರೆದಿರೋ ತಪ್ಪು. It's not financing bank at all. NABARD is the financing bank.
So Apex bank ಇಲ್ಲ ಅಂದ್ರೆ NABARD ಬರಲ್ಲ.
NABARD ಬರುತ್ತೆ. It's statutorily ಬರುತ್ತೆ.
That is for Apex bank to recommend what to do.
ಇಲ್ಲ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕು ಇಲ್ಲ, ಡೈರೆಕ್ಟ್ಲಿ DCC ಬ್ಯಾಂಕಿನವರೇ ಪ್ರಪೋಸಲ್ ಕಳಿಸ್ಬೇಕು. ನಾನು ಅದನ್ನು ಹೇಳ್ತಾ ಇಲ್ಲ. ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ is not my member. DCC ಬ್ಯಾಂಕಿನ ಮೆಂಬರ್ ಅಲ್ಲ ಅವರು. ಮೆಂಬರ್ ಅಲ್ಲದೆ ಇದ್ದವರಿಗೆ ಒಂದು ಸ್ಥಾನ ಕೊಟ್ಟಿದ್ರು. ಬಟ್ ಎನಿವೇ ಅದನ್ನ ತೆಗ್ದಿದ್ದಾರೆ. ತೆಗ್ದಿದ್ದು ಸರಿ ತಪ್ಪು ಇದು ಬೇರೆ. Your Lordship may kindly see annexure F.
Yes. Now what has he suggested?
3/8/24 ಇದು 2/2/24 ತಿರಸ್ಕಾರ ಮಾಡಿದ್ರು. ಆಲ್ ರೈಟ್, ತಿರಸ್ಕಾರ ಮಾಡಿದ ಕೂಡಲೇ ಇಲ್ಲ ನೀವು ಬೇರೆ ನಮೂನಿ ಮಾಡ್ಕೊಳ್ಳಿ ಅಂತೇಳಿ 6 ತಿಂಗಳವರೆಗೆ ಯಾವಾಗೂ ಏನು ಮಾಡ್ಲಿಲ್ಲ. ಕಂಟೆಂಪ್ಟ್ ನಲ್ಲಿ ನೋಟಿಸ್ 2ನೇ ತಾರೀಕಿಗೆ ಇಶ್ಯೂ ಆಯ್ತು.
ಏನಕ್ಕೆ ಕಂಟೆಂಪ್ಟ್ ಆಗಿದ್ದು?
ನಾವು ಎಲೆಕ್ಷನ್ ನೀವು 3 ತಿಂಗಳೊಳಗೆ ಮಾಡ್ಬೇಕು ಅಂತಿತ್ತು, ಇನ್ನೂ ಪ್ರಿಪರೇಟರಿ ಸ್ಟೆಪ್ಸ್ ನೀವು ತಗೊಂಡಿಲ್ಲ, ತಗೊಳ್ಬೇಕು ಅಂತೇಳಿ ಹಾಕಿದ್ವಿ. 2/8 ಕೋರ್ಟ್ ಎದುರಿಗೆ ಬಂದು ಆರ್ಡರ್ ಆಯ್ತು. 3/8 ಮಾಡಿದ್ರು. ಇಲ್ಲಿ ಏನ್ ಮಾಡ್ತಾರೆ ಅಂದ್ರೆ ಆಪರೇಟಿವ್ ಪೋರ್ಷನ್ ಪೇಜ್ 85 ತಾವು ನೋಡು.
Yes.
ಅವರು ತಮ್ಮ ಸಂಖ್ಯೆ ಇದನ್ನೆಲ್ಲ ಹೇಳಿ 2 ಜಿಲ್ಲೆಯ ತಾಲೂಕಾವಾರು ಹಾಗೂ ಎಲ್ಲಾ ವಿಧದ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸುವುದು ಅವಶ್ಯಕವಾಗಿರುವುದರಿಂದ ಗೃಹ ನಿರ್ಮಾಣ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಕಲ್ಪಿಸಿರುವ ಒಂದು ನಿರ್ದೇಶಕ ಸ್ಥಾನ ಮತ್ತು ಹಾಲು ಉತ್ಪಾದಕರ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘಗಳಿಗೆ ಕಲ್ಪಿಸಿರುವ ಒಂದು ನಿರ್ದೇಶಕ ಸ್ಥಾನವನ್ನು ತೆಗೆದುಹಾಕಿ ಈ 2 ನಿರ್ದೇಶಕರ ಸ್ಥಾನಗಳನ್ನು ಚಿಕ್ಕಬಳ್ಳಾಪುರ ಜಿಲ್ಲೆಯಲ್ಲಿ ಹೊಸದಾಗಿ ರೂಪಿತಗೊಂಡಿರುವ ಮಂಚೇನಹಳ್ಳಿ ತಾಲೂಕು ಮತ್ತು ಚೇಲೂರು ತಾಲೂಕುಗಳಿಗೆ ಅವಕಾಶ ಕಲ್ಪಿಸಲು ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯ ಸ್ಥಾನಗಳನ್ನು ಪುನರ್ರಚಿಸಿಕೊಂಡು ಸೋ ದಿವಸದೊಳಗಾಗಿ ಆಡಳಿತ ಮಂಡಳಿ ಸದಸ್ಯ ಅಳವಡಿಸಿಕೊಳ್ಳಲು ನಿಯಮಾನುಸಾರ ಕ್ರಮ ಕೈಗೊಂಡು ತಿದ್ದುಪಡಿ ಪ್ರಸ್ತಾವನೆ ಸಲ್ಲಿಸಲು ನಿರ್ದೇಶಿಸಿದೆ. Now he issues a 12/5 direction to the administrator that you delete that Mahila Sangha, this thing, you delete that housing, housing ನಾವು ಹೇಳಿದ್ವಿ ಇದನ್ನ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಇಂದು ಗವರ್ಮೆಂಟ್ ನಾಮಿನಿ ಅದೆಲ್ಲದನ್ನು ಹಾಗೆ ಇಟ್ಕೊಳ್ಬೇಕು ಅಂತೇಳಿ ಮಾಡಿದ್ರು. ಇದನ್ನ 3/8 ಕೊಟ್ಟಿದ್ದಾರೆ. Our contention is this is a ploy adopted only for the purpose of postponing the election, and they have successfully done it by saying ಈ ಪೆಟಿಷನ್ ಅನ್ನ ಹಾಕಿ ಮ್ಯಾಟರ್ ಪೆಂಡಿಂಗ್ ಇದೆ, ಅದಕ್ಕಾಗಿ ಇಲೆಕ್ಷನ್ ಮಾಡೋ ಟೈಮ್ ಅನ್ನ ನಮಗೆ ಮತ್ತೆ 4 ತಿಂಗಳು ಇದನ್ನು ಕೊಡಿ ಅಂತ ಹೇಳಿ ತಗೊಂಡಿದ್ದಾರೆ. Now all that I am bringing to your lordship's notice is kindly see section 26.
Yes.
Subject to the provisions of this act, the rules and the bylaws, the final authority of a cooperative society shall vest in the general body of members.
Yes.
Let us say, for using a high sounding word, legislative wisdom in this general body was delete these 2, provide for these 2 talukas.
Because the maximum is 21.
In the meeting, I would say, ಇನ್ನೊಂದು ಬಾಡಿ ಆರಿಸಿ ಬಂದ ನಂತರ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕಿನ ಅವಶ್ಯಕತೆ ಆಯಿತೋ ಅಥವಾ ಮತ್ತೇನಾದ್ರೂ ಚೇಂಜ್ ಮಾಡ್ತಿರೋ ಅನ್ನೋದು ನೋಡೋದಕ್ಕೆಲ್ಲ ಇರ್ತಿತ್ತು. ಅದ್ರ ಬದಲು he wants to say ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕನ್ನು ನೀವು ಡಿಲೀಟ್ ಮಾಡಿದ್ದು ತಪ್ಪು, now you delete these 2. This is a sort of overreaching the general body decision. ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಅನ್ನ ಮೆಂಬರ್ ಮಾಡಿಕೊಳ್ಳೇಬೇಕು ಅಂತ ಎಲ್ಲೂ ಪ್ರೊವಿಷನ್ ಇಲ್ಲ. ಅದನ್ನ ತಾವು ನೋಡ್ಬೇಕು. 28A subsection 2. The board of a cooperative society shall consist not less than 13, but not exceeding the numbers specified below, excluding chief executive. I come under B Roman 2. DCC Bank. In the case of a federal society, including apex societies, 21 members. Maximum that I can reach is 21 members.
Including apex societies.
Apex societies, ಅಂದ್ರೆ ಈಗ apex bankನವರು they can have only 21 members in their board of directors.
Yes.
ಅದರಲ್ಲಿ
ಎಷ್ಟು ತಾಲೂಕಾ ಇದೆ ಇದು?
ಇದೀಗ ಮೊದಲು 10 ಇತ್ತು, ಈಗ 12.
That gives you 9 play.
Then your lordship may kindly see. First provision. Provided that a member shall not represent more than one constituency in the board of a society, may not be relevant for our purpose presently. Next, provided that subject to minimum and maximum number of the members of the board specified in subsection 2 of section 28A, the bylaws of a cooperative society shall provide for composition of the board of the society to include within permissible limits. In case of a assisted society, government nominee as specified under section 4B of section 28A. ಸರ್ಕಾರದ ನಾಮಿನಿಗೆ ಒಂದು ಅವಕಾಶವನ್ನು ಇಡಬೇಕು.
Yes.
B. In case of all cooperative societies other than non-agricultural credit cooperative societies, if necessary, an ex officio member and nominee from the financing or the credit agency. It is left to the society. If necessary, you may have an ex officio member and nominee of the financing or credit agency. This was included by way of an amendment.
In 2014.
2014 ಮೊದಲಿನ ಇದರೊಳಗೆ ಅದರದ್ದು ಅವಕಾಶ ಇರಲಿಲ್ಲ. This amendment was also brought about because of Kolar DCC bank election. ಇಲ್ಲಿ elect ಆಗಿ there was a majority ಇದಿತ್ತು. ಆ ಮೆಜಾರಿಟಿ ಒಳಗೆ ಬೇರೆ ಯಾರು ಈ ಎಕ್ಸ್ ಆಫಿಯೋ ಡೈರೆಕ್ಟರ್ಸು ಸರ್ಕಾರದವ್ರ ಕೈಗೆ ಸಿಗೋ ಅಂತವ್ರು ಯಾರೂ ಇರಲಿಲ್ಲ. ಆದ್ರೆ ಇವರು 2 ಜನರನ್ನ ಸೇರಿಸಿದ್ರು. ಈ ಅಮೆಂಡ್ಮೆಂಟ್ ಇರೋದಕ್ಕಿಂತ ಮೊದಲೇ ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ನಾಮಿನಿ ಸೇರಿಸಿದ್ರು. ಸೊ ಎ ರಿಟ್ ಪಿಟಿಷನ್ ವಾಸ್ ಫೈಲ್ಡ್, ಕನ್ಫೈನ್ ದಿ ಎಲೆಕ್ಷನ್ ಆಫ್ ಪ್ರೆಸಿಡೆಂಟ್ ಟು ದಿ elected board of directors because
Not
this
the-
apex bank nominee etc. are not part of
They
28A1
cannot contest.
ಅಂತ ಹೇಳಿ ರಿಟ್ ಪಿಟಿಷನ್ ಹಾಕಿ, ರಿಟ್ ಪಿಟಿಷನ್ ನಲ್ಲಿ ಇನಿಷಿಯಲಿ there was an interim order of stay. Of course, division bench said let the election go on. ಇದ್ದಿದ್ದ ನಾವು ಇವ್ರನ್ನ ಸೇರಿಸಿರೋದೇ ತಪ್ಪು. ಬೈಲಾದಲ್ಲಿ 28A1 ನಲ್ಲಿ ಎಲ್ಲೂ ಈ ಅದರ್ ದನ್ ಎಲೆಕ್ಟೆಡ್ ಡೈರೆಕ್ಟರ್ಸ್ ಅನ್ನ ಸೇರ್ಸೋದಕ್ಕೆ ಪ್ರೊವಿಷನ್ ಇಲ್ಲ ಅಂತ ಹೇಳಿ ರಿಟ್ ಇತ್ತು.
You challenge the validity of it.
ವ್ಯಾಲಿಡಿಟಿ. ಆವಾಗ an amendment was done providing that society may include a nominee.
May ಎಲ್ಲಿದೆ?
ನೋಡ್ರಿ, in
Shall-
case of all cooperative societies other than non-agricultural credit cooperative societies, if necessary,
If necessary.
if necessary, it is left to the society to its wisdom.
Yes.
ಅದು ನನ್ನ ತಾಲೂಕು, there was a mistake on my part. Earlier 12 talukas, 10 members ಇತ್ತು. 12 talukas. Now 14 talukas.
14 talukas. So that is giving you only play of 7.
ಹಾಗಾಗಿ
7 ಅಲ್ಲಿ ರಿಜಿಸ್ಟರ್ ನಾಮಿನಿ 1.
ಅದರಲ್ಲಿ ನಾವು 2 ಡಿಲೀಟ್ ಮಾಡಿ,
ಅಲ್ಲ ಕಂಪಲ್ಸರಿ ಎಷ್ಟಿದೆ?
ಕಂಪಲ್ಸರಿ
ಎಲೆಕ್ಟೆಡ್ ಅಷ್ಟಾದ್ಮೇಲೆ
ಈಗ ಆಕ್ಚುಲಿ ಗವರ್ಮೆಂಟ್ ನಾಮಿನಿ ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟ್ರಾರ್ ಇದಾರಲ್ಲ, ಅದನ್ನೇ ಎಕ್ಸ್ ಆಫಿಯೋ, ಅದನ್ನ ಡಿಲೀಟ್ ಮಾಡ್ರಿ ಅಂತ ಹೇಳ್ಬೋದಿತ್ತು ಇವರು.
ಸಹಕಾರ ಸಂಘದ ಜಂಟಿ ರಿಜಿಸ್ಟ್ರಾರ್ ಒಂದು,
ಅವ್ರನ್ನ
ಕರ್ನಾಟಕ
ಡಿಲೀಟ್
ರಾಜ್ಯ
ಮಾಡ್ಬೋದಿತ್ತು.
ಸರ್ಕಾರ, ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕು ಸರ್ಕಾರದ ನಾಮಿನಿ ಇಬ್ಬರು ಅವರಿದ್ದಾರೆ.
ಹ್ಮ್.
2 is JRCS and government. ಅಲ್ಲಿ ಬಾಕಿ ಇನ್ನ 5
ತಾಲೂಕಿಯಲ್ಲಿ
ಇದರಲ್ಲಿ ಅಪೆಕ್ಸ್
14 ಕದ್ರಿ 10 ತಾಲೂಕು ಇದ್ವು ಮೊದ್ಲೇ 10 ಜನ ಇದ್ರು. ಬಂಗಾರಪೇಟೆಗೆ ಇದ್ ಮಾಡಿ ಇವಾಗ 12 ಮಾಡಿ 2 ಜನರನ್ನ ಕಮ್ಮಿ ಮಾಡಿದ್ರೆ 21 ಹಂಗೆ ಉಳಿಬೇಕಲ್ಲ. ಇನ್ 14 ತಾಲೂಕ ಎಲ್ಲಿ?
ಇನ್ನ 5 ಉಳಿಯಿತು.
ಇಲ್ಲ ಅಂದ್ರೆ ಕಾರ್ಯವ್ಯಾಪ್ತಿ ಈ ಕೃಷಿ ಉತ್ಪನ್ನ TAPCMS ನಿಂದ ಒಬ್ಬ ನಿರ್ದೇಶಕರು ದೇ ರಿಮೇನ್. ಹಾಲು ಉತ್ಪಾದಕರ ಸಹಕಾರ ಸಂಘಗಳಿಂದ 2 ಜನ ದಟ್ ರಿಮೇನ್ಸ್. ಇವಾಗ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘ ಅವ್ರು ಡಿಲೀಟ್ ಮಾಡ್ರಿ ಅಂದಿದ್ದಾರೆ. ನಾವು ಪ್ರಪೋಸ್ ಮಾಡಿದ್ರೊಳಗೆ ಮಹಿಳಾ ಸಹಕಾರ ಸಂಘ ವಾಸ್ ರಿಟೈನ್ಡ್.
Yes.
All that it was done was, we had proposed a amendment deleting serial number 5 housing society exclusive directorship anna delete ಮಾಡಿ ಅದನ್ನ we had asked it to be merged with all other societies. And Apex Bank nominee, those 2 were to be deleted, providing 2 seats for new 2 talukas. ಇಲ್ಲಿ ಈಗ ಅವ್ರು ಹೇಳೋದು
5 and 6 were merged, ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ were deleted.
ಈಗ ಅವರು ಅವ್ರಿಗೆ ಹೇಳೋದು
ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಇಡಿ
4 and 5 ಡಿಲೀಟ್ ಮಾಡ್ರಿ, ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಇಟ್ಕೊಳ್ಳಿ, ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟ್ರಾರು ಇಟ್ಕೊಳ್ಳಿ, ಸರ್ಕಾರದ ನಾಮಿನಿನೂ ಇಟ್ಕೊಳ್ಳಿ.
ಅದೆಲ್ಲ ಹೋಗಲ್ಲ ಅದು. ದಟ್ ಇಸ್ ಬಿಕಾಸ್ ಸ್ಟ್ಯಾಟ್ಯೂಟ್. ಸೊ ಡಿಫರೆನ್ಸ್ ಇಸ್ ವೆದರ್ ಮಹಿಳಾ
ಅಲ್ಲ, ಆಕ್ಚುಲಿ ಜಾಯಿಂಟ್ ರಿಜಿಸ್ಟ್ರಾರು ಸ್ಟ್ಯಾಚ್ಯೂಟ್ ಅಲ್ಲ. ಇಫ್ ನೆಸೆಸರಿ ಯು ಮೇ ಹ್ಯಾವ್. ಯಾಕಂದ್ರೆ ಗೌರ್ಮೆಂಟ್ ನಾಮಿನಿಗೆ ಒಂದು ಸಪರೇಟ್ಲಿ ಇಟ್ಟಿದೆ 4B ಗಳಿಗೆ ಗೌರ್ಮೆಂಟ್ ನಾಮಿನಿಗೆ.
ನೌ ದ ಇಶ್ಯೂ ಇಸ್ ಬಿಟ್ವೀನ್ ಮಹಿಳಾ ಕೋಆಪರೇಟಿವ್ ಸೊಸೈಟಿ ಅಂಡ್
ಅದಕ್ಕೆ ಮೊದಲನೇದು, ಯುವರ್ ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ ಅವರ್ ಫಸ್ಟ್ ಕಂಟೆನ್ಷನ್ ಈಸ್ ಜನರಲ್ ಬಾಡಿ ಹ್ಯಾಸ್ ಟೇಕನ್ ಎ ವ್ಯೂ. It is not that we have done something contrary to the act to say, I will reject this bylaw. Maybe after election, the new body which comes into place may think otherwise and they may amend or do something. But ಇವರು ಅದನ್ನ ನೀವು ಅಪೆಕ್ಸ್ ಬ್ಯಾಂಕ್ ಇದ್ದು ಡಿಲೀಟ್ ಮಾಡಬಾರ್ದು. That was not something which ಇಂಥದ್ದೊಂದು ಕಾಯ್ದೆಗೆ ವಿರುದ್ಧವಾಗಿದೆ, ಅದಕ್ಕಾಗಿ ನಾನು ಡಿಲೀಟ್ ಮಾಡ್ತೇನೆ ಅಂತ ಹೇಳಿ ಅನ್ನೋ ಅಂತ ಅಲ್ಲಾಗಿತ್ತು. ಜನರಲ್ ಬಾಡಿ ಹ್ಯಾಸ್ ಬೀಯಿಂಗ್ ದಿ ಸುಪ್ರೀಂ ದಿಸ್ ಥಿಂಗ್. ನೌ ದಟ್ ಇಟ್ ಸೇಸ್ ಆರ್ಟಿಕಲ್ 19(1)(c) and 43(b) if read together, voluntary formation and autonomous democratic control. Therefore, general body decision should have been respected. ಒಂದನೇದು. ಎರಡನೇದು, ಯು ಲಾರ್ಡ್ಶಿಪ್ ಮೈ ಕೈಂಡ್ಲಿ ಸಿ ಸೆಕ್ಷನ್ 12(6).
Hmm.
12(2) capital A.
Yes.
If the registrar is unable to dispose of such application within the period specified in subsection 1, the amendment of the bylaw shall be deemed to have been registered. Now I will read one, my lord. A cooperative society may amend its bylaws in conformity with the provisions of this act and the rules made thereunder from time to time. Every cooperative society shall make amendments to bylaw in conformity with the amendments made to this act or the rules from time to time within 90 days from the date of coming into force of said amendment. 1A. Every proposal for such amendment shall be accompanied by such fee as may be prescribed, and fees may be prescribed for different class of societies. Class 1. Every proposal for such amendment shall be forwarded to the registrar And if the registrar is satisfied that the proposed amendment is not contrary to the provisions of this act and the rules, does not conflict with the cooperative principle, satisfies the requirement of sound business, will promote the economic interest of the members of the society, is not inconsistent with the principles of social justice, he shall within a period of 3 months from the date of receipt of the proposal register the amendment. ಈ 90 days ನಲ್ಲಿ ಅವ್ರು ರಿಜಿಸ್ಟರ್ ಮಾಡದೆ ಹೋದ್ರೆ
subsection 1 ಅನ್ನತ್ತೆ. It should have been subsection 2.
ಅಲ್ಲಲ್ಲ amendment forwarded under subsection 1, time limit is provided in Roman 5, 2 Roman 5.
Yes.
Application within the period.
So this 2A should have read subsection 2. Not subsection 1 ಅಲ್ಲ ಅದು. In typographic error ಇಲ್ಲ ಎಲ್ಲ ಬುಕ್ ಹಂಗೆ ಇದೆಯಾ? Specify the time period is specified only in Roman 5 of clause 2. Subsection 2.
So to section sub clause 1 also speaks of 90 days. My lords will
Provided
wait.
that every cooperative society shall make
Within 90 days.
in conformity with the amendments made to this act or the rules from time to time. That's different. If there's an act amended and that necessitates an amendment in the cooperative society's bylaws, that has to be done in 90 days is the mandate.
Please.
This is not a voluntary amendment. This is a compulsory statutory amendment that is under proviso.
Consideration is only under 2(5).
Under 2(5), 2 capital A ಅಲ್ಲಿ subsection 1 refer ಮಾಡುತ್ತೆ. It should have referred to specifically clause 5 of section 2, but at least subsection 2 refer ಮಾಡಬೇಕಾದ್ರೆ subsection 1 ಅಲ್ಲಿ there is nothing to do with it.
Seems to be an inserted provision in 98.
This is deeming fiction. Deeming fiction is only as regards subsection 1, which does not, the provision not dealing with voluntary amendment. Mistake ಆಗಿದೆಯಾ ಏನಿದು ಅಂತ? Doesn't make sense. Because once it is statutory thing, then there is a obligation on the society.
ಒನ್ನಿಗೆ ಸಂಬಂಧ ಬೀಳಾರ್ದು ಯಾಕಂದ್ರೆ if the registrar is unable to dispose of the application.
ಬರಕ್ಕಾಗಲ್ಲ ಅದು. Provision is mandatory. There's no question of disposing. It has to be accepted in terms of the, so ಇವಾಗ ಪ್ರಾಬ್ಲಮ್ ಆಗೋದು deeming fiction generate ಮಾಡಕ್ಕೆ. It is referring to subsection 1 for deeming fiction. That won't inure to your benefit. It can only be subsection 2. We can only say that this is redundant. It does not make sense. Mistake ಆಗಿದೆ ಅಂದ್ರೆ ಅದು ನೋಡಿ ಹೇಳಿ ಅದು.
ಗವರ್ಮೆಂಟ್ ಪಬ್ಲಿಕೇಶನ್ ಯಾವ್ದಾದ್ರು ನೋಡ್ಬೇಕು.
ಗೆಜೆಟ್ ಅಲ್ಲಿ ನೋಡಿ ಎಷ್ಟೋ ಸತಿ ಅದೇ
ನೋಡ್ಕೊಂಡು ಹೇಳ್ತೇನೆ. ನಮ್ ಕಂಟೆನ್ಷನ್ ಇಷ್ಟೇನೆ. 22ಗೆ ಅವ್ರು ರಿಜೆಕ್ಟ್ ಮಾಡ್ತಾರೆ, 90 days ನಂತರ ರಿಜೆಕ್ಟ್ ಮಾಡಿದ್ದಾರೆ, therefore there is deemed registration. ಒಂದನೇದು. ಎರಡನೇದು, even otherwise ಈ 12(5) ಡೈರೆಕ್ಷನ್ ಇಶ್ಯೂ
711 was your 611 711 you had forwarded.
711 it is submitted.
711/24.
ಹೌದು.
And it was rejected on
20th February.
22/25.
7/11/23 now.
3. 23. So 12. So by 7/11, 7/2/2023, it should have been rejected.
ಹೌದು.
Not having been rejected is deemed to have been in
One
terms of.
factual error, though the forwarded message says it is on 7/11. My lord, say, as per our records, we have received it only on 4/12. So we are well within the 90 days period.
That is why 7/11 is important date mark ಮಾಡಿ ಅಂತ
ಅಲ್ಲಲ್ಲ, ಅವರು 4/11
ಆರ್ಗ್ಯುಮೆಂಟ್ ಮಾಡಿಲ್ಲ ಇನ್ನ ಇವಾಗ ಬಂತು ಅದು ಆರ್ಗ್ಯುಮೆಂಟ್.
ಯಾಕೆ ನಾನು ಹೇಳ್ತೇನೆ, ಇದು ಈ 4/11 ಇನ್ ಸುದ್ದಿ ಏನ್ ಹೇಳ್ತಾರಲ್ಲ, ಅದು ಅವರು ಹೇಳೋದು ಸಮ ಅಲ್ಲ ಅಂತ ಅವರದ್ದೇ ರೆಕಾರ್ಡು Annexure D.
Where they refer to 7/11.
ಹೌದು.
He referred to the date of the forward.
receipt
when it was
ಯಾವತ್ತು ಅಂತ.
received. I can produce the records to show that when we received it. Original records are available.
ಬ್ಯಾಂಕಿನ ಪ್ರಸ್ತಾವನೆ ಸಂಖ್ಯೆ so and so, ದಿನಾಂಕ so and so.
We don't say the receipt date, we refer to the date of the.
You should start saying that.
That in view of this,
In
maybe
fact, we are
next.
not only in this, we are observing the, what we have told Ms. Naik is when any officer passes an order, he should put the time and date and time, not only just the date.
Yes.
And now that it's all digitally signed, time bande baratte. When it's physically signed, time unu baribeku.
That should be.
And whenever there are references like this, received anu alle bandbidbeku.
Both
So
in the
that-
same ullekha.
It should be clear.
Dated so and so, received so.
You should issue a necessary instruction. Otherwise, 7/11 is received on 7/11 idu. Unless you show otherwise.
I can place the records.
First. Second, it is not for the registrar
Hmm.
to substitute his wisdom
Hmm.
for a decision of the general body. Therefore, even otherwise, the order dated 22/24 rejecting the proposal is wrong.
That is what
It
your
should be
prayer
registered.
is for, to challenge.
Yes, it should be registered.
Hmm.
Once that is registered, there is no impediment for holding the election.
Hmm.
And for any elected body, they may take another view. They may call a general body and do that instead of the registrar issuing a direction under 12(5) that you do like this, you do like that.
You are not acceptable to that.
Ah,
You have already done what you wanted to do. They are given some
Yeah.
instruction which you are not acceptable.
ಈ ಟೈಮ್ನಲ್ಲಿ 12(6) ಕೆಳಗೆ ಕೊಟ್ಟು ಈ ರೀತಿ ಮಾಡ್ರಿ ಅಂತ ಹೇಳೆಲ್ಲ ಡೈರೆಕ್ಷನ್ ಕೊಡೋದು, ಅದಕ್ಕೆ ಇನ್ನೊಂದು ಜನರಲ್ ಬಾಡಿ ಕರೆಯೋದಕ್ಕೆ ಅಫ್ಕೋರ್ಸ್ ಅದಕ್ಕೊಂದು ಪ್ರೊಸೀಜರು ಅದನ್ನೆಲ್ಲ ಮಾಡೋದು, ಅದನ್ನ ಮಾಡ್ಬೋದು ಇಲೆಕ್ಷನ್ ಆದ್ಮೇಲೆ. ಇಲೆಕ್ಷನ್ ಆಗಲ್ಲಿವರೆಗೆ ಈ ರೀತಿಯದರದ್ದು ಅವಶ್ಯಕತೆ ಇರಲಿಲ್ಲ. 12(6) ಇಸ್ ಟೋಟಲಿ ಅನ್ನೆಸರಿ. 20th February the order, he could have rejected it only on the ground that it is contravention of the act, it is in conflict with any this thing. Antad ಏನು ಬರ್ದೇ ಹೋದ್ರೆ 12(2) ಕೆಳಗಿನ ಬರ್ದೇ ಹೋದ್ರೆ there is no question of rejection. Deemed ಅಲ್ಲ ಅಂತ ಇಟ್ಟುಕೊಂಡ್ರೆ that order of rejection should go, it should be registered. They can go ahead with the election.
There is no embargo. You are not coming in the way.
Yeah.
So don't blame it on us. Yes.
That would be the sum and substance of the argument.
Rajgopal. Anything in addition? ಇರತ್ತೆ, ಇದ್ದೇ ಇರ್ಬೇಕು, ಇದ್ದೇ ಇರ್ಬೇಕು ಹೇಳಿ. ನೀವು ಮುಗಿಸ್ಬಿಟ್ರೆ ಅವ್ರು ಮಂಡೇ ವಿಲ್ ಟೇಕ್ ಇಟ್, see the records. ಅರ್ಧ ಗಂಟೆ ಇವತ್ತು ರೆಡಿ ಇಲ್ಲ ಅವ್ರು. He doesn't want to argue.
ಅಲ್ಲಲ್ಲ, ಇವತ್ತು ಆ ಕಡೆ ನಿಂತ್ಕೊಂಡು he has lost a case. Therefore, in the lighter way.
ಬರೀ 1.5 hour ಅದು ಆಗೋಯ್ತು. Third Street. You produce the records on this one, but you will also have to make your submission on how you can insist for Apex Bank.
My lords, they have not dealt with my primary objections, I will point out.
Oh,
They don't even have the locus to argue whatever they have been arguing with.
ಅದನ್ನ
They have not answered.
Reply
this.
cover ಮಾಡಿ.
ರಿಪ್ಲೈ ನಲ್ಲಿ ಕವರ್
They have
ಮಾಡ್ತೇವೆ.
not answered.
ಅದಕ್ಕೆ
They
all
are
that
arguing as if-
all that I am doing is I am relying upon the judgment of the Supreme Court in the case of R.C. Cooper, where it is said a member, if affected, has the locus standi to challenge.
Who is the petitioner here?
My lords, on two grounds, my lords, they are arguing as if they are the DCC bank.
You are not the DCC.
They are not
bank.
DCC
I'm not
bank.
DCC bank.
They are no, and they are not even representing the society whom they are arguing for. A director is before my lords. My lords, a director of a society who is arguing for a federal society
In all the
bylaw.
petitions, who are
Please.
the petitioners?
I am a member of
My lords,
Member
two
society.
separate petitions, two directors of different societies are before my lords. They have to first substantiate before my lords their locus to question this.
I will-
Because these two petitioners have stalled the elections.
Now, if Supreme Court has said,
They argue for the
and
DCC.
Supreme Court has
we'll
said like
consider.
this,
Yes, Mr. Subrahmanya, what, you are also here in this?
My lords, yes, my lords. I am, my lords, an impleading applicant. My lords,
Impleading applicant.
yes,
Yaar
my lord.
impleading applicant.
My lords, that is a member society, my lords.
Innocent society.
And- No, no, my lords, I am supporting, my lords, the respondents.
ಹೌದು.
Petition is filed by the two societies.
ನೀವು ಯಾವ ಸೊಸೈಟಿಗೆ?
My lords, I represent, my lords, the,
So both the impleading application will allow. ಯಾರು?
my lords, that is Chikkalanerapu Agricultural Cooperative
Both of them.
Society. My lords, is the
You
fourth-
also come as intervener, they will also come as intervener. 75. IA 3 of 24 has been filed. Two of the societies,
Yes, please.
by two of the societies claiming to be members of the DCC Bank, primary society, federal society, to come on record, considering that they may also be affected by the orders passed by this court, though not as party respondents. They are brought on, they are permitted to assist this court
primary society.
as a intervener.
Member society.
IA 3 of 24 is accordingly disposed.
Please.
75.2. Basraju, ನೀವು ಯಾರು?
They are also director, my lord. Director for a
Another
society.
member. Same order, one.
Society, they are not the members of DCC Bank. The society is the member and they can't represent the society.
Who is the impleading applicant?
They are the petitioners.
ಇಲ್ಲ 75.2 ಅಲ್ಲಿ HN ಬಸವರಾಜು ಎಸ್ ಯಾವ society? That is Women's Cooperative Society. That is in the second matter.
second,
Two petitions are filed by the members. This petition is filed by the two societies seeking for their representation.
The DCC Bank is not before us.
DCC Bank is a respondent.
DCC Bank is now under administrator.
Even otherwise.
They will not,
Administrator.
no, they will.
ಅದೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
not come.
ಅದೇ ಹೇಳ್ಬೇಕಾಗಿತ್ತು.
They will not come at all.
That is.
Otherwise, administrator will be carried very less.
ನೀವು ಅದು ಹೇಳಿಲ್ಲ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್ ಅಂತ ಇವಾಗ ಹೇಳ್ತಾ ಇದ್ದೀರಾ ಅಡ್ಮಿನಿಸ್ಟ್ರೇಟರ್. That should have come first. statement. 75.2, accepting the reasons stated in support of IA 1 of 2024, the impleading applicant is permitted to come on record as an intervener to assist this court. IA 1 of 24 stands disposed.
Administrator is appointed on 19/11/2023
After the resolution.
after the resolution.
Relist on 10th at 2:30 PM at 4 PM.
Please.
Grateful.
Learned AGA is directed to secure the records relating to the date, relating to the submission of the amendment by the DCC Bank
Please,
for approval of the amendment.
please.
Then I can tell you a poster.
ಅದು ಸೋಮವಾರ.
ಅವ್ರು ಒಬ್ಬರೇ ಇಲ್ಲ ಈ ಸಲ, ನಾನಿದ್ದೇನೆ. ನನಗೆ ಆ 4:30 ಎಂಬಾರ್ಗೋ ಇಲ್ಲ.
ಆಫ್ಸೆಟ್ ಆಗೋಯ್ತು. ಬಸವರಾಜ್ ಕೇಳ್ಬೇಕು ಏನು ಅಂತ. ಯಾಕೆಂದ್ರೆ ಅವ್ರಿಗೆ 2 ಪೆಟಿಷನ್, ನಿಮ್ದು ಒಂದೇ ಪೆಟಿಷನ್. ಏನ್ ಪಾಸ್?
Serial number 8.
DM ಕೃಷ್ಣ ಬಂದಿದ್ರು. ಯಾವಾಗ ಬಂದಿದ್ರು?
ಇದ್ರು ಸ್ವಾಮಿ.
ಅವ್ರು ಬಂದಾಗ ನಾವು ತಗೊಳಲ್ಲ ಮ್ಯಾಟ್ರ್, ಅದೇ ಪ್ರಾಬ್ಲಮ್. ಅವ್ರದಲ್ಲ ನಮ್ದು. 8 relist on
Tuesday.
Monday at 4 PM. Please.
Hearing will be called.
72 ಅಲ್ಲ. interim order extent. Yes.
Serial number 81.
Serial number 102, my lord.
I'm the number 6, my lord.
The urgency in the matter, Your Honor.
Connected matter.
ಏನಪ್ಪ 102?
I am the respondent
ಇಬ್ರು
number.
ಹೇಳ್ಬೇಡಿ, ಅವ್ರು ಹೇಳೋವರೆಗೂ
I am the respondent number 6.
ಹಾ, ಏನ್ ಹೇಳಿ?
Connected ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಆಗಿದೆ. 102 ಅಲ್ಲಿ ಅರ್ಜೆನ್ಸಿ ಇದೆ.
ಎಲೆಕ್ಷನ್ ಮ್ಯಾಟರ್ ಮೆಲಾಡ್.
ಏನ್ ಇದು ಇಶ್ಯೂ ಏನು?
ಅಲ್ಲ ಮಂಡೇಗೆ ಡೇಟ್ ಕೊಟ್ಟಿದ್ರೆ ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ಮೆಂಟ್ ಈಗ.
ರಿಸಲ್ಟ್ ಅನೌನ್ಸ್ ಮೆಲಾಡ್ ರಿಗಾರ್ಡಿಂಗ್ ಮೆಲಾಡ್ ಎಲೆಕ್ಷನ್ ಇಸ್
ಇದ್ರಲ್ಲಿ ಇಶ್ಯೂ ಏನು?
13
20 ಡೇಟ್ ಕೊಟ್ಟಿದೆ.
ನೋಟ್ ರಿಜಿಸ್ಟರ್ ಪೋಸ್ಟ್ ಏನು?
Lord, regarding say that, my lord, two is concerned, my lord, not stated any, society has not stated any.
102 on Monday at
Please.
4 PM.
Serial number 81.
Hmm.
Had to become infectious.
Infructuous. 81. Memo has been filed, dismissed as infructuous.